Tomorrow could. Yes. Nimdan mother. Release of vehicle. ಆ ಕೋರ್ಟಲ್ಲಿ ಕೊಡ್ಲಿಲ್ವಾ? ಸರಿ, ಫ್ರೈಡೆ ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್ ಸರ್. Monday. What were you doing till now, sir? No. What were you doing till now? ಏನ್ 311 91 ಏನು? I rejected ಈಗಲೇ. Yes. Judgment time ಅಲ್ಲಿ 311. What do you mean? Yes. Next. Monday. Wait, she is there. Why? So why 2:30, madam? Who has come? What do you want? Settlement, is it? Then? FIR Monday, yes. Because they have come from Gwalior, I can't adjust my time. Yes. Monday, fresh matters, all Monday kodi. Don't project pseudo urgency, real urgency idre matra heli. Yes. Petitioners are daughters. Okay. Fresh up pending. Fresh up pending. Yenu. It's okay. Monday. ಇದಕ್ಕೆಲ್ಲ ಯಾಕೆ ಮೆನ್ಷನ್ ಮಾಡಕ್ ಆಯ್ತಾ ಇದೆ? ನಾನು ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ. ಮಂಡೇಗೆ ಬರಲಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? ಮಂಡೇ. ನೋ ಮಂಡೇ ಸರ್. ITP. ಆಯ್ತು, ಅದ್ರಲ್ಲಿ ಅರೆಸ್ಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಫ್ರೈಡೆ ಕೊಡಿ. ಎಸ್. That will come on 2nd July. Calcutta. Yes. Adik, you're mentioning that only, right? It will pronounce on 2nd July. Yes. On Friday or Saturday, all parted matters will be listed. Yes.
That was listed on Thursday. Yesterday, not listed. Today also not.
ಯಾವುದು ಏನದು?
Tomorrow.
Tomorrow ಕೊಡಿ. ಎಸ್, ನಿಮ್ದೇನು ಸರ್? ಕೊಡಿ tomorrow. ಆಯ್ತು. ಏನಾಯ್ತು? ಅದು ಬಂದಿಲ್ವಾ? 2:30ಗೆ ತಗೊಳ್ಳಿ. ಎಸ್, ಅದು 2:30ಗೆ ತಗೊಳ್ಳಿ. Wait, don't join, come this side. ಏನು? Tomorrow, yes. Give the memo, sir. It will come according to its day and seniority. Yes, Pawan. ಯಾವ ವರ್ಷದ್ದು? ಪೆನ್ ಡ್ರೈವ್ ಮ್ಯಾಟ್ರ? ನಾಳೆಗೆ ಹಾಕಿ. ಬೇಲ್ ತಗೊಂಡ್ರ ಇಲ್ವಾ? ಮೂಡ ಕೊಟ್ಟಿದಾರ ಇಲ್ವಾ? ವೆನ್? ಅದೇ ನಾವಾಗ್ಲೇ ತಗೊಂತೀನಿ ಇದನ್ನ. ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್. ಆಯ್ತು, ಫ್ರೈಡೆ ಕೊಡಿ. ಯಾಕೆ ನೀವಿರಲ್ವಾ ಫ್ರೈಡೆ? ಕೊಡಿ. ಪ್ರಿಮೇಚರ್ Saturday ಕೊಡಿ. Saturday, sir. Saturday, sir. Yes.
These matters were reserved for dictation on Friday 4 p.m.
ಯಾವ್ದು?
Defamation matters, my lord, the senior counsel matter.
That's Supreme Court.
Yes.
Ah.
Friday is a late in the lower court and no interim order is there.
So I have set it for dictation. You want me to prepone dictation?
My lord, the date was given for Friday, my lord.
Date is it will be listed on Friday, sir.
14th was this.
14th ಕೊಟ್ಟಿದ್ದ?
14th.
ಯಾವ್ದು ಮೇಡಮ್? 14th ಕೊಟ್ಟಿದ್ದು. 14th ಕೊಟ್ಟಿದ್ರೆ ನಾಳೆ ಅಲ್ಲ, ನಾಡಿದ್ದು ಹಾಕಿ. 21st ಹಾಕಿ.
21st
My lord,
listed in the.
So what, sir? Big deal. Yes.
Lord, essential commodities matter, my lord. Food grains vehicle both are not released for them. Then, my lord, your lordship gave the date.
Yes, sir.
Your thing pending matter, your lordship gave the date today, still it not listed. Friday can I expect?
How many matters can I also take, sir? What do you mean?
My lord,
Yes.
my submission is today's date was given, my lord. I'm
ಏನ್
sorry. my
ಮಾಡಕ್ಕಾಗಲ್ಲ.
lord.
We'll see.
Friday can I expect?
It will come according to the date ಪ್ರಕಾರ ಬರುತ್ತೆ. Interim order ಇಲ್ವಾ?
Interim order ಇದೆ, but vehicles
Yeah.
those 40 bags my lord are lying on the road, my lord. Vehicle is losing it. Can I, Friday can I expect?
Next week.
Or any date, can you any date
It
can
will
you?
come, sir.
Any date, next week,
Next
any
week
date
will
can I?
come, yes.
27, 28.
Next week it will come, yes.
28th or 27th or
Bharat,
28th.
nenne-
Otherwise it will not be listed. Today date was given.
That's all.
File ಅಲ್ಲಿ ಕಳಿಸಿದ್ರು ವಾಪಸ್ ಕಳಿಸಿದ on the ground well it's not a submission memo.
100 ಮೇಲೆ ಆಗಲ್ಲ sir, daily I can't take what I took yesterday.
27, 28
Humanly impossible.
I will be glad for you.
No, sir, no, not at all.
My lord,
It will come, sir. Interim order ಇರೋದ್ ಕೇಸಲ್ಲಿ ಅವ್ರು move ಮಾಡ್ಲೇಬೇಡಿ. Yes.
my lord, this matter, my lord, dispose
Please,
matter,
Sandhya Prabhu here.
my lord, dispose matter, my lord, that I had filed an application for direction, my lord, ಇಲ್ಲೇ hear ಮಾಡ್ಬೇಕಂತ ಮಾಡಿದ್ದಾರೆ. It's a matter, my lord, where property is sold.
ಆಯ್ತು.
Sale proceeds ಜೊತೆ interest ಒಂದು ಹಾಕಿರ್ಲಿಲ್ಲ ಅಂತ.
ಆಯ್ತು, ಸರಿ ಕೊಡಿ.
My lord's fresh
ಈಗಲೇ
matter, my
argue
lords.
ಮಾಡ್ಬಿಡ್ಬೇಡಿ ಎಲ್ಲ.
My lord's
Friday
fresh-
ಹಾಕಿ.
My lord's quashment for criminal petition, my lords. NBW has been issued against the petitioner, my lords. Maybe it heard
But
on.
the husband,
No, my lords, it's for false criminal case being filed.
what were you doing till MBW was issued?
My lords, we had actually taken a bail as well, my lords. Even after that, NBW has been issued,
Bail
my
ತಗೊಂಡ
lords.
ತಕ್ಷಣ you should not appear before the court ಅಂತ ಯಾರು ಹೇಳಿದ್ದು?
My lords, they have issued, hearing
When
is,
is the
hearing
next
is this week, my lords.
No
On
problem.
Friday, my lords, kindly, my lords.
Saturday,
It's a matter of two thousand
Saturday.
sixteen, my lords.
Saturday, yes.
My lord, the allegation is 498A read with
Yeah,
306
why are
of
you all
the.
making a mention? Pending matters, please give. Are you going to
no.
get arrested in the afternoon?
No, my lord.
Then give all the
This
memos.
is a fresh matter, my lord.
Fresh matters on Monday. Give all the memos. Please give all the memos. Unless there is extreme emergency, don't project anything.
Malots,
Give.
Malots,
Wait.
Malots. In this matter, Malots, the petitioners are senior citizens, Malots.
So what, sir?
Malots, they have been put out of their own house by
Really?
their son and daughter, Malots.
Why? What
Now
is
they
the
have
matter?
filed a counter complaint against the senior citizens, Malots.
No problem.
Malots, police,
One minute, bail ilva.
illa Malots.
Bail ತಗೊಳ್ಳಿ.
Malots, FIR, Malots.
Take bail and come.
Malots,
Take bail and come, sir. Yes.
The matter thrice, my lord. The jurisdiction.
Monday, yes.
My lord, kindly tomorrow.
Monday. Settled, Friday ಹಾಕಿ.
Fresh matter, my lord.
Malots, it's a fresh matter, Malots.
Monday ಕೊಡಿ, sir.
Malots.
Monday ಕೊಡಿ. Yes.
Lord, this is a writ petition, your lord.
Give it. You don't want on Monday?
Malots, they are living in PGs and all, Malots, the senior.
You don't want on Monday? ಈಗ ಕ್ರೈಮ್ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ವಾಪಸ್ ತಗೊಂತಾರ ಮನೆಗೆ?
Oh, please, Malots.
What are you talking? Give it on Monday. Yes.
Lord, this is a writ petition matter.
Give it, give it. Yes.
But the writ petition, the lordship have heard this matter, Tamil Sangam matter. Election has been stayed last 1 year.
ಯಾವ್ದದು?
Dictating Tamil Sangam matter. ತಾವು ಡಿಕ್ಟೇಟಿಂಗ್ ಆರ್ಡರ್ ಅಂತ ಹಾಕಿದ್ರಿ ಆಮೇಲೆ
Release ಮಾಡ್ಬಿಡೋಣ ಕೊಡಿ.
ಒಂದ್ ವರ್ಷ ಆಗುತ್ತೆ.
We'll
election
release it.
ಆಗಿಲ್ಲ,
Yes,
stay
give it,
ಆಗಿದೆ.
give it. Yes. Saturday ಹಾಕಿ.
Lord's fresh matter, my lord. Police are possibly taking a check and are harassing the petitioners every day.
Monday, yes.
Parties are compromising the.
Compromised ಅಂತ ಹೇಳಿ.
Compromised.
Yes.
File the compromise petition also.
ಯಾವತ್ತು?
Friday.
Friday, yes.
My lord, I'm moving a memo for a pending matter. There is no urgency, my lord, but a
Then why
date
are
may
you
be,
moving memo?
my lord, a date may be allotted, my lord. My divorce petition is allowed and DV
It
is
will come,
pending.
which year?
23.
2 weeks ಬಿಟ್ಟು ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. Yes.
Oblige me.
My lord's compromising.
ಏನು 376 ಅಲ್ಲ ತಾನೆ?
376.
ನೀವು ಬರಲೇಬೇಡಿ 376.
ಸ್ವಾಮಿ ಅದರಲ್ಲಿ
You are the one who made me write that wrong order 2 years back.
No, my lords, here
I
the
regret today.
my lords, here the complainant is doctor.
And
My
I'm
lords,
telling
ಮದ್ವೆ
the state,
ಆಗಿದೀವಿ.
move it for recalling, they are not moving it.
ಅಲ್ಲ ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ ಮದ್ವೆ ಆಗಿದೀವಿ. 17 ವರ್ಷ 5 ತಿಂಗಳಾಗಿದೆ. ನಾ ಪ್ರೆಗ್ನೆನ್ಸಿ ಟೈಮ್ ಅಲ್ಲಿ ಹಾಸ್ಪಿಟಲ್
ಗೊತ್ತು ಎಲ್ಲದರಲ್ಲೂ ಅದೇ ಆಗೋದು ಕೊಡಿ. Yes, Friday.
My lord, sir, the matter-
My lord, it was last 2 occasions.
Fresh matter,
Fresh matter.
Monday.
Lords, the matter is pertaining to KPI.
Huh?
The matter is pertaining to KPID Act, my lords.
Huh.
I'm seeking a date to be given, my lords, because it's pending since.
Pending
20
matter.
Pending matter.
Which year, sir?
23, sir.
2 weeks ಬಿಟ್ಟು ಒಂದು ಡೇಟ್ ಕೊಡಿ.
One date, please.
Today, on the 13th, according to the daily order, but it's not listed in the copy.
According to the daily order, we don't work, madam. According to my orders, that's all. We'll see. When is that? What is that memo? ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಾಗಿತ್ತ ಮೇಡಮ್? It will come tomorrow or day after it will come. Yes. Failed trap ಎಲ್ಲ 7th 11th ಯಾವತ್ತೋ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ ನಾವು ಟ್ರ್ಯಾಪ್ ಎಲ್ಲ 11th July. All trap matters.
22nd, my lord, other matters are listed.
No problem, sir. 11th all trap, those also will be adjourned to 11th. That will be a trap day. Yes.
Please, the lordship will give it.
All 7 AM matters ಅವತ್ತೆ. 11th ತಗೊಳ್ಳಿ ಮೇಡಮ್. 2 weeks ಬಿಟ್ಟು ಒಂದು ಕೊಡಿ. Yes. All the cases.
96th matter, my lords. Matter has been settled.
Withdrawal.
Yes.
ತಗೊಂಡಿರಿ. You are for the respondent.
Respondent number 2.
Settled ಅಂದ್ರೆ ಏನು ಈಗ? You want withdrawal of the petition or recording of compromise?
Recording of
Then
compromise.
230, yes.
Serial number 50, my lord. We'll seek for adjournment.
Adjournment, direct and indirect, no. Only when the matter is called, yes.
Being spoken to number 1.
Why is it being spoken to? Additional SPP ಅವರ ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು. ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಈಗ. Recalled. The matter was disposed, reserving liberty to the petitioner to call in question the charge sheet filed during the pendency of the petition according to the learned additional SPP. The charge sheet had already been filed and that was what is called in question. Therefore, the order stands recalled post the matter for admission. Interim order ಇದೆಯಾ? ಇಲ್ಲಲ್ಲ? Post the matter for admission next Wednesday ಕೊಡಿ. Withdraw ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Adjournment ಆದ್ರೆ ಇಲ್ಲ, yes. ಅದಾದ್ಮೇಲೆ you want to go somewhere, go ಹೇಳೋಗಿರಿ ಅಷ್ಟೇ. ಬೆಳಗ್ಗೆ 10:30 don't make mention for adjournment at all. Yes. Second matter, same order.
Council submission is my lord. There is one council submission,
Accepting the submission of the land council with the petition, office objections overruled. Next witness, yes.
Fresh matters number 3.
ನೋಡಿದ್ರಾ ಇದು?
Yes. 239 ಮೇಲೆ ಬಂದಿದೆ.
ಅಲ್ಲ ಆಯ್ತು 239 ಮೇಲೆ 2092 ಇಂದ 2007 ವರೆಗೂ crimes registered in 2014.
Civil suit is also filed and dismissed.
Is all.
The entire thing has been considered by the trial court.
ಏನಾಯ್ತು ಸೂಟ್?
Suit did a decree in our favor. Come to the conclusion.
The
we are in
petitioners
Your
are,
lordship may, two issues, my lord. Your lordship may see the page 245, my lord, the,
discharge order.
how the discharge order,
ಸರಿ.
245, my lord.
discharge
That this
application.
is the
Charge
coord-
frame
This
ಆಗಿದೆಯಾ?
is the coordinate.
ಇಲ್ಲ,
bench
charge
order.
frame ಆಗಿಲ್ಲ.
ಒಂದು ನಿಮಿಷ. Coordinate benches.
Coordinate bench.
House.
240?
245, my lord, internal page 11. 245. Internal page 11, my lord.
ಇದು 482 ನಾ?
ಹೌದು 480.
Earlier filed the 482.
Where the charge sheet was challenged.
482.
Coordinate bench.
The honorable court says that you file an application for discharge. That has been filed.
Discharge reject ಆಗಿದೆ.
Otherwise I come up for this honorable.
Coordinate bench.
Factual aspects, their contention so and so are not exactly one and the same.
Well, only it says the only trial court after parties are put to test the cross examination, establish the same.
So what I am submitting before the honorable court. So far, accused number 2 is concerned, there is no materials at all. One aspect. The second aspect you are asking. The,
Coordinate bench.
what I am saying, ಸಾಹೇಬ್ರೆ,
Findings ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, I agree to what I submitted your answer. ಅದು ಹೇಳ್ತೀನಿ. ಅವಾಗ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇತ್ತು, ಸೂಟ್ ಡಿಸ್ಪೋಸ್ ಆಗಿರ್ಲಿ. Suit was pending.
The suit also now they filed an appeal pending before this court.
Yes, your lordship, see that I filed the judgment and decree of the original suit also, it is in page number 245 here. 248 here.
But look at the
I understand.
92 ಇಂದ 2007 ವರೆಗೆ ಸುಮ್ಮನೆ 2014 ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು
Like,
ಸಿವಿಲ್ ಸೂಟ್ ಇದ್ದಾಗ
he is now clearly impersonated that person. They produced the document to show that he is inserted the
the
name.
trial court has held it otherwise.
Like said, trial court has accepted that finding, my lord. That's the
Which
reason.
one? Impersonation by him.
Yes, yes, ma'am.
ಎಲ್ಲಿದೆ? Where is
Your
it?
lordship.
Where is it?
Sir, the charge sheet
Issues,
material
your
of-
lordship, 263.
Charge sheet ಬೇಡ.
Your lordship, issues number 263, your lordship.
Page.
Number 263.
That
your lordship.
OS, my lord, is now
63
challenged
or-
before this court.
That's okay, sir.
263
There's a prima facie finding that there is no impersonation.
Injunction,
Will
Your
injunction
lordship,
suit.
injunction.
Your lordship, issue number, whether the plaintiff proves that he has been lawfully carrying on the business of retail sales of Indian made foreign liquor and obtained license from the competent authority. After
Issue
making-
number 4 ಏನ್ ಮಾಡಿದ್ದಾರೆ?
Next, your lordship.
Issue number 4.
Negative. Defendant number 1 and further proves that the plaintiff has impersonated. That has been negative. The para number 27 in the Suragatha.
There's a prima facie finding.
Issues framed in that regard.
Coordinate bench has said that all these things is a matter of trial.
Answer, stay ಮಾಡೋದು ಬೇಡ, will answer it. Yes. The heard the learned Counsel H.P. Leeladhar appearing for the petitioner. The learned counsel for the petitioner submits that the license that was allegedly forged in the year 1992 and was in operation till 2007 is complained of in 2014. And the complaint has led to registration of the crime and the police filing a charge sheet after investigation. The learned counsel would submit on the same issue. A civil suit was filed by the very complainant in OS 7914 of 2000.
Very complainant, petitioner here.
By the petitioner against the complainant, who was the defendant therein. The suit is decreed in favor of the petitioner. The specific issue with regard to impersonation is also held in the negative in favor of the petitioner. He would therefore contend that the very substratum of the crime is effaced by the order of the civil court. The learned additional SPP would, however, submit that in an earlier occasion when the petitioner was before this court, before this court, a coordinate bench had observed that it prima facie amounted to forgery and had permitted the petitioner to avail the remedy of discharge. The discharge having been rejected, the petitioner is before this court. The learned additional SPP would further submit that the order in OS so and so has been tossed before this court and is pending consideration. With all these factors, when is the next date? End stage ಅಲ್ಲಿ ಇದೆ ಅಲ್ಲಿ?
Framing charges,
ಯಾವತ್ತಿದೆ next date?
19th.
With all these factors, till the appearance of the complainant, the concerned court shall defer framing of charges. 1 additional SPP, 2 emergent notice returnable by 11th.
March.
Number 4.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡೋ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಅಂತ ಅನ್ಬಾರ್ದ ಮೇಡಮ್? This is why sometimes I pass order. Civil court, if it is proved that yes, it is forgery, this will revive one. This is what I'm going to do in this also. Yes. Will state part payment. Yes. The petitioner is before this court calling in question proceedings in so and so registered for offences punishable under section 138 of the Negotiable Instruments Act. The learned counsel for the petitioner submits that the check has been partly honored and against part payment, the proceedings under section 138 would not be entertainable. He would entertainable. The submission stands to reason as the apex court in its judgment rendered on reported in 2023 1 SCC page 578 in 578 has so held that once part payment is made of a check, the offense under section 138 would not be entertainable. In that light, there shall be an interim order of stay of further proceedings before the concerned court. Emergent notice to the respondent returnable by the 16th of July. Yes.
5.
This case, last occasion, no.
Just filed my power yesterday. 2 weeks time, my lords, I will place some 3 judgments of the apex court. There is, my lords, a goading here. They have, in first instance, my lord, they have gone and destroyed his house.
Who destroyed what
Really,
house?
they have charge sheet has been filed.
Charge sheet has been filed.
Last occasion, own certificate produce ಮಾಡಕ್ಕೆ
Charge sheet file ಮಾಡಿದ್ರೆ ಚಾಲೆಂಜ್ ಮಾಡಿ.
ಅಲ್ಲ ಲಾಸ್ಟ್ occasion charge sheet ಫೈಲ್ ಮಾಡಿಲ್ಲ ಮತ್ತೆ ಕೋರ್ಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಮಾಡಿದ್ದು ನಾನು ನೆಕ್ಸ್ಟ್
ಮಾಡಿದಾರೆ ಮೈಕ್ ಇಟ್ಕೊಳ್ಳಿ. ಯಾಕೆ?
ಲಾಸ್ಟ್ occasion ಮೇಲೆ ಅಷ್ಟೇ ಡಿಸೆಂಬರ್
ಈ ಕಡೆ ಹೇಳ್ಕೊಳ್ಳಿ.
ಫೈಲ್ ಮಾಡಿರ್ಲಿಲ್ಲ ಲಾಸ್ಟ್ occasion ಅಲ್ಲಿ. ಕೋರ್ಟ್ ಮಾಡಬೇಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಇತ್ತು, ಓರಲ್ ಡೈರೆಕ್ಷನ್ ಮೇಲೆ ಅಷ್ಟೇ.
ಹೌದಾ? ಯಾರು ಹೇಳಿದ್ರು?
ಓರಲ್ ಡೈರೆಕ್ಷನ್ ಇದೆ, ಯಾಕೆ ಕೋರ್ಟ್ ಡಿಸೆಂಬರ್ ಕೋರ್ಟ್ ಮೇಲೆ ಅಷ್ಟೇ.
I told.
Yes, and also PM report, postmortem report already produced before this court martial.
We submitted an 18 file.
Charge sheet. Submitted on 18th.
18.
The matter has come on 10th.
There is no direction.
Then otherwise, may I submit?
Urgency ಯಾಕೆ ಅವ್ರು ಹೇಳಿದ್ರು ಒಂದು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ?
18 ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ charge.
May I submit?
ಅವಾಗ 18/5
May I submit, my lord, the Supreme Court decision, please, my lord, would be that even if they, during the course, my lord, charge sheet is filed, it could still.
No, I am not on that. I am aware of that.
Please.
Filing of charge sheet will not take away 482.
Please.
Yes, don't worry.
Death note also ಇದೆ.
Death note.
Death note, ಅದೇ ಕೇಳಿ. Where is the death note? That's what I am asking.
Madam. That handwriting has also been proved, man.
Improved,
Handwriting has been proved with FSL.
proved,
Yes.
FSL ಆಗಿದೆ.
FSL.
ಏನು ಲೋನ್ ತಗೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ,
ಹಾ.
ಲೋನ್ ಇಲ್ಲ, ಮನೆ ಕೊಂಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ
ಹಾ.
ಇವ್ರು ಸಿಟ್ಟು ಊರಲ್ಲಿ. They have
ಮನೆ
gone
ಯಾರು
and-
ಕೊಂಡ್ಕೊಂಡಿದ್ರು?
the deceased.
ಹಾ.
He had purchased it in the name of his wife. He is a painter. He has got 2 children.
ಹಾ.
Now these persons have gone, please, my lords, and threatened, intimidate him. They're not only that, they've destroyed his house also, for which an earlier FIR is registered.
ಹಾ.
Thereafter, my lords, continuously they go and harass him, please, my lords, in the village. He
They are
got,
these people.
yes, please.
That evidence ಇದೆಯಾ?
Yeah, the complaint, the wife has written all
ಅಲ್ಲ,
this. Ingredients, please, my lords, are made out.
Kindly shall I permit to read the complaint, complaint itself, kindly, Mash.
ಓದ್ಲಿ ಸರ್.
Subject, ನನ್ನ ಗಂಡ.
ನೀವು ಸಬ್ಜೆಕ್ಟ್ ಇಂದ ಓದ್ಬೇಡಿ, ಹೇಳಿ
Yes,
ಸರ್.
yes. ಅಲ್ಲಿ next ಪ್ಯಾರಾದಲ್ಲಿ Mash, kindly see the page number 24, Mash.
ಎಸ್ ಸರ್.
ಯಾವ ಕೋರ್ಟಿಗೆ ಹೋಗುತ್ತಿರೋ ಎಂದು ಬೆದರಿಕೆ ಹಾಕುತ್ತಿದ್ದರು. ನಾವುಗಳು ಊರಿಗೆ ಹೋಗುವುದೇ ನಿಲ್ಲಿಸಿದ್ದೆವು. ಸದರಿಯವರುಗಳು ರೌಡಿಗಳ ರೀತಿಯಲ್ಲಿ ವರ್ತಿಸುತ್ತಿದ್ದರು. ನಂತರ ದಿನಾಂಕ 30/1/2024 ನನ್ನ ಗಂಡ ಹಬ್ಬಕ್ಕೆಂದು ನಂತರ ನಾನು ಕೆಲಸಕ್ಕೆಂದು ಮನೆಯಿಂದ ಹೊರಗೆ ಹೋಗಿರುತ್ತೇನೆ ಹಾಗೂ ನನ್ನ ಮಕ್ಕಳು ಶಾಲೆಗೆ ಹೋಗಿರುತ್ತಾರೆ. ಈ ಸಂದರ್ಭದಲ್ಲಿ ನನ್ನ ಗಂಡ ಬೆಂಗಳೂರಿನ ನಮ್ಮ ಮನೆಗೆ ದಿನಾಂಕ 31/1/2024 ಬೆಳಗ್ಗೆ 7 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಮನೆಗೆ ಬಂದು ಸಪ್ಪಾಗಿರುತ್ತಾರೆ. ನಾನು ವಿಚಾರಿಸಿದಾಗ ಈ ರೀತಿ ನನಗೆ ಊರಿನವರ ಕಿರುಕುಳ ಹೆಚ್ಚಾಗಿದೆ. ನನ್ನ ಊರಿಗೆ ಹೋದಾಗ ಮೇಲೆ ತಿಳಿಸಿರುವಂತವರುಗಳು ಹೆಸರು ಹೇಳಿ ಅವರುಗಳು ಈ ನನ್ನ ಮಗ ಇನ್ನು ಜೀವಂತವಾಗಿದ್ದಾರೆ, ಇನ್ನು ಸತ್ತಿಲ್ಲ, ಈ ನನ್ನ ಮಗನನ್ನು ನಾವೇ ಸಾಯಿಸಬೇಕು ಎಂದು ಮಾತನಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದರು ಮತ್ತು ನನಗೆ ತುಂಬಾ ಹಿಂಸೆಯಾಗಿದೆ ಎಂದು ಹೇಳಿದರು.
The time gap between these statements and the death?
He has come back from the village since then immediate next day itself he is committed.
One day, Malash. And this incident is occurred in Magadi. He is staying in Bangalore, Malash.
Sure.
ಅಲ್ಲ, ಬಟ್ ಬೈದುಕೊಳ್ತಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. ನೇರವಾಗಿ ಬೈದ್ರು, ನೇರವಾಗಿ ನನಗೆ ಹಿಂಸೆ ಕೊಟ್ರು ಅಂತ ಅವ್ನ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅವ್ರ ತಾಯಿ ಹೇಳಿಲ್ಲ, ಅವನ ಹೆಂಡತಿ ಕೂಡ ಹೇಳಿಲ್ಲ ಅದನ್ನ. ಅದು ಮಾರ್ನಿಂಗ್ 7 ಗಂಟೆ ಆಯ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. ಇವ್ರು ಇರ್ತಕ್ಕಂಥದ್ದು ಬೆಂಗಳೂರಲ್ಲಿ ಇಂಡಸ್ಟ್ರಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಪಿಟಿಷನರ್ಸ್ 1 and 2 is this stay in ಬೆಂಗಳೂರು. ಸೊ ಔಟ್ ಇಸ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ ಅದು. ಆಕ್ಚುಲಿ ಅವ್ರು ಅಲ್ಲಿ ಹೋಗಿರ್ತಾ, ಆಮೇಲೆ ಹಬ್ಬ ಇತ್ತು ಅಂತ, ಆ ದಿನ ಯಾವುದೇ ಹಬ್ಬ ಇಲ್ಲ ಇಲ್ಲಿ, ಹಬ್ಬಕ್ಕೋಸ್ಕರ ಹೋಗಿದ್ರು ಅಂತ. It's a false complaint. 306 specifically stated that must immediately affect.
ಗೊತ್ತು ಸರ್, ಇಮಿಡಿಯೇಟ್ಲಿ ಎಫೆಕ್ಟ್ ಗೊತ್ತು.
The apex court, my lords, in one judgment, my lords, it has said, courts must be scrupulously.
ಹೌದು,
courts
ಸ್ಕ್ರೂಪುಲಸ್,
must
ಅದ್ರಲ್ಲೇನು ಡೌಟ್ ಇಲ್ಲ.
examine the facts and circumstances of the case and also assess the evidence adduced before it in order to find out whether the cruelty and harassment meted out to the victim had left the victim with no other alternative but to put an end to his own life.
ಯಾವ ವರ್ಷದ್ದು ಅದು?
2009, lords.
ತುಂಬಾ ಹಳೇದಾಯ್ತು.
There's one
Much
another
water has flown in 3
Daksa Ben versus.
much water has flown in
Last year,
306, sir.
last year's 3 judgments.
ಲಾಸ್ಟ್ ಇಯರ್ ಅದು ಆಯ್ತು, ತುಂಬಾ ಹಳೇದಾಯ್ತು.
2023 ಒಂದಿದೆ.
ಟಾಕ್ ಆಫ್ ಲಾಸ್ಟ್ ವೀಕ್.
Last week, much.
You should be last week, sir. Last
Sorry,
year
please,
ಎಲ್ಲ
much. I
ಹಳೇದಾಯ್ತು.
will get that judgment. That's what happens is in Daksa Ben versus State of Gujarat.
ದಕ್ಷ ಬೇನು ಹಳೇದಾಯ್ತು ಸರ್.
Please, Lord, but that one paragraph, Lord's grave and heinous crimes that are not private law in nature and have significant effect on society.
ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಬಾರ್ದು ಅಂತಿರೋದು.
It's quite-
ಏನೇನೋ ದಕ್ಷ ಬೇನೇನು. ಎಸ್. You have not got the judgment that you should have got.
I get it, Lords. I've got about 7 judgments, Lords.
ಎಲ್ಲ
I will place it before my Lords.
Yes. Yes, sir. There appears to be a case for them. We'll hear this. Objections ಹಾಕ್ತೀರಾ?
ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ.
The petition calls in question proceedings. Charge sheet ಹಾಕಿದಾರಲ್ಲ?
ಹಾಕಿದೆ.
ಇನ್ನೂ ಹಾಕಿಲ್ಲ.
Yeah, filed charge sheet.
Proceedings in
Is
crime
charging.
number 72 of 2024 registered for offences punishable under section 306 of the IPC. The learned additional SPP submits that the charge sheet has been filed in the case at hand on 17/5/2024 itself. The learned counsel for the petitioner would submit that he would argue the matter instead of challenging the charge sheet. Therefore, he is heard. The learned counsel seeks to impress upon the fact that there is neither proximity nor goading by these petitioners against the husband of the complainant, who is said to have died by commission of suicide, and therefore these petitioners are alleged of abetting such suicide. The learned counsel would seek to place reliance upon the latest judgment of the apex court in the case of Prabhu versus State of Karnataka, 2024 SSC Online SC page 137, to buttress his submission that unless there is instigation or goading that would lead the victim with no other option but to commit suicide, the abetment to suicide cannot be driven home against these petitioners. Per contra, the learned additional SPP would, by taking this court through the evidence and the death note appended, the death note which forms a part of the charge sheet, to contend that there was constant harassment to the victim. Therefore, the petitioners are prima facie guilty of abetment to suicide under section 306 of the IPC. He would seek to place reliance upon the judgment of the apex court in the case of S. Mahendra versus State of Karnataka, and reported in 2022 2 SCC page 139, where the apex court 129, where the apex court considers the very same issue and holds that the proceeding under 482 should not be in a proceeding under 482, when facts are thus, the court should not have interfered. Yavat.
2 weeks plus.
Objections, if any, in the next 2 weeks. List the matter on 5th July. ನಮ್ಗೆ next time ಏನಾಗಿತ್ತು? ಎಲ್ಲಿ judgment ಮಹೇಂದ್ರ?
I'll pass it on. I didn't get it much. Yesterday.
Judgment ತಂದಿದ್ದೀನಿ.
I made a note of all that. Pass it on next day.
ಅದು ಯಾವುದು 7 ಅಲ್ಲ, ಇದು ಬೇಕಾಗಿರೋದು.
I'll get it.
In the meanwhile, amendment, the charge sheet is concerned, amendment.
ಇಷ್ಟೊತ್ತು ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಮತ್ತೆ? ಅಮೆಂಡ್ ಇಲ್ಲ, ಫೈಲ್ a fresh petition. What is this? Leave it, we'll dismiss it right away. List on 5th.
Right.
Yes.
Bill number 6.
22 ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, 22 2 SCC 129. Yes, sir. Yesterday's matter.
Yes, yesterday's matter, my lord. This matter also, my lord, charge sheet has been submitted to the court.
It is.
Hello.
Charge sheet ಹಾಕಿದೆ.
Then I have to verify. Sir.
Yes. Otherwise, one clarification.
Only
They have
one-
invoked Arms Act.
Yes,
You are alleged to have been carrying long end choppers or whatever in the car.
yes,
Your contention is that it would not come under the Arms Act.
yes.
Uh,
But here FIR was registered, my lord, for offence under section 25(1)
Arms Act.
triple A.
Ah.
My lord, which is, my lord, triable by sessions court, punishable to the extent of life imprisonment.
Ah.
My lord, this is sheer abuse of process of law. My lord, quoting this section, my lord, registered FIR, they were taken to custody, my lord, produced before the magistrate also. my lord.
What is the incident that led to?
Nothing happened, my lord, that in the car, my lord, the weapons were there.
Why?
My lord, they had gone, my lord, to police station to furnish a surety as per the uncity bail order. My lord, uncity bail order, my lord, I have produced here, FIR was registered in respect of accused number 6, your lordship. My lord, FIR. is
Crime
at
number
case-
275 of 22?
Yes, yes, my lord. This
Ah.
is the FIR, my lord. In this, my lord, uncity bail was granted by sessions court.
Where is the
For
bail order?
accused number 9, my lord,
Bail order?
bail order at page 41, my lord. They had gone to furnish a surety. They were detained, my lord, and then at night, my lord, 10 o'clock, they registered an FIR and produced before. And the next day, quoting, my lord, an offence which is trial by sessions court. For nothing. My lord, if FIR goes, my lord, charge sheet also goes.
No, that is true.
Yes.
I am sure of all that.
Yes, your lordship.
Thing.
Lordship, may kindly see, my lord, the sections quoted in the FIR, my lord, that.
No, this is
25(1)
25
AA.
Arms Act, ಕೊಡಿ madam. No, what was the acts to grind against you by the state?
Nothing, my lord, that
Why were you targeted?
Lord, police, my lord, they had, because, my lord, accused number 9, he succeeded in getting uncity bail in a old matter. My lord, they were searching for him. My lord, he is from Andhra Pradesh. My lord, the other accused, my lord, they had gone to police station to furnish surety along with him. My lord, they went at 2 p.m. My lord, they were asked to wait, my lord, at up to 10 o'clock. At 10 o'clock, my lord, when they were waiting in the car, my lord, they were taken all inside the police station, detained, and next day they produced quoting, my lord, which is impossible to get a bail.
No, whoever manufactures, sells, transfers, converts, repairs, tests, proves, exposes transfer of his possession or conversion of repair to prohibited arms
Prohibited arms.
and prohibited ammunition in contravention of section 7. What is section 7?
Again, my lord, it's a license is required, my lord, section 7. It is.
Acquire of any possession of
Possession,
carry.
manufacture, prohibited arms. Prohibited arms yaudu?
My lord,
Even
only
knives
long
All
choppers,
ammunition.
Long is also prohibited.
no. Prohibited arms, my lord, is defined, my lord, under section 2(7).
It should be defined.
Yes. My lord, these are all firearms,
To
my lord,
steal.
are prohibited arms, not a long chopper keeping in vehicle, my lord, is a prohibited arm.
Prohibited ammunition, prohibited arms.
Arms,
Yes.
C to
Ideal, it is defined. Where are you going
Steam.
beyond the definition?
Yes.
sharp edged. Lordship.
Apply to trigger missiles, continued discharge until pressure is removed from trigger and magazine. Weapons of any design.
To C, my lord.
To C na.
Yes,
Prohibited arms, your lordship may kindly, I, my lord, that section.
definition of
2I.
arms. Definition of arms.
Arms. Arms, all right. Come
Arms
to
are
prohibited arms.
prohibited arms.
Arms, everything may be. What is prohibited arm?
Now they've invoked 25(1)(b)(b), man. In the charge sheet.
FIR ಯಾಕ್ ಅದಕ್ಕೆ ಹಾಕಿದ್ರಿ?
FIR ಹಾಕಿದೆ, but subsequently.
Why? When what senior counsel
they
says is
invoke
correct.
Both, they invoke both the provisions.
No, because that is punishable by life imprisonment.
Life.
You will not get bail.
At the time of invoking FIR, they
Why
invoke
do you,
both
why do you
provisions.
simply invoke something? Without there being any substance, why do you simply invoke something? Then why did you now wriggle out of it? How did you now wriggle out of it?
Based on the
Based
investigation.
on what? Based on what? Were there any prohibited ammunition or arms in the vehicle
it's
that
only
you
the weapons.
intercepted?
Only weapons.
Only weapons.
Weapons.
It would not come under prohibited ammunition?
No, it's only arms.
It's only arm. Then how did you invoke that provision at the outset? No, they may be something.
Yes.
You should have responsibility to invoke proper, ಬೇಕಾದ ಕೇಸಲ್ಲಿ ಬೇಕಂತ ಬಿಟ್ಬಿಡ್ತೀರಾ? ಯಾವ್ದ್ರಲ್ಲಿ ಏನ್ invoke ಮಾಡ್ಬೇಕು, you take the victim for a ride by invoking some provisions which will enable an interim order here. And in these cases, you invoke something that bail also should not be granted.
You can see the weapons used there.
The weapon, are they prohibited?
That's correct.
25(1) bail ಮಾಡಿದ್ರೆ ಏನು? Bail ಸಿಗುತ್ತಾ ಇಲ್ಲ? Life imprisonment ಅಲ್ವಾ? Deliberately you invoke this. What senior counsel says is correct.
At this stage of bail, my lord, magistrate has called for explanation. When we urge for on merits, my lord, kindly see, my lord, page 28. A report was called for from the concerned police as to why they invoke this section. My lord, they invoke section, my lord, their explanation, my lord, is that we will invoke appropriate section at the time of charge sheet. That
Arey,
is the reply.
What is this? You take somebody's liberty for a ride and then say, casually say, we will invoke appropriate section. Who is the IO?
Securement.
No, something has to be passed against this IO. It's not correct.
Page 64, my lord, the reply is that ಸೂಕ್ತ ಕಲಂಗಳನ್ನು ಅಂತಿಮ ವರದಿಯಲ್ಲಿ
ನೋಡಿ ಇಲ್ಲೇ ಹೇಳ್ತೀರಾ 25AA ಅಥವಾ 25(1)B ಮಾಡ್ತೀವಿ. Why did you make it 25(1)A?
And my lord, these are all, my lord.
Sir, they may be criminals, they may be anything. But their liberty cannot be taken away like this by invoking a provision which will never entail a bail.
Well,
And ಸಿಕ್ಕಿದ್ರೆ prohibited ammunition ಇದ್ರೆ NIA invoke ಮಾಡೋದು ಎಲ್ಲ prohibited ammunition. You have invoked
I've
against
been,
these people.
arms could have been a properly the right.
Hey,
one.
what arms definitely.
properly-
Arms, yes, you do
Yes.
it. ಇದು bail ಕೊಡಕ್ ಮಾಡದೇ ಇರೋದಕ್ಕೇನೆ ಮಾಡಿರೋದು. Yes, anything else?
Now the charge sheet has been filed.
No problem, yes. I will stay this now.
Like, Lordship may have it, my lord. Next week, I'll seek the explanation from the IO, my lord, then
No, explain, let the IO be present.
I'll
Yes.
keep him present.
Keep him present. Heard the learned senior counsel, a Hasmat Pasha appearing for the petitioner. A crime comes to be registered against these petitioners in crime number 162 of 2024, invoking section 25 within bracket 1 capital AA and 25(1)B small b FIR against under the Arms Act 1959, hereinafter referred to as the Act for short. The learned senior counsel would take this court to the complaint and demonstrate prima facie that the very invocation of section 25(1) AA is on the face of it an abuse of the process of the law, only to deny these petitioners being granted bail, as 25(1) AA is punishable, which can extend up to life imprisonment. Punishable with 10 years, which can extend up to life imprisonment.
Minimum of 10 years. you know.
Minimum of 10 years, which can extend up to life imprisonment. The learned senior counsel would refer to the order granting bail where the concerned court has sought an explanation from the hands of the investigating officer as to why why section 25(1) AA is invoked when none of those ingredients were present in the case at hand. A reply is submitted to the concerned court by the investigating officer that while filing the charge sheet, they would invoke appropriate sections. It definitely shocks the court as to how 25(1) AA, a very grave offense of carrying prohibited ammunition or arms, is invoked against these petitioners, which ostensibly appears to be to deny them the grant of bail. And later, in a casual manner, 25(1) is now invoked in the charge sheet against these petitioners. There is a vast difference between section 25(1) AA and 1B. Section 25(1) AA reads as follows. Section 25(1) deals with, punishes the person carrying prohibited arms or prohibited ammunition in contravention of section 7. Section 7 deals with prohibited ammunition or arms. Prohibited ammunition and arms bear definition in section 2. The petitioners are alleged to have been carrying certain machete in the vehicle, which was intercepted and found. This prima facie would not come within the definition of prohibited arms or ammunition.
Not only in arms also, my lord, it will not come.
Prohibited arms or ammunition,
Also
and
arms.
even in the arms is the submission of the learned senior counsel. The matter would require consideration. The investigating officer appears to have deliberately invoked 25(1) AA. Therefore, he shall submit an explanation as to why he invoked 25(1) AA when none of the ingredients of the said offense are even on the face of it found. There shall be an interim order of stay of all further proceedings against these petitioners pursuant to the registration of the crime in crime number 162 of 2024 till the next date of hearing. List the matter on 5th July at 2:30 PM.
My submission, my lord, 1B also does not apply.
That we will consider later.
Please.
Like,
My lord, this complaint which has been filed, my lord, is a counter for the complaint which we have filed previously. The petitioner has filed a previous complaint where FIR has been made.
What
in that-
happened to that? Sir?
That is
Charge
still
sheet
in,
ಹಾಕಿದ್ದಾರೆ.
no, my lord,
ಅದರಲ್ಲೂ ಹಾಕಿಲ್ವಾ?
no.
ನಿಮ್ದ್ರಲ್ಲಿ 341.
Yes, ma'am.
Yes. 341 ಗೆ ಏನಿದೆ?
Wound certificate.
341 ಗೆ ಏನಿದೆ ಅಂದ್ರೆ wound certificate. 323 ಗೆ ಇದೆ ಅದು.
ಅಲ್ಲ ಅವ್ರನ್ನ ಹಿಡ್ಕೊಂಡು ನಿಲ್ಲಿಸಿ ದಾರಿಲಿ ಹೋಗ್ಬೇಕಾದ್ರೆ ಹಿಡ್ಕೊಂಡು ವೆಹಿಕಲ್ ನ
ಏನಿದೆ wound certificate?
ಪೇಜ್ ನಂಬರ್ 24, my lord. Yes, traveling, he was stopped. It clearly states it is simple in nature, but the thing is, my lord,
You wound simple grievous ಇರ್ಬೇಕು ಅಂತಿಲ್ಲ. Wound
my lord,
ಇದ್ರೆ ಸಾಕು.
the petitioners are not present at that place at that time, my lord.
What is your complaint?
Our complaint is that, my lord,
Same
in-
day?
not on the same day, my lord.
Then?
Before, his contention is that he filed a case in crime number 36. It is,
Crime
we have,
number 36 ನಿಮ್ದೇನು? ಇದು ಯಾವ crime? 522.
we have furnished that PCR, my lord.
Yes, ಬೇರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಟೀರಿಯಲ್ ಕೊಡಿ. ಇದೆಯಾ? Give it. What is the ಐ ವಿಟ್ನೆಸ್ ಇದಾರಾ? ಐ ವಿಟ್ನೆಸ್ ಇದಾರಾ?
ಇಲ್ಲ.
The petitioner is before this court calling in question registration of a crime in crime number 522 of 2023, registered for so and so. The learned counsel submits that the petitioners register a crime against the complainant in crime number 36 of 2023, which is under investigation. As a counterblast to the said crime, an incident that never happened is sought to be projected. The learned additional SPP was directed to produce the original records. There is no evidence against these petitioners, either eyewitness or otherwise. The only evidence that is recorded is that of the complainant, who says that the incident has happened. In the light of the pending dispute between the two and the crime registered against the complainant, the impugned crime being registered as a counterblast cannot be brushed aside. Till the appearance of the second respondent complainant, there shall be an interim order of stay of all investigation in crime number 522 of 2023. Yes.
Charge sheet has been.
File I, and all,
ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿದೆ.
oh, sorry, proceedings in so and so, CC. Ithole Jagdish.
Respondent number 2, my lords, I feel for a short accommodation to
Idella forged.
statement of objections. My lords, yesterday they gave me the papers, although your lordships had directed 1 week ago to give the papers. It had come on the
Jack,
last day.
why that mistake? 10/6/2024, I have directed you to give,
My lords,
and
I
you
got
give on
it yesterday.
18th.
And not just that, my lords, they filed additional documents of more than
File,
100
file.
pages.
I'll take it next week. There's a folly on the advocate on record.
I consider it. And one more aspect is, my lords,
ನೀವೇ ಯಾಕೆ mic use ಮಾಡಿ?
please, my lord. One more aspect is, immediately after registration of the FIR, now I am informed that the entire sale consideration, the purchase, they kept it in the
No,
bank
no,
account. They
let
got it freezed. How it goes on, my lord? A dispute which is purely civil, they go
No,
to the.
it appears to be covered by Lalit Chaturvedi, just see,
My lords, that.
just see. While filing your objections, you do it, no issues.
My lords, in fact, there's a judgment of a coordinate bench of this honorable court, my lords, in Y.N. Srinivas, where it says that in a similar circumstance where there was a fabricated document,
No,
on
that
the
if it,
basis
if
of
you
which a
prima facie show that it is fabricated, definitely I will not interfere in
deed
this.
was executed,
We'll see.
this honorable court has come to the conclusion that forgery and a civil suit, if so filed.
No,
will
it is not the law that merely because pending criminal case should go away. There are many judgments to that
Here
effect.
it's
ಅವರೇ appear ಆಗಿದ್ದಾರೆ ಈ ಕಡೆ.
Please,
So ತೊಂದ್ರೆ ಇಲ್ಲ.
My-
I'll
my
take
lord,
it on next Tuesday. I'll take it.
please, there's absolutely no
Fantastic.
allegations of nothing of fabrication in the present
We'll
case.
see.
If somebody else claims some right, my lords, immediately this.
ನೀವು
case
ಅವತ್ತು
is
ಕಾಪಿ
filed.
ಕೊಟ್ಟಿದ್ರೆ she would have come up with the objections.
Please.
Yes.
Now, my lord, may I also submit now itself, my lord, that your lords may also consider the FIR and subsequent event of this freezing also, my lord. So immediately.
Freezing of the bank account.
Yes, they immediately after the FIR, they got the freeze.
Fine.
And in the meanwhile, let them not proceed further. That's all my submission.
Proceed further for what?
The FIR they got registered.
ಹಾ.
Let them not, they are calling them, ಬನ್ನಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡೋಣ. ಯಾಕಂದ್ರೆ 16 ಕೋಟಿ ನಮ್ಮ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಇದೆ.
Compromise ಮಾಡೋದಿಲ್ಲ.
ಅಲ್ಲ ಪೊಲೀಸ್ ಅವ್ರು ಕರೆಯೋದು ಬೇಡ ಅಂತ. ಇದು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಮ್ಮ ಅದಾಲತ್ ಇದೆ.
That's all right.
ಲೋಕ
They
ಅದಾಲತ್
will
ಇದೆ.
not-
No, we have not filed any civil suit.
ಇಲ್ಲ ಹಾಕಿಲ್ಲ, ಸಿವಿಲ್ ಹಾಕಿಲ್ಲ. But they can achieve, could not achieve their.
We'll see. Could not achieve ಅಂದ್ರೆ
Could
ಹಾಕಿದ್ರೆ
not
ತಾನೇ.
achieve the civil court is being achieved. through the police.
ಹಾಕಿದ್ಮೇಲೆ whether they can achieve or
ಇಲ್ಲ,
not.
defreezing ಎಲ್ಲ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ಲಿ ಬಹಳ ಕಷ್ಟ ಇದೆ. To freeze the account. That has been freezed immediately.
Then ನೋಡುವ.
Court freeze, I don't know.
Let's see. I'll take it next Tuesday.
Very well. Very
Yes.
Great.
At the learned counsel BG Nayantara submits that the a copy of the writ petition,
Criminal
copy of the criminal petition is served upon her only yesterday. Notwithstanding the fact that it was directed to be served on 10th itself. Therefore, list this matter on 25th in the fresh
But
matter.
My name in the cause list may be
ತೋರ್ಸಿಲ್ವಾ?
printed correctly. It's
ಏನಾಗಿದೆ?
printed wrongly.
Which serial number is it?
Serial number 8.
8. Registry to correct the name, print the name appropriately as Nayantara BG.
Please, my lords. I'm grateful. 9.
Great.
See, DB Act, my lords.
The petitioner is before this court seeking the following prayer. The petitioner is the wife of the first respondent. First respondent, alla?
Yes, ma'am.
First respondent and the daughter-in-law of respondents 2 and 3, and the sister-in-law of the fourth respondent. Alleging domestic violence as is defined under the Act, the petitioner seeks to register an application before the concerned court in criminal miscellaneous 62 of 2024. The concerned court, on going through the application, nips it in the bud by observing that the case does not even project any domestic violence. A perusal at the complaint / application filed under section 12, there is abundant material to demonstrate prima facie that there was domestic violence by the respondents herein. A notice in the least or an inquiry in the least ought to have been conducted by the concerned court. Nipping it in the bud by dismissing the complaint undoubtedly causes grave prejudice to the wife, the applicant. If there is no case later found out, appropriate orders would be passed by the concerned court, not dismissing the complaint itself, as maintenance, residence, and all other interim reliefs were also sought at the hands of the concerned court by the petitioner wife. Since no notice was even issued to the respondents, I deem it appropriate to set aside the order impugned, restore the application before the concerned court with a direction to the concerned court to regulate its procedure and proceed further. For the aforesaid reasons, the following order: allowed, quashed. Application number criminal miscellaneous 62 of 2024 stands restored in the file of so-and-so court. The concerned court is directed to regulate its procedure and proceed further in the matter. All contentions left open. Next. Sanction records. Last time I had asked you. Order nodilla last time. Nimige.
They are not served a copy.
Huh?
Copy ಕೊಟ್ಟಿಲ್ಲ ನಾನು.
No, my lords.
What is this?
We have served the two set of papers in the registry.
ಅವ್ರು ಕೈ ಕೊಡಕ್ಕೆ ಏನು ಒಂದು ನಿಮಗೆ?
He was retired way back in the year 2020.
Correct. Allegation is you kept the file till the amendment of the act and now you have accorded sanction. That's the allegation.
Not sanction subsequently withdrawn, they have produced the.
Withdraw ಮಾಡಿ ಮತ್ತೆ ಆಮೇಲೆ ಕೊಟ್ಟಿದಾರಾ?
No, my lords.
ಮತ್ತೆ?
ಅದಾದ ನಂತರ they waited till my retirement. Then they filed a charge sheet. In the
ಆಮೇಲೆ sanction ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಮಾಡಿರೋದು.
Please, now 11 witnesses has been examined.
Sanction cuts at the root of the matter. Sir, how did the court take cognizance without sanction?
Not, he was retired in the year.
Retired ಬೇಕಾಗುತ್ತೆ. Where is?
2022.
The cognizance
He
in
is
the year
retired.
2022.
The retired in 22.
Yes.
No, 20 he was retired.
Even against a retired employee, you need sanction under section 197, if not 19. You may not need it under 19 of the Prevention of Corruption Act. Under 197, you do need. Lab Singh versus State of Punjab.
Lab Singh.
197 in it.
What, Latif?
Please.
ಈ ಕಡೆ ಬಂದ್ಮೇಲೆ ಮರ್ತು ಬಿಟ್ಟಿದ್ದೀರಾ ಎಲ್ಲ?
97.
14-16-807, Lab Singh versus State of Punjab, Punjab versus Lab Singh.
Yes.
Even retired persons would need sanction. The test is nexus, whether it was in discharge of official duty. No doubt, because it's sanction 19, you have sought.
Please.
It is in discharge of official duty. It has to be. So 197 automatically applies. Witness ಏನಾರು ಆಗಿರಲಿ.
I'll go.
No court shall take cognizance. Say see 197, non-obstante. Both 19 and 197. Retire ಆಗೋರು ಕಾಯ್ದ್ಬಿಟ್ಟು ಆಮೇಲೆ you grant sanction. ಅಲ್ಲ you file the charge sheet ಯಾಕಂದ್ರೆ sanction ಬೇಕಾಗಿಲ್ಲ. ಯಾವತ್ತು charge sheet ready ಇದ್ದು?
My lords, the charge sheet is ready. My lords, charge sheet is ready.
When was the sanction accorded and withdrawn?
My lords, the accorded on 17/1/2019.
That was withdrawn. Why?
It is withdrawn on 12/3/2020.
Why was it withdrawn?
My lords, the document reveals that, my lords, there is his brothers and other properties were.
Why was it withdrawn?
My lords.
Why was it withdrawn?
My lords, your lordship may kindly come to the page number.
Sir, why was it withdrawn? ಹೇಳ್ಬಿಡಿ.
No, withdrawn ಅಂತಂದ್ರೆ the materials were not properly placed before the sanctioning authority when the sanction was accorded. Subsequently, it was realized that it was based on, yes.
So who withdrew it? The very competent authority?
Yes, the same competent authority, the same competent.
That is after retirement.
Date said. Sanction
Millards,
Granted on,
the sanction is
17.
granted on 17/1/2019, withdrawn on 12/3/2020. On 31/8/2020, the petitioner attained the superannuation.
charge sheet filed before the court on,
18/2/2022.
trial is on.
Yes,
Cognizance is taken on 19/3.
Cognizance taken on
19/3/22. A detailed order is passed.
13(1)D na?
Please.
Alla,
13(1)E.
13(1)E.
13(1). Detailed order is passed.
Please.
So
Millards, his lordship's Justice Sunil Dutt Yadav ಅವ್ರ judgment, so Jamir Pasha judgment na rely ಮಾಡಿದ್ದಾರೆ. Millards, in that case, Millards, the person was retired even prior to the amendment. It
ಯಾರು
is-
ರಿಲೇ ಆಗಿರೋದು?
Millards, the trial court, while taking the cognizance,
ಸರ್ ಅದನ್ನೇ.
while taking the
ಇವ್ರು
cognizance,
ಇವ್ರು
the
ಕೊಟ್ಟಿರ್ತಾರೆ,
trial court
ಅದಕ್ಕೆ
relies
ಅವ್ರು
on that
ತಗೊಂಡಿರ್ತಾರೆ.
judgment. That is totally different.
ಇಬ್ರು ಗೊತ್ತಿದ್ರಲ್ವಾ?
I'll go through that.
You go through, take your time. Till then, let proceedings not go on.
Then I'll pass on that to Syed Zamir Pasha.
ಪರವಾಗಿಲ್ಲ. ಲಾಭ್ ಸಿಂಗ್ ಇದೆಯಾ ಅದ್ರಲ್ಲಿ? ಲಾಭ್ ಸಿಂಗ್ ಇದೆಯಾ ಅದ್ರಲ್ಲಿ?
Yes.
ಕೊಡಿ ಇದ್ರೆ.
ಇದೆಯಾ? ಇದೆಯಾ? ಇಲ್ಲ. ಪಂಚಲಿಂಗಿ.
ಪಂಚಲಿಂಗ್, ಲಾಭ್ ಸಿಂಗ್ ಸರ್. ನೀವು ಕರ್ನಾಟಕ ಪಂಜಾಬ್ ಇದ್ ಮಾಡ್ಬೇಡಿ. The petitioner is before this court calling in question the proceedings in special case number 11. Jagdish, you have anything to say?
We are only formal part in.
Formal. The
Some
petitioner
copy
is
by
before this court calling in question proceedings in special case number 117 of 2022, registered for offences punishable under section 13(1)E, read with 13(2) of the Prevention of Corruption Act. The sanction in accordance with section as necessary under section 19 of the Prevention of Corruption Act was granted to prosecute the petitioner on 17/1/2019. The competent authority, realizing that there was an error in grant of sanction, withdraws the said sanction on 12/3/2020. After the withdrawal of the sanction, petitioner retires on attaining the age of superannuation. Till that time, no charge sheet was filed, even though sanction was granted on 17/1/2019 and it was withdrawn on 12/3/2020. The prosecution had close to 14 months to file the charge sheet, which they did not do. After the retirement of the petitioner, on the score that against a retired employee, sanction need not be sought for, they filed the charge sheet on 18/2/2022, and the concerned court takes cognizance of the offence as aforesaid on 19/3/2022. The defense of Latif appearing for the Lokayukta is that one
The offences are not invoked, therefore 197 sanction is
IPC ಏನು ಇಲ್ವೇ ಇದರಲ್ಲಿ?
13(1)E ಮಾಡಿದೆ.
only 13(1)E.
Only 13(1)E now.
Please, Mullah.
Yes,
I'll pass on the recent judgment of the apex court. The station house officer was B.S. Srinivas. I'll pass on that.
Sir,
judgment.
B.S. Srinivasan.
Just clarified.
Justice Pardiwala.
Paragraph.
Is 2020, that can, during the proceedings, anytime sanction can be produced.
ಇದರಲ್ಲಿ the act is not retrospective ಅಂತ ಮಾಡಿದೆ.
We have not invoked anything of,
No, it's only
IPC
IPC offense.
No, IPC offenses.
only disproportionate asset.
ನೀವು ಹೇಳ್ಬೇಕಲ್ವಾ IPC ಇಲ್ಲ. ಹೇಳಿಲ್ಲ ನಮ್ಮ ಹತ್ರ.
ಲಾಭ್ ಸಿಂಗಲ್ಲೂ ಅಷ್ಟೇ.
Lapsing is also on the.
There
ಲಾಭ್
was
ಸಿಂಗಲ್ಲೂ
IPC.
ಅಷ್ಟೇ, 13(1)E and 13(2).
There is an IPC offense also.
ಲಾಭ್ ಸಿಂಗಲ್ಲ.
Please.
ಏನು?
IPC ನಿದೆ.
ಇದೆಯಾ?
Yes.
IPC
yes.
ನಿದೆ. PC Act and IPC both.
Available.
PC ಇದ್ರೆ, but it's an amalgam. Anyway, we'll decide. this
97 will
issue.
not attract.
197.
We'll see, we'll decide this issue. Yes, so and so. The learned counsel Latif B submits that there is no IPC offense for obtaining sanction for against a retired employee. Once, sorry, section
19.
Latif B would submit that section 197 would not get attracted as there is no IPC offense against the retired employee and it was only offense under section 19. Be that as it may, the matter would require consideration and an explanation as to why between 17/1/2019 and 12/3/2020, no charge sheet is filed when the sanction stood withdrawn and the petitioner has retired on attaining the age of superannuation on 31/8/2020. This deliberate act needs explanation till such time further proceedings before the concerned court shall remain stayed. Yes,
Please.
By the state.
by the state, yes.
Copy could.
By the copy ಕೊಡಿ. ಕಾಪಿ ಯಾಕೆ ಕೊಡಲ್ಲ?
ಇಲ್ಲ, ನಾನು ರಿಜಿಸ್ಟ್ರಿ ಒಳಗೆ 2 ಸೆಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಇನ್ನೊಂದು ಸೆಟ್ ಕೊಡ್ತೀನಿ, ಈಗಲೇ ಕೊಡ್ತೀನಿ.
ಕೊಡಿ.
Right now I will furnish.
Yes, the date, will resolve this.
Please.
I thought you have invoked 420 also.
No. And out of 11 witnesses have been examined.
ಆಯ್ತು, ಒಂದು ವಾರ ಮಾಡದಿದ್ರೆ ಏನಾಗಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಏನು?
Next date 2ನೇ ತಾರೀಕಿಗಿದೆ. My lords, what happens is in that court, trial
ಡೇಟ್
court,
ಕೇಳಿದೆ ಅಷ್ಟೇ.
2/7 ಇದೆ.
2/7, post this one Monday na madam? One is Monday. Post this, list this matter on 28th.
Please.
Please.
Yes. The one at 31st, 29th, 30th and 1st. Yes. 28th.
Please.
7. My lord, complainant is a wife, my lord, and the petitioners are a sister, brother-in-law and brothers of the husband.
Heard the learned counsel appearing for the petitioner. The petitioner is the wife and her family members.
Petitioner is my lord,
Husband is not there.
no, my lord.
No, that's what I'm saying. Husband, crime is registered by whom? Husband,
Registered by the.
by the wife. right?
Wife,
Yes.
my lord.
The petitioners are accused 1, 2, 5. The family members of one Onnegowda TM, the husband of the complainant. It transpires that the husband of the complainant registers a petition seeking annulment of marriage against the wife. After which comes the impugned complaint. In the normal circumstance, there would not be, it is not the law, albeit prima facie, that if the wife registers the complaint after the receipt of a notice in the petition seeking annulment of marriage, these proceedings should be stayed or obliterated. But the facts in the present, the facts obtaining in the present case would clearly indicate no offense against these petitioners, much less the offenses alleged on a perusal at column number 17 of the charge sheet. ನೀವು ಒಂದು ಹಾಕಿದ್ದೀರಾ? ಇಲ್ಲ.
ಅಲ್ಲ ಇವರು ಲಾರ್ಡ್ಶಿಪ್ ಮೆತಿ ಪೇಜ್ 45
ಏನ್ ನೋಡಿದ್ದೀನಿ. ಇವ್ರು ಬಂದು ಗಲಾಟೆ ಮಾಡಿದ್ರು ಅಲ್ಲಿ.
ಪೇಜ್ 45 my lord, their own MC petition filed by them.
ಹಾ.
ಅದರಲ್ಲೇನೆ page para 11 my lord speaks about complaint being filed. That's one of the reason he is asking for divorce.
But what is there in the complaint? Husband and ilwala ಬಿಡಿ. There shall be an interim order of stay of further proceedings against these petitioners. Yes, next.
Based on a complaint. Managing
Yes, my lord,
director.
that I have been informed by the investigation agency. No action will be taken against her.
But chairman,
ಅಲ್ಲ but
ಲೋನ್ ಪೇಪರ್ಸ್ ಕಳೆದೋದ್ರೆ
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ.
ಲೋನ್ ಪೇಪರ್ಸ್ ಕಳೆದು ಚೇರ್ಮನ್ ಏನ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ.
It's the complaint seems to be only concentrating on the managing director rather than on the offense.
The lordship's entire complaint speaks something.
ಇಲ್ಲ, ಲೋನ್ ಪೇಪರ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಚೇರ್ಮನ್ ಅಂಡ್ ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ ವಾಟ್? ಚೇರ್ಮನ್ ಅಂಡ್ ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ or head of the legal cell. ಅಲ್ಲಿ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಎಲ್ಲೋ ಆದ್ರೆ ಇವರೆಲ್ಲ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ?
And they are based in Bombay and the incident takes place in Bangalore.
I have been informed, my lord, that though no material available, no case against her, we will not take any. Your lordship may record my submission, my lord. We will not even arrest her.
The learned additional
Without leave of
SPP
this court, we will not even arrest.
on the additional SPP gives an undertaking on instructions that no action coercive or any kind will be taken against this petitioner as there is no material to proceed against him. The learned.
But no
additionally-
material, but without leave of this court will not take.
Alla,
it.
therefore, the state shall not proceed against the petitioner in any kind without the leave of the court. List the matter on 11th July.
4 weeks, my lord, we will, by then investigation.
ಆಯ್ತು ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ತಾರೆ ಬಿಡಿ.
Or
List the matter on 23rd July. Heard the learned senior counsel ಜವಳಿ ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ಮಾಡಿ. Yes.
Therefore.
The one clarification, my lord, in the same matter, in case if there is any investigation help she is required, my lord, she can cooperate that. We will not.
No, don't, you will harass him.
We will not arrest her.
Chairman and managing director sitting in Bombay, what is he got to do? Complainant has some axe to grind against him, ಅದಕ್ಕೆ ಇವೆಲ್ಲ. Yes. ಏನಾರು ಇದ್ರೆ you seek leave of the court, I will permit.
39 for the petition.
10 days.
Please.
The petitioner is before this court seeking the following prayer. The petitioner is an accused in CC 6146 of 2021, gets convicted for the offense, files an appeal in criminal appeal 441 of 2023 as a condition precedent for grant of for an order of suspension. The court directs payment of 30%,
Please.
30% of the amount of the check. Challenging that order, the petitioner is before this court only for the reason that he needs 10 more days time to deposit the said amount. The 10 days yavattinda kodla? Date of receipt ಕೊಡ್ತೀನಿ.
From the date of receipt.
The prayer being innocuous, I deem it appropriate to permit 10 days time to deposit the said amount before the concerned court. 10 days would mean from the date of receipt of the copy of this order. The aforesaid observations, the petition stands disposed, ordered accordingly. Again, warrant ಆಗಿದೆಯಾ?
Warrant ಆಗಿದೆ. Till then.
Till such time, till the expiry of 10 days from the date of receipt of the copy of the order, the warrant issued against the petitioner shall stand suspended.
Please. Great.
14. Your Lordship, I appear for petitioner. Between the complaint and the petitioner, there was financial transaction. I borrowed sum of rupees 30 lakh.
ಆಯ್ತು, ಮಿಕ್ಕಿದ ಯಾವಾಗ ಕೊಡ್ತೀರಾ? 5 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹೌದು.
ಮಿಕ್ಕಿದ ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
Because I am ready to pay the money. Only the.
You
So they
made
have
part
issued-
payment.
Yes.
30 ಲಕ್ಷ ಇಸ್ಕೊಂಡಿದ್ರಿ,
ಹೌದು,
5
what
ಲಕ್ಷ
happened-
ಕೊಟ್ಟಿದ್ದೀರಾ,
what
ಮತ್ತೆ ಯಾವಾಗ
happened is
ಕೊಡ್ತೀರಾ ಹೇಳಿ?
I have issued 2 checks. For the
ಅದು
purpose of
dishonor
security,
ಆಗಿದೆ.
for the purpose of security. She did not return that check. That's the reason
ಈಗ
you are
now
asking
you
her to pay.
undertake, we will issue notice and ask her to return checks here only. You keep.
She initiated proceeding before the magistrate.
It's all
under
right.
NI
madam.
Act.
No problem. ನೀವು ದುಡ್ಡು ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಹೇಳಿ? ಇಸ್ಕೊಂಡಿರೋದು ಹೌದಾ?
ಹೌದು, I am admitting that.
ಕೊಡ್ಬೇಕಾಗಿರೋದು ಹೌದಾ?
ಹೌದು.
ಯಾಕೆ ಪ್ರೊಸೀಡಿಂಗ್ ಎಲ್ಲ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ ಒಂದೇ ಸರಿ?
Yes, please, your Lordship may issue notice later.
That all that I will do. ನೀವು ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಹೇಳಿ?
No, I need to consult the party when. That's
Yes,
it.
ನೀವಿದ್ದೀರಾ? 138 ಅಲ್ಲಿ ನೀವು ಯಾಕೆ?
ಇಲ್ಲ, 138 ಇಲ್ಲ. This is.
Then 406, 420.
They initiate both proceedings. One is before the police station, another one is under the NI Act.
ಎನ್ಯಾಕ್ಟ್ ಮಾಡಿದಾರಾ?
ಹೌದು.
The petitioner is before this court calling in question proceedings in crime number 37 of 2024, registered for offences punishable under section 406 and 420 of the IPC. A financial transaction between the two leads the petitioner to issue certain checks. Those checks are dishonored. Dishonoring of the checks, the complainant registers proceedings under section 138 of the NI Act.
Yes.
That is pending consideration. Simultaneously, the petitioner has also registered a crime for the same cause of action for offense punishable under section 406 and 420 of the IPC. The issue is whether the two proceedings can simultaneously be initiated. This is referred to a larger bench by the apex court, which is yet to be decided in the case of so-and-so 2022 SEC online SC page 110. Therefore, till such time, 110, therefore, till the next date of hearing, there shall be an interim order of stay for further investigation in so-and-so. List this matter on additional SPP 1 to emergent notice returnable by 12th July.
Beautiful, madam.
But ದುಡ್ಡು ಕೊಡ್ಬೇಕು next time.
ಇಲ್ಲ, ready ಇದೀವಿ ನಾವು.
ಎಲ್ಲಾ ಕೇಸು ಕ್ಲೋಸ್ ಆಗುತ್ತೆ ಒಂದೇ ಸರಿ.
Yes, please, your.
Yes. 7980 ಗೆ ಇಷ್ಟೊಂದು.
My lord, it's a clear case of abuse of police power. Absolute a fit case where we say police raj, my lords. My lords, what the petitioner is running is a poker place, my lords, poker club. He's
It is
been
held to be a skill alva.
skill.
Ah.
Both online poker has been held to be a game of skill, not of chance. Physical poker also has been held to be a game of skill and not of chance. There's no dispute on that. My lords, at the time when we were to open this recreational club in 2018, my lords, they would refuse license. We come before this court, and this court, my lords, at page 33, the order passed by this court is permitting us to carry on the activity with conditions. If my lords would notice page 35, where my lords, fortunately, one condition will come to my aid totally, where CCTV has to be put everywhere.
ಹಾಕಿದ್ದೀರಾ?
Complete CCTV. So this order which is passed, my lords, condition at page 35 may be noticed. Now, despite this, my lords, they would then come and start harassing us in the year 2022, my lords. We were running the club 2022 harassment. We file a contempt.
Yes, sir.
When, my lords, one aspect I may have to bring.
ನೀವು ಪೂರ್ತಿ ಹೇಳಿ.
ಒಂದು ಹೇಳ್ಬಿಡ್ತೀನಿ ಆ sequence, because now, my lords, we have CCTV footage. Police comes into the venue, my lords, and they see that all are playing poker. They ask, how is this game played? It is explained in front of the members. This is how it is paid. They stop it. They seize 21,000 rupees. They take 19 mobile phones, entire poker kit, and they close the.
Why did you
premises.
teach them?
After teaching them, my lords, problem
Why did
is
you, see, they learnt and they gave you.
we have it on CCTV footages. And with
ನಿಮ್ಗೆ
this,
ಯಾಕ್
my
ಬೇಕು
lords,
poker?
they shut down the club, which has been running from 2018.
ಓ ಇದೇನಾ ಮೊಬೈಲ್ ಫೋನ್ ಸೀಸ್ ಆಗಿರೋದು ಅಂತ ಹೇಳಿದ್ದು.
How do 19 phones have seized, my lords, 21,000 taken, all my entire poker
Why
set,
did you seize
club
the
has come to a standstill.
seizure? What illegal activity was going on there?
First time
ಎಲ್ಲ ಹಿಂಗೆ.
Lord.
ಅದರಲ್ಲಿ ಮಚ್ಚಿದೆ ಅನ್ಬಿಟ್ಟು ಆರ್ಮ್ಸ್ ಆಕ್ಟ್ ಮಾಡಿ.
Idralli antu judicial notice has to be taken, my lords, of how they've gone about it. I will point out, NCR is registered on the basis of the inspector giving complaint to sub-inspector. I have come to know, so this is my complaint. NCR gets registered, same day you get 155(2) notice, go to the club, ask them how it is played, poker played, and you do this activity.
You should not have learnt how to play.
Real
ಆಮೇಲೆ
harassment.
ನಾಳೆ ನಿಮ್ಗೆ ಕ್ಲೋಸ್ ಮಾಡಿ ಅವ್ರು ಆಟ ಆಡಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ. I don't know whether they're using my kit.
We are assured that everything is seized.
They could have, and with so many proceedings, my lords, and the club has been brought to a standstill. 500 members are there for that club playing this game.
First time birthday, we'll ask the check Miller what has happened, but 155 compliances happened in this case.
155 complaints is all
No
right.
problem.
Heard the learned senior counsel, Sandesh Chowta, appearing for the petitioner. What is called in question is only registration of a crime in crime number 155 of 2024 for offense punishable under section 79 and 80 of the Karnataka Police Act. Though these offenses are non-cognizable, cognizance of the action of the police is what is required to be taken by this court in the case at hand. The learned senior counsel would explain and would submit that everything is recorded in the CCTV footage, that the police enter the premises, ask the ask the inmates
Dealer, the person who deals.
ask the person who deals with poker to demonstrate to them as to how poker is played. And when it is demonstrated and taught how poker is played, the entire unit is seized and all mobile phones are taken away and the proceedings are initiated. On the ground that there is no CCTV in the unit and they were playing a game that is contrary to law. This court, in concerning the very same recreation society, has in writ petition 55798 of 2017 had held that license to play poker should be granted. Again, in which was following an earlier order in writ petition 39167, holding that the game of poker is a game of skill and not a game of chance or gambling. Therefore, the very registration of crime again appears to be an abuse of the process of the law by the police, albeit prima facie, till the learned additional SPP would justify his action by way of necessary documents or submissions. Till such time, all investigation in crime number 55 or 155, 155 of 2024 shall remain stayed.
Premises is kept under lock, my lords. Club is not
Open it,
running.
open it.
Adanaದ್ರು open ಮಾಡಿ, let the
In the light of the aforesaid circumstance of the issue being covered by 3 orders passed by the coordinate benches and no illegal activity being projected by the police, even in the impugned complaint, the premises that is now under lock and key shall be opened forthwith.
mobiles, 19 mobiles.
ಏನ್
of all
ಅಲೋನೆ
the
ಮಾಡ್ಬೇಡ ಮತ್ತೆ ಏನ್?
Members, my lords. Members mobiles.
ಅವ್ರದೆಲ್ಲ ಯಾಕೆ ಸೀಸ್ ಮಾಡಿದ್ರಿ
I don't
ಮೆಂಬರ್ಸ್
know, 19 mobiles, 21,000 in cash they've seized.
I'll second.
ಕ್ಯಾಶ್ ಇರ್ಲಿ ನಿಮ್ಮ ಹತ್ರ ಅವ್ರ ಕ್ಯಾಶ್
Mobiles ಆದ್ರೂ members.
ಬೇರೆ ಯಾವ್ದು ಯಾವ್ದು ಮೊಬೈಲ್ ತಗೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ?
Nice.
Right, invasion, right to privacy, sir. Have you registered anything against them?
I'll secure, my lord, what transfer.
If the mobile phones of all the members without any rhyme or reason are seized by the police as is alleged, the police shall forthwith return the same, as there is no warrant of seizure against private persons who are members of the club. The return of the mobile phone shall be reported to the court by the next date of hearing.
Obliged.
ಏನೇನ್ ಮಾಡ್ತೀರಾ? Yes.
CCTV ನನ್ನ ಹತ್ರ ಮೂರು ಇದೆ CCTV footage.
ಅಲ್ಲ ಅವ್ರಿಗೂ ಬೇಕಾದ್ರೆ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ, I'll pass it on to Mr. Jagdish.
ಪೆನ್ ಡ್ರೈವ್ ಅಲ್ಲಿ ಕೊಡಿ.
Pen drive. Obliged.
List on ಯಾವ್ದು ಬೇಕು ಜಗದೀಶ್ ಸರ್?
Week after next.
Week after next, 5th July? 5th July. ಅಕಸ್ಮಾತ್ ಅವ್ರ ಮೊಬೈಲ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಮೂವ್ ಮಾಡಿ. How can you see
Fourth-
somebody's mobile
fourth
just like
July.
that?
4th July.
ಆಯ್ತು 4th July. ಅಲ್ಲಿ ಯಾರೋ ಕೂತಿದ್ರು ಅವ್ರದೆಲ್ಲ ಮೊಬೈಲ್ ತಗೊಂಡು ಹೆಂಗೆ?
I'll check, my lord, what.
What? This is police power. Misuse of police power.
I'll check.
Next.
This case and for petitioner, my lordship. 138 proceedings, my lordship. 311 application is rejected by the trial.
ಸರ್ವ್ ಮಾಡಿ. ಎಷ್ಟನೇ 311 ಇದು?
First 311. ನಾನು
The-
ಚೀಫ್ ಎಕ್ಸಾಮ್ ನ
ಯಾವತ್ತು ಜಡ್ಮೆಂಟ್ ಇದೆಯಾ?
ಇದಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್.
Arguments on this. Learned counsel for the petitioner is directed to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement to the effect in the next 3 days. List the matter next Friday, 28th, till such time further proceedings before the concerned court shall remain stayed, both 16 and 17. Yes, additional SPP, I had asked you to justify the action. Well, Mahesh Ali. Nimda madam, why?
So I heard 17, apologies, your lordship.
Huh.
In this, the IO.
No, detail order I passed last time.
File has been misplaced, my lord.
Our money is misplaced ಅಂತಾರೆ, ನೀವು file misplaced ಅಂತೀರಾ? Yes. We'll have it after 2 weeks. You'll trace the file?
Yes.
Yes.
Next week only.
Huh?
Next week. my lord.
ಆಯ್ತು, next week.
There's
List the
Next week, interim orders.
that is there. I have granted it, yes. List the matter on 28th, ಆಗತ್ತಾ?
27th.
27th. List the matter on 27th at the request of the additional SPP. The ones that interim order subsisting shall continue till the next date of hearing.
Grateful.
Check bounce proceedings stayed on account.
You have asked for disposal within 3 months.
Your lordship
Second
need to
prayer.
order that.
We'll do that.
Very.
ಯಾವ ವರ್ಷದಿದೆ? 2007?
2007 is the petition, is the complaint filed. In 2011, it is stayed.
2011 stayed.
14 it is stayed. In 2014, it is stayed. In
Where?
These proceedings that are subject matter of this petition,
Stay ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ?
the magistrate has stayed it on account of a memo moved by the accused.
Magistrate stayed it.
Yes, your lordship.
How come?
He has stayed it on account of a memo moved by the accused stating that the company which has issued the check has undergone liquidation, undergone winding up.
That's an order on merits. Where is the question of stay?
Your lordship, I'm saying the resumption of the proceedings on account of the fact that 138
It is dismissed.
No, your lordship.
Well, direct resumption of proceedings immediately.
Very good.
The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner would submit that the proceedings were initiated against the ಮತ್ತು ಒಂದು recall already ಆಗಿದೆ?
Your lordship, what happened is in 2014, the matter got stayed. Then in 2018, the complainant reported that the winding up proceedings are not proceeding any further.
Who appears for the respondent?
Mr. Kamlacharan appeared on the last occasion and in fact had handed over a copy of the judgment
Yes,
that
sir.
covers this
Where is-
issue.
For the respondent, my lords.
Yes. Yes, sir.
Lords, arguing counsel has a personal inconvenience to this matter, my lords. My lords, may
List tomorrow. List tomorrow in the fresh matters list.
may kindly
I will direct resumption of proceedings there, sir.
I'm obliged.
On your
Lord-
memo, how can it be stayed? Yes. Next.
Lords, Lords, in fact, it was stated in 2014, my lords.
Maybe, sir.
Lords, may kindly fix a date.
It is too
There
late
is
in the
a
day for
personal
me to
inconvenience.
keep quiet, sir. To 10 years in the magistrate stays his own proceedings. Where is the power? A mockery.
Lord,
On a
need
memo filed by you.
Date,
If this is
there is a
permitted, then
personal
over.
inconvenience.
All memos will travel everywhere. Yes. Tomorrow in the fresh matters list.
Lords, may kindly, there's an inconvenience for tomorrow.
In the
my
fresh
lords.
matters list, if you want to argue, argue. Otherwise, I'm going to resume proceedings there. Let him pass orders on merits, not this way. 10
Yes,
years in on a memo, you got the proceedings stayed before the court. What jurisdiction the magistrate has to stay his own proceedings? Yes.
Lords, partner in a firm exits against the settlement of accounts of about 1 crore 30 lakhs.
It's a very well drafted complaint.
Yeah, I know, my lords.
Complaint ನೋಡ್ಬಿಟ್ರೆ ತುಂಬಾ between the lines ಓದ್ಬೇಕು.
Between the lines ಓದ್ಬೇಕಷ್ಟೇ.
ಎಲ್ಲ purely commercial transaction. And complaint is so well drafted.
Lord,
that ನೋಡಿದ ತಕ್ಷಣ there's something big.
This is the third complaint. First complaint they give, saying that the complainant asked the police intervention to get the time for payment of this money. Second complaint is given to the principal secretary. Principal secretary refers to it to one of the police stations. The police says that this is purely a civil transaction.
It is on the face of it.
Yes, X5
Heard the learned senior counsel, D.R. Ravishankar, appearing for the petitioner. What is called in question is proceedings in crime number 110 of 2024, which arises out of a private complaint registered on 23/4/2024. A perusal at the complaint would indicate something big, as it is a very well drafted complaint. But the soul of the complaint is setting the criminal law into motion on commercial transactions and recovery of money. Therefore, this court has undertaken the exercise of reading between the lines of the complaint as directed by the apex court in the case of Muhammad Ali versus State of Uttar Pradesh in 2023 SEC online SC page 950. And one more, Salib Bantena idiyalla. Salib so and so.
Yes.
And the apex court in both these cases have directed the court examining the petition under section 482 of the CRPC to read between the lines and see the intent behind the complaint. The intent is ostensible that it is for recovery of money and a pure commercial transaction being given a color of crime, albeit prima facie. Therefore, there shall be an interim order of stay of further proceedings in crime so and so till the next date of hearing. 1 HCGP 2 emergent notice returnable by 19th July.
There's one additional fact. This is after the initiation of 138 proceedings. She enters appearance, takes time for cross-examination after recalling the witnesses. Then she goes and gives this complaint as a counterblast to 138 proceedings.
Final order ಏನಾದ್ರು
Very well, lords.
ಎಲ್ಲ ಇಲ್ಲೇ ಬರ್ದ್ಬಿಟ್ಟು.
Right.
Yes. In terms of memo. ಏನೇನು ಹಾಕಿದಾರೆ? Maybe vacated. The petitioner has filed a memo seeking to withdraw the petition. The contents of the memo, the petition is permitted to be withdrawn, not on the contents of the memo, but is a withdrawal simpliciter. Yes. Next.
23.
I appear for petition, my lord. I have received the copy. Statement of objections copy they have. Served upon.
Why did you receive? Statement of objections ಅಲ್ಲೇನು What is it?
The only objection was we have not served them.
ಅಷ್ಟೇ.
We have served them.
ಆಯ್ತು, ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
No, minutes.
ಏನಿಲ್ಲ.
Maybe taken up next week or week up. There is already an
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ಲ, ಅದಕ್ಕೆ
ಇದೆ
ಅರ್ಜೆನ್ಸಿ
entry model.
Please, my lord,
Entry
interim
model
order.
ಇದೆ.
ಇದೆಯಾ? ಇಲ್ಲ. ನೋ,
No, my lord, interim order was granted in the.
it is not extended, sir.
Lord,
It is
it's
granted on 2/8/23.
IA filed for vacating stay.
ಮತ್ತೆ ಬಂದಿದೆ, ಆಮೇಲೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ. ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ. ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟ ಮೇಲೆ ವೆಕೇಟ್ ಮಾಡೋದು ಬೇಡ. Unless we hear it. 420.
Only 420 of IPC, my lord.
ಅದು why only 420? Who has lured whom?
So, my lord, is like they went on projecting as if as for the execution of the registered sale deed is concerned is yet to happen, and there is a agreement for sale in our favor. They went on projecting at us, we will do it later, we will do it later, there are communications. In the meanwhile, suppressing it, they sold to somebody else and they were informed to us. And
ಎಷ್ಟು ತಗೊಂಡಿದ್ರಿ ನಿಮ್ಮ ಹತ್ರ?
my lord, they had received 21 lakhs.
Along with interest ಕೊಟ್ಬಿಡಿ. ಹೆಂಗೋ ಸೇಲ್ ಮಾಡಿದಿರಲ್ಲ ಬೇರೆಯವ್ರಿಗೆ.
That is not the case, my lord. We will.
That is not the case, sir.
Sale deed is there, my lords. Afterwards only we came to know that the sale deed. Sale deed is produced, my lords, R5, page 30.
This is fraud. Anyway, he is
Please.
struggling, let Balkrishna come. Yes. Orders alittala.
As my lord.
List the matter on next Wednesday haki for admission. Interim order subsisting shall continue till the next. Interim order subsisting bada granted on 2/8/2023 shall continue till the next date of hearing. ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಅದು. Wednesday ಬೇಡವಾ?
Week after next, my lord, any day.
Week after next. Wednesday after next.
Please,
Yes.
please. And in the meanwhile, my lord, so of course, without prejudice to our contentions, my lord, if they are, whether they are willing to at least.
ಕೊಟ್ಬಿಡಿ, give a quiet as
Take
to everything.
instructions, my lord, I will take.
ಈಗ ಇನ್ನೊಬ್ರಿಗೆ ಸೇಲ್ ಮಾಡಿರೋದು ಹೌದಾ? ದುಡ್ಡು ಬಂದಿದ್ಯಾ? ಅವ್ರ ದುಡ್ಡು ಕೊಟ್ಬಿಡಿ.
There are other business transactions between the.
ಎಲ್ಲ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ, ಕರೆಕ್ಟ್ ಆಗುತ್ತೆ. ಕೊಟ್ಬಿಡಿ ಇದೆಲ್ಲ, everything will be closed. Give a quiet as to everything. All is well.
In fact, this is, I feel, is a matter as far, the only amount, question is one of amount, my lords. Of course, that amount according to us, the land value has gone. I feel that
That is true,
that's
but
why
at
they
least
separate.
ಅದಕ್ಕೆ with interest ಕೊಡಿ.
ಅದಕ್ಕೆ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು, ನಮ್ಗೆ ಗೊತ್ತಿಲ್ದಂಗೆ they have sold it for a very higher price to somebody else immediately, without even informing us. Agreement has never been cancelled.
Seek instructions. Otherwise, you have to face trial if this is the thing.
My lord, he waited for 10 years, my lord. After 10 years, he lodged the complaint. Only to my lord.
ಆಯ್ತು, ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಿ.
Lord, I will take
They were
instructions
supposed to
regarding.
give certain documents, they have never given.
Just enrichment. If you are without 10 years ಅಲ್ಲಿ ಇವ್ರು ಬರಲೇ ಇಲ್ವಾ ಮುಂದೆ?
ಇಲ್ಲ,
No, my lord.
continuous correspondence
Up
is
to
there.
10 years, my lord.
Continuous emails are there.
In the year 2023,
Thank you,
they issued a
ಹೇಳಿದ್ದಾರೆ
legal
ಅವ್ರು.
notice to me.
ಆಯ್ತು,
They don't inform us and sell it.
ಆಯ್ತು ನೋಡಿ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ, ಕಂಟಿನ್ಯೂ ಆಗಿರಲಿಲ್ಲ.
I am grateful.
2 Wednesdays. 3rd July.
Great.
Obliged.
Post immediately after receipt of notice of. ನೀವಿದ್ದೀರಾ?
ಅಲ್ಲ, ನನ್ನ associate.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇದೆ, maybe
Yes, so-
continue.
Madam, post immediately after service of notice upon so and so entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ. Next.
25.
Yes, madam.
Petitioner being A4,
ಅಲ್ಲ, ಈಗ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಏನ್ ಕೇಳೋಂಗಿಲ್ಲ, ಏನಿದೆ ಅಂತ.
ಇಲ್ಲ, interim application may kindly be considered, my lord.
ಇದೆಯಾ? ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ?
Order ಇಲ್ಲ ಸ್ವಾಮಿ. When the
Notice
matter
to
was,
R2. What is the matter?
matter is.
Entry order is not granted.
No, my lord. On that day, I was not able to appear.
384, yes. We'll post it immediately after receipt of notice. Post immediately after receipt of notice upon,
My interim application may kindly
no,
be
no.
considered.
not in this case.
No, because I may be permitted to explain the actual fact of the
Then
case.
tomorrow, yes, in the list tomorrow, in the fresh matters list. Yes. Not in the orders at all, yes, next.
Yes, ma'am.
Unless you are being arrested in the afternoon.
26.
Hearing for petitions, my lord. Matter has become infructuous. Police have filed charge sheet.
Challenge ಮಾಡ್ತೀರಾ?
No, my lords.
You don't want to challenge.
We want to challenge the charge sheet. my lord. Liberty
ಅದನ್ನೇ
may be
ಕೇಳಿ,
given.
yes, format order. ಗೊತ್ತಲ್ಲ madam? Yes. Disposed.
Time may be granted to comply that.
A week's time to comply with the office objections. Enter ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ.
Yes, in the event they stand complied, list the matter on 1st July.
Please.
Next.
28.
Idu nimde, madam. Office objections
Will be complied in the meantime. Kindly my interim application may be considered. Madam.
tomorrow.
Yes.
Yes, nothing in orders. Tomorrow, fresh matters list.
Yes,
Yes.
ma'am.
Comply with the office objections during the day. Yes. File kodi, madam. Notice to our 2 weeks time. Halima, madam, nimde.
And today itself I will comply.
Senate council submits that needful would be done during the course of the day. In the, ಒಂದ್ಸರಿನೂ ಬಂದಿಲ್ಲ court ಮುಂದೆ? Interim order ಇದೆಯಾ?
ಅವರಿಗೆ wound certificate ಆಗ್ಲಿಕ್ಕೆ your lordship has directed.
List the matter on Tuesday in the event the needful is done in the fresh
320
matters list.
323, 504, 506, 150.
30.
For the petitioner, Maharaj, I may be permitted to present the case, Maharaj.
No, sir.
21st ಗೆ judgment ಇದೆ.
ನಾಳೆಗೆ ಹಾಕ್ತೀನಿ.
Maharaj, it's a very simple matter.
ನಾಳೆ 21st, tomorrow is 20th?
No, 20th.
It is before 21st? Please. Then tomorrow. Yes.
Maharaj, office objections have been complied with.
The, accepting the submission of the council, office objections overruled, list tomorrow, 311 application,
311,
91, yes, tomorrow in the fresh matters list, yes.
51.
But I have done the needful, Lord. I have paid process.
Council submits needful has been done, office to verify. Interim order idea?
Please, Lord.
Idre continue ಮಾಡಿ. Next, yes.
32.
Yes, Girish?
Page number 5, order sheet as it is produced ಮಾಡಿದ್ದಾರೆ.
Submission accepted, Monday, fresh matters.
Cover by decision.
ಏನು covered by?
Non-cognizable offense, my lord.
ಯಾವುದು? Offense ಏನು?
504, 506,
No permission taken.
323.
No permission
ಇದೆ,
taken.
341 ಇದೆ, ingredients not attached.
Monday. Yes, list on Monday. In the fresh, ಒಂದ್ಸರಿನೂ ಬಂದಿಲ್ಲ ಅಲ್ಲ? Fresh matters list on Monday. Yes, next.
33.
The petitioner, the trial court has wrongly,
Council submission ಏನು?
the trial court has wrongly mentioned the year of the CCM.
Accepting the submission of the council, office objections overruled, list the matter.
My lord,
Can
once
can it wait till Monday?
My lord, the warrant is issued against the.
Tomorrow
serious
in the fresh matters list, yes. Warrant issue ಆಗಿದೆ, ಏನಕ್ಕೆ ಕೊಡಿ?
And the offense is only a 500, my lord, and complaint is a practicing advocate.
1 minute, sir. Where is the warrant? I will post it on Monday. List on Monday in the fresh matters list till such time any warrant of any kind hanging on the head of the petitioner shall remain stayed. Yes, next.
Grateful.
34.
Compromises. Compromise, please. Pass over ಮಾಡಲಾ? 230. 230, please pass.
5.
In this matter. This is a council submission with regard to the office objections.
Ah.
The matter is pertaining to the illegality in the recruitment process by KMF.
Ah.
I would have written exam in Belgavi, Vijaypura as well as in Kolar. The office objection is with regard to why is it that you have not gone before Kalburgi when you have written an exam? My council submission is since I have written an exam even in Kolar. So I have invoked the jurisdiction of this court anta heli.
Office objections stand overruled, accepting the submission of the council to the petitioner.
My instruction with regard to PF is we have paid and I will verify if it's not paid, I will pay the
The
necessary.
learned council further submits that needful would be done in the course of the day. In the event needful is done, list the matter on.
4th, 5th, any convenient date. Manoj.
List the matter on 4th July.
Much obliged.
Yes.
36.
Yesterday, Lordship asked this matter to be listed in fresh matters, but somehow it has come in the orders.
ಮತ್ತೆ maintainability. ಏನು office objections ಏನು sir?
It's about, the petitioner is not the accused in the case, he is the bank manager, my lord. The case.
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ.
Case
Office
is-
objections ಏನು sir?
Office,
Offense ಏನು arrest warrant ಇದೆ?
there is a warrant issue.
Where is the warrant?
Lordship may kindly at the page, annexure M, page 58.
What is this government? ಎಲ್ಲ bank chairman, managing director, if loan documents are not found. This has become rampant.
Here, one policy is required to be formulated, my lord, because all these banking frauds, what happens is, my lord, the IO will not get full information. He will submit half information. Based on that, my lord, the magistrate's court passes the order. What happens, my lord, when by the time the IO collects the information and submit it to the court, the money will not be there in the account. Based on that information, my lord, the magistrate's court will issue the.
Office objections overruled. List tomorrow in the fresh matters list.
Oblige.
ಚಾರ್ಜ್ ಶೀಟ್ ಒಂದು 7 ವಾಲ್ಯೂಮ್ ಇದೆ, ಅದು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ರಿಪಿಟೇಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನೋಡು, ಐ ಆಮ್ ದಿಸ್ ಪಿಟಿಷನ್.
ಯು ಆರ್ ಬರ್ಡನಿಂಗ್ ಮೀ ದೆನ್.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಕೊಡ್ತಾ ಇಲ್ಲ, ಅದೇನೋ ಕೊಡೋದಿಲ್ಲ ನಾನು. ಐ ವಿಲ್ ನಾಟ್ ಐ ಸೀಕ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್.
ಲೋಕಾಯುಕ್ತನ
ಲೋಕಾಯುಕ್ತ ಟುಮಾರೋ ಮೆಲಾಡ್ ಇಸ್ ದ ಕೇಸ್ ಲಿಸ್ಟೆಡ್ ಫಾರ್ ಎವಿಡೆನ್ಸ್.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಅಲ್ಲ, ಅದು ಡಿಸ್ಚಾರ್ಜ್ ಕೇಳಿದ್ವಿ, ಅವ್ರ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿಲ್ಲ.
ಯಾವಾಗಿದೆ ಡಿಸ್ಚಾರ್ಜ್? ಯಾವತ್ತಾಗಿದೆ ಆರ್ಡರ್? 31 ಸರ್.
ಇದರಲ್ಲಿ 13 ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ಸ್ ಚೇಂಜ್. ACB ಇಂದ ಲೋಕಾಯುಕ್ತಕ್ಕೆ ಬರ್ತಾರೆ. Section 17, which is not the officer specific order. Except the first order authorizing ACB Inspector DSP to investigate.
ಅಷ್ಟೊಂದು ವೆಲ್ ತಮಾಸ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ, ಇದು around 87% ಹಿಂಗೆ.
100 ಇಲ್ಲ.
Not those 13 orders are not there. That is not the legal ground. Secondly, the lordship will find 119, not page 119.
Not in this stage, I'll hear. What is the ನಾಳೆ ಏನಿದೆ?
ನಾಳೆಗೆ ಎವಿಡೆನ್ಸ್ಗೆ
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸರ್?
ಅಲ್ಲ, ಅದು ಡಿಸ್ಚಾರ್ಜ್
ಯಾವಾಗ ಆಯ್ತು ಹೇಳಿ?
ಜನವರಿ ಆಯ್ತು.
ಡಿಸ್ಚಾರ್ಜ್ ಆರ್ಡರ್ ಆಗಿ 5 ವರ್ಷ ಆಗಿರುತ್ತೆ.
ಇಲ್ಲ, ಜನವರಿ 24, ಫೆಬ್ರವರಿ 23rd February 2024.
Then till now ಏನ್ ಮಾಡ್ತೀವಿ? We are in June.
ಮಧ್ಯೆ ವೆಕೇಶನ್ ಬಂತು, ಹಂಗಾಗಿ. Tomorrow is the
ನಾಳೆ fresh matters. Yes.
please.
Place tomorrow in the fresh matters list. An objection in office objection?
Yeah, the old volume charge sheet ಹಾಕಿಲ್ಲ ಅಂತ. That for the present you will ask me dispense with, I am not going.
The office objections square production of the entire charge sheet material for the present stands dispensed with list tomorrow in the fresh matters.
Please.
Admission 38.
Lottery prohibition of Malashi. Last date of hearing, measure of the order is passed in Malashi.
ಏನಿದು?
Lottery. Kerala state lottery.
Yes sir. Enter ಮಾಡಿದ್ಯಾ?
ಹೌದು ಸ್ವಾಮಿ. Last date already partly argument ಆಗಿದೆ.
Your accused number?
7 to 9, 11 to 17, 19 to
Your
20.
ಮೇಲೆ ಏನಿದೆ sir?
ಏನಿಲ್ಲ.
The petitioners are before this court. Petitioners accused 7, 8, 9, 11. ಅಯ್ಯೋ, ಎಲ್ಲರೂ ಇದ್ದಾರೆ?
ಎಲ್ಲರೂ ಇದೆ sir.
ನೀವ್ ಯಾರಿಲ್ಲ? So and so
ಸ್ವಾಮಿ,
accused
8, 9.
Madam, cost title accused number ಇದೆ, ಆಮೇಲೆ ಹಾಕೊಳ್ಳಿ. The petitioners are accused so and so are calling in question the proceedings in CC 1018 of 2017 registered for offences punishable under prayer ಇದೆ madam, ಇಲ್ಲ ಅಂದ್ರೆ charge sheet ಅಲ್ಲಿ so and so heard so and so. The first respondent on 7/10/2016 appears to be in receipt of certain information that accused number 1 is running a shop in the name of Mahanadi Group in the cellar of one complex in the town municipality and is operating Kerala State Lottery illegally and sending messages through his mobile phone seeking deposit of money from general public. The police is said to have inspected the premises and along with the team. And when accused number 1 was questioned, accused number 1 was questioned, name of accused number 2 crops up and the second respondent then, and the police then apprehend accused number 1 and 2, and with the help of the said accused 3, 4 and 5 are also brought into the web of crime. These where did you spring, sir? Thereafter, after the arrest of accused number 1 in crime number 219 of 2016, during the course of the investigation, drag all these petitioners into the web of crime on the score that they were knowing the they were playing the lottery despite it being banned in the state of Karnataka, and they are participants in the lottery network of the accused number 1, 2, 3, or others. It is therefore, it leads to registration of the crime against these petitioners for the aforesaid offences and sections 353, 506 of the IPC. The police, after investigation, file a charge sheet against all the accused. Filing of the charge sheet has driven these petitioners to this court in the subject petition. The learned counsel appearing for this court in terms of its order dated so and so has, Madam Natarajan Sahib in the order, 15/12/2022 has granted an interim order of stay of further proceedings qua these petitioners, finding that the allegation was only against accused number 1. They said interim protection is in subsistence even today. The learned counsel learned counsel appearing for the petitioner submits that there is not even an iota of evidence against these petitioners that they are the perpetrators of illegality qua the selling of lottery. No doubt the messages were sent to the members of these petitioners also. They are only the participants who were lured by the other accused into these proceedings. He would submit that none of the offences get attracted to these petitioners. The learned HCGP would though refute the submission to contend that the charge sheet is filed and certain amount is transferred to the account of the petitioners, to account of few of the petitioners. It is for them to come out clean in the trial. I have given my anxious so and so, so and so. The afore narrated facts are not in dispute. What led these petitioners into the web of crime is what is narrated herein above. The issue now springs from the issues has sprang from the complaint. Therefore, I deem it appropriate to notice the complaint, page 12 and 13 marked portion. The police, after investigation, file a charge sheet against all the accused, including these petitioners. The summary of the charge sheet as obtaining in column number 17 reads as follows, Madam, page 31 marked portion. A perusal at the complaint or the summary of the charge sheet would not indicate any, even a titter of material, TITTER, titter of material against these petitioners accused 7 to 9, 11 to 17, 19 to 26. All the allegations are goaded against accused number 1 to 6, who are to answer the perpetration of illegality by selling of the lottery of the state of Kerala that was banned in the state of Karnataka. The finding no allegations against these petitioners either in the complaint or in the charge sheet, as the learned HCGP is unable to point out any instance even in the statements against these petitioners except the flow of money of a few thousands from account of the petitioner to the account of the petitioner. They can at best be said to be participants in a lottery and not perpetrators of illegality, as is eligible against accused number 1 to 6. Finding no ingredient of any of the offences so alleged, permitting further proceedings against these petitioners would become an abuse of the process of the law and result in miscarriage of justice. Therefore, for the aforesaid reasons, the following order allowed quashed qua these petitioners accused so and so and Thakpudi, Madam.
For the petitioners in this case, my lords.
I appear for
The
respondent, but
offences
took,
are
my lords.
four
My lord,
part-
seniors on his legs, my lords. Kindly pass over the matter.
447.
447 and 427.
Yaar possession lidare.
We are in possession of the property, my lords. As on the date of registration of the complaint, my lords, there are civil disputes are pending between the parties, my lords. As on the date of registration of the complaint, my lords, there is a injunction order in favor of the petitioners granted by the city civil court, my lords. Your lordship may kindly come to.
Really?
The documents are produced, my lords.
Tell the story, sir.
There is an injunction order in favor of the petitioners, my lords. And as on the date of registration of the complaint, my lords, the petitioners also have lodged a complaint before the same police station by mentioning the injunction order granted in favor of the petitioner, my lords. For that, my lords, the jurisdictional police have filed a NCR and they have filed a FIR to the complaint lodged by the respondent number 2 before the police. This is in respect of, my lords,
ಆಯ್ತು ಬರ್ಲಿ ಅವ್ರು. Yes, sir.
Injection
You are
order.
ready?
Injection order in favor of the complainant in MFA number 2433 of
ಅದು
2018.
ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್.
ಹಾ.
ಇಂಜೆಕ್ಷನ್ ಇವ್ರು ಕೊಡ್ಲಿಲ್ಲ, ಆಮೇಲೆ ಅವ್ರು ತಗೊಂಡಿದ್ರು.
And also, my lords, this is already, my lords, this matter has been disposed of by the Supreme Court regarding the acquisition proceedings, my lords. After that, my lords, the sale deeds have been executed by the original owners in favor of the petitioners, my lords. The respondent number 2 also filed
ಆಯ್ತು.
civil suit for declaration and injunction before the
22 ಲಿಸ್ಟ್ ಆನ್ 25th at the request of the learned counsel.
25th ಬೇಡ,
Not
July
kind-
first week ಅಲ್ಲಿ.
List on 2nd July.
Much obliged.
Interim order subsisting shall continue.
40,
Lordship, this is a case of false promise of marriage, Lordship. It's covered by Lordship judgment.
False promise of marriage. Yes, sir.
Consensual.
ಎಷ್ಟು ವರ್ಷ?
5 years.
Kindly pass on, senior will come.
ಪಾಸ್ ಓವರ್ ಎಷ್ಟು ಪಾಸ್ ಓವರ್ ಕೇಳ್ತೀರಾ?
2 minutes.
ಯಾರು ಸೀನಿಯರ್ ನಿಮ್?
Poonam Patel.
Huh?
Poonam Patel. Respond number 2.
ವೇರ್ ಇಸ್ ಗೇಟರ್?
Lordship, the 164 statement is at page number 37.
Page?
37, Your Lordship.
$37. ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದು ಮದುವೆ ನಂಬಿಸಿ ಆಸೆ ಹುಟ್ಟಿಸಿ 2011 ಇಂದ 17 ವರೆಗೆ.
ಹೌದು.
ಈಗ ಯು ಆರ್ ಮ್ಯಾರಿಡ್.
Married.
ಯಾರು ಮದುವೆ ಆದ್ರೆ? ಯು ಆರ್
Married
ಮ್ಯಾರಿಡ್.
and- married and he also has got a child now.
ಹೌದಾ?
In second attempt,
ಸೆಕೆಂಡ್ ಅಟೆಂಪ್ಟಾ?
petitioner is married in the second attempt.
ಸೆಕೆಂಡ್?
Second attempt. First attempt is
ಮ್ಯಾರಿಡ್ ಸೆಕೆಂಡ್ ಅಟೆಂಪ್ಟ್. ವಾಟ್ ಡು ಯು ಮೀನ್
first
ಅಟೆಂಪ್ಟ್?
ಮದುವೆ ಆಗಕ್ಕೆ ಟ್ರೈ ಮಾಡಿ ಅದು ಕ್ಯಾನ್ಸಲ್ ಆಗುತ್ತೆ, ಮತ್ತೆ ಸೆಕೆಂಡ್ ಅಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ಮದುವೆ ಆಗಿದೆ. Kindly pass on.
ಇದ್ರಲ್ಲೂ ಅಟೆಂಪ್ಟ್ ಆಗುತ್ತೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
They filed a suit, injunction, they filed a suit for injunction.
ಹಾ.
Not
for
directing
you
not
not
to
to get married.
ಹೌದು, ಹೌದು.
Injunction is granted.
ಇಲ್ಲ.
ಅಲ್ಲ ಟ್ರಯಲ್ ಕೊಟ್ಟು ಒಂದ್ಸರಿ ಅದು ಕೊಟ್ಬಿಟ್ಟಿರ್ತಾರೆ. ಗೆಟ್ ಅಲ್ಲಿ ಬಿ ಹಿಯರಿಂಗ್ ಹಿಮ್ ಗೆಟ್ ಮೇಡಮ್. ಎಸ್.
Lordship, the 164 statement says that the parents did not agree ultimately because she being elder. And
ಎಲ್ಡರ?
she is 3 years elder to him actually.
ಸೊ ವಾಟ್?
ಅಲ್ಲ,
ಅದಕ್ಕೆ
that's
ಮದುವೆ
what,
ಆಗಿಲ್ಲ
that's what the parents did not agree. In the inner 164 statement, she has stated that. At last 4 lines, Your Worship. ಈ ಬಗ್ಗೆ ನಮ್ಮ ಮನೆಯ ಹಿರಿಯರು ಹಾಗೂ ಆರೋಪಿ ಮನೆಯವರು ಕೂಡ ಬೀದರ್ನಲ್ಲಿರುವ ಆರೋಪಿಯವರ ಚಿಕ್ಕಮ್ಮನ ಮನೆಯಲ್ಲಿ ನಮ್ಮ ಮದುವೆ ಮಾತುಕತೆ ಆಡಲು ಹೋಗಿದ್ದಾಗ ಆರೋಪಿಯ ತಂದೆ ತಾಯಿಗಳು ನೀನು ಸಂತೋಷನಿಗಿಂತ ದೊಡ್ಡವಳಿದ್ದೀಯಾ, ಆದ್ದರಿಂದ ಮದುವೆ ಮಾಡಿಕೊಳ್ಳುವುದಿಲ್ಲವೆಂದು ನಿರಾಕರಿಸುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಆರೋಪಿ ವಿರುದ್ಧ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸಿ ನನಗೆ ನ್ಯಾಯ ಕೊಡಿಸಿಕೊಡ್ಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ ಪ್ರಾರ್ಥಿಸಿಕೊಳ್ಳುತ್ತೇನೆ.
ಎಲ್ಲಿ ಓದಿದ್ರಿ ಈಗ?
Lordship.
ಏನ್ ಓದಿದೀಗ ನೀವು?
No, 164 statement at last 4 lines, Your Lordship.
ಆಯ್ತಾಯ್ತು ಅಂದ್ರೆ ಡಿಸ್ಚಾರ್ಜ್ ರಿಜೆಕ್ಟೆಡ್.
Reject.
ಆಬ್ವಿಯಸ್. ಈ ಕೇಸಲ್ಲೂ ಡಿಸ್ಚಾರ್ಜ್ ಕೊಟ್ಟಿಲ್ಲ ನೀವು. ಎಸ್ ಮೇಡಮ್. ನೋ ಟೈಮ್.
Apologies, Lords.
ಎಸ್. ಇದ್ರಲ್ಲಿ ಏನ್ ಟೈಮ್ ಕೊಡುವಂತದ್ದು ಇಲ್ವೇ ಇಲ್ಲ.
Yes. That's limited submission, Lords. This is, according to Lords, not one of those cases which as per the submission gets covered. Because Lords, here, all along it has been a misconception of fact.
Yes.
Lords, it's admitted, Lords, that they were in a relation.
You want rest?
No, Lords.
I'll be hearing him.
Yes.
You sit down.
Yes.
Yes, sir.
Lordship.
ಮತ್ತೆ ಅದನ್ನೇ ರೀಪ್ಲೇ ಮಾಡಿ. Yes.
FIR is at page number 16, Lordship. The narration is that from 2013 they were in they were of same place and they were residing together along with their brother. And they were in a relationship, and in 2017 she underwent an abortion, and in 2018 she lodged a complaint that he has not kept his promise of marriage. That is the facts of the entire facts of the case.
Yes.
And effort were made, but parents ultimately did not agree because of
Yes, ma'am.
Yes, but it's made to look as if it's been a consensual relationship from beginning, physically. Not so, my lords, because right from the beginning, the petition had an intention of, it's not a case of breach of promise, my lords, at the outset. He, my lords, right from the beginning said, because they come from a small town, both together came from a village from Bidar district. They came right from the beginning, the consensus was given only on the condition that he would marry her. That relation is continued for 5 long years from 2013 to 17 admitted. That's, I cannot, that's on record.
Yes, yes.
But the incident, my lords, which has led to the complaint is that the abortion, my lords, which happens. He, my lords, says that if you about this thing, I will marry you. That, according to me, my lords, is the factor which has to be taken into consideration by this honorable court, which, according to my lords, continues the misconception of fact which I'm asserting was there right from the beginning. It's not that it happened only in 2018. This cannot be disconnected from the relationship which started in 2013. That's the limited submission notes I have, because everything else is in your lordships. But I would, because now what happens, my lords? He is married. She remains unmarried, aborts the child at his insistence that post that he will marry her. She's not led to bear the child also. And he is married and settled, my lords. She still, in fact, she is now left, I'm told that she's left Bangalore and job and gone back to her village, where again, my lords, to live as a single lady with all this incidents. And this came to fore, the villages, when the incident of abortion happened. Till then, my lords, nothing was. Therefore, my lords, this is a case for trial. There's enough material to show, my lords, that it's not one of those cases, which is largely in these cases made to look like a consensual
No,
relationship.
not met, go to the 164 statement.
Yes, my lords, I have seen those statements. It's everything, statements in record.
How can you expect conviction in this case? For your satisfaction, trial should be permitted. Otherwise, how can you expect conviction in this case?
That's what I'm saying.
See the
This is
latest judgment.
Please, no?
See the latest judgment.
Yeah, I have seen lots of judgment lots there. In
No,
fact,
no,
it's-
Supreme Court has confirmed my order.
Yes.
In little more detail, it is written.
Yes, yes, lots.
Miss X versus Mr. A.
Yes. Well, that's why there's a thin line of difference that we could draw. So what is my submission lots? This is not those facts which fall into those.
No, in fact, under BNS, it is a crime. False promise of marriage, if it's a crime. But we are under IPC still.
According to me, lots, justice has to be given to this lady because she's. In fact, I had a chat with her also yesterday at this stage of life when he settled married.
Very difficult, man. 417 idea.
420.
420
idea.
420 is.
Adhan sustain ಮಾಡ್ಬೋದು.
Your Lordship, yes, already 5 years and the ingredients for of cheating, they say that the marriage talks were held and fathers did not agree, parents did not.
Anyway, you've cheated, ಅದರಲ್ಲೇನು doubt ಇಲ್ಲ.
Your Lordship, he is married and having a child.
So?
Ingredient of cheating, that false promise, the complaint doesn't make out a ingredients of cheating.
Hmm.
420, 376.
That 5 years they are in relationship and.
That is 376, guys.
Lordship, that on a false promise.
376 ಆಯ್ತು.
FIR and 164, both doesn't make out 417.
There are 376, 420 and 313 minutes.
313 is abortion. ಅದು ಇವ್ರೇನ್ ಮಾಡಿಲ್ಲ, ನೀವಾಗ ಮಾಡ್ಕೊಂಡು.
No,
As a force, see, that is 313 comes with forceful abortion.
That is what is my case, Milots.
Where?
What I've stated, Milots.
Forceful abortion by use of force.
What I'm trying to say here, Milots, that
313.
what was also.
Ingredients are in 312.
Because what happens is we could probably dissect it in two set of incidents. One, what he says is 2013 to 17. Yes, even if I go a step ahead, we could accept that. But what happens the subsequent event when she was pregnant? He says, if you abort this, I will marry you definitely.
See, 3112 is what causing miscarriages. 313 is punishable for that. Whoever voluntarily causes miscarriage, so and so and so.
Numbers from
Be caused in good faith for the purpose of so and so. Like good faith irade illa, but
because from 2013 she was led to believe, Milots. This is what I say. But that there was a misconception of fact that you would end up the relationship in a legal sanctity and get married. That also, my lords, gets coupled with another incident in 2017 by abortion.
That's custom.
As your lordship suggested, at least that's 420 sustained, my lords, if that were to be the, because it's
Even
very
that, it
apparent.
is, see, 420, dishonest intention right from the beginning.
Yes.
If there was no effort from his side or the parent's side to get married, get you both married, which failed later, then 420,
No
100%.
effort, no, my lords, that's false. That's a factually false statement. There was no
164,
effort.
not your statement, not his statement. Come to 164, our
I have
victim
said
statement
parents-
only.
The parents and brother's statements.
3 years older to the boy, so they said,
No,
you
they
know,
say after this incident of abortion, when our
whatever it is, the efforts were made to get married. If no effort is made and he walks away, then 420 attracts.
its effort was one-sided. I mean, it's not that, whatever, it's not like both parents sat and like what your lordship judgment, which came up about 2 weeks back. There, my lords, in fact,
Lordship,
both
even-
sides marriage was, talks were held and wife had certain financial.
No, that
things.
is engagement.
Yes, they were engaged and to
Their
be married.
betrothal ceremony had taken
Yes,
place.
and they were to married and then it breaks. This is not a case where the efforts were made by both the parties. This is what. And efforts were made so much more so because after the abortion, not when they were in relation between 13 to 17. That's another fact. Because that is an incident.
Yeah,
which
I'm
will be-
bound by what I have written and what the Supreme Court has.
But I am only impressing upon the court that a distinction could be made because of the.
No, when BNS comes, we'll see. Because their distinction is permissible. Definitely permissible.
I'll wait.
No, I can't put this in BNS.
The prospect.
This is under IPC only. Yes. The petitioner is before this court calling in question proceedings in SC 1993 of 2018, registered for offences punishable under section 376, 420 and 313 of the IPC. Facts in brief, heard so and so. Facts in brief germane are as follows. The petitioner is the sole accused, the second respondent, the complainant. The petitioner and the complainant are said to have had a relationship right from 2011 through 2017.
13.
13,
13.
11 and
13 to 17.
13.
2013 to 2017. When
2011 in a 164 statement.
ಅದನ್ನೇ ಹೇಳಿದ್ ನನ್ನ ಮತ್ತೆ 13 ಅಂತ ಹೇಳಿದ್ದು.
ಅವ್ರದ್ದಿಲ್ಲ, ಅವ್ರದ್ದು.
2011, your statement from 2011 through 2011 through 2017, and they were staying under the same roof. Therefore, the complainant herself narrates that it was a live-in relationship for close to 6 years. A complaint comes to be registered by the second respondent on 9/3/2018, alleging that the petitioner has had sexual relationship with the complainant has, petitioner has had sexual relationship with the complainant on the promise of marriage, which from the inception was false. He had no intention to get married, and therefore the complaint is registered for offences punishable under section 376, 420. The complaint further narrates that on the instructions of the petitioner, the complainant undertook abortion, and therefore section 313 for the offense of miscarriage of offense of voluntarily causing miscarriage is laid against the petitioner. The concerned court takes cognizance of the offense committal 3-2
Committed.
The matter is committed to the Court of Session on 3/2/2022. Allah, adalla, reject matter. Yes.
Discharge is rejected.
So the petitioner files an application seeking his discharge from the proceedings, invoking section 227 of the CRPC in SC 1993 of 2018. That having been rejected has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that the relationship between the two, both physical and otherwise, was consensual, as they were living in the same house, and therefore it was a live-in relationship for 6 years. The talks of marriage between the two also did take place, and the parents of the petitioner did not agree as the complainant was 3 years older to the petitioner. This is what is borne in the statement is what the learned counsel would submit and seeks to place reliance upon plethora of judgments rendered by this court or by the apex court or this court as the case would be, seeking quashment of the proceedings. The learned counsel, Srimati Poonam Patil, representing the complainant, would make a vehement effort to refute the submissions, contending that they were living under the same roof, but the entire period in which they were living under the same roof was on the pretext that he would get married to the complainant. Therefore, it was the physical relationship that the petitioner had throughout the 6 years was on account of the promise of marriage, which from the inception was false. No effort was made to get married, and above all, it was the petitioner who directed the complainant to get the child aborted. Only then he could get married. The learned counsel would submit that this is not a case of breach of promise of marriage, but would fall under the category false promise of marriage, and therefore it is a matter of trial for the petitioner to come out clean. The learned HCGP would toe the lines of the complainant in contending that the charge sheet is filed and the matter is pending before the court of session. It should be permitted to be taken to its logical conclusion, as it is for the petitioner to come out clean in the trial. I have given my so-and-so. The afore-narrated facts are not in dispute. The relationship between the two is a matter of record. The relationship floundering results in a complaint being registered for the aforesaid offences. Since the issue springs from the complaint, I deem it appropriate to notice the complaint, page 16 to 17. The complainant herself narrates that they were in the same house as a live-in couple for about 4 years, from 2013 to 2016, and they were in love. The breach of they were in love, and it is the case of the complainant that the petitioner has had physical escapades with the complainant, all on account of promise of marriage, which he has eventually breached. Therefore, it is eventually breached. Therefore, the complaint alleges that it was a false promise of marriage. The police, after investigation, filed a charge sheet. The summary of the charge sheet as obtaining in column number 7 reads as follows, page 13, 14. Madam, Kavya, ಈ ಕಡೆ ಎಲ್ಲ column 6 ಮುಂದುವರೆದಿದೆ ಎಲ್ಲ ಟೈಪ್ ಮಾಡಿಬಿಡಿ, 7 ಮಾತ್ರ ಇಲ್ಲ. A perusal at the summary of the charge sheet or the complaint, as the case would be, is indicative of the fact that the petitioner and the complainant were in live-in relationship for about 6 years. The 6 years would come not from the complaint or from the summary of the charge sheet, but from the statement of the complainant herself. The complainant tenders her statement under section 164 before the concerned court on 15/3/2018. The statement is germane to be noticed. It reads as follows, page 37, 38. It is the case of the complainant in her statement that the petitioner and the complainant knew each other since 2011, and the friendship had flowered into a relationship from 2013 to 2017, as they were living in the same house as a live-in couple. Therefore, the statement of the complainant, if the statement of the complainant and the summary of the charge sheet are read in juxtaposition to each other, what would unmistakably emerge is that all that has happened between the petitioner and the complainant were all acts on consensus. The learned counsel for the respondent, as observed herein above, makes a Herculean effort to bring the issue on the issue of false promise of marriage only on the score that the petitioner, the complainant got the child aborted only on the direction of the complainant, of the petitioner. And therefore, it should come within the ambit of false promise of marriage. The said submission is noted, but only to be rejected, as as the issue noted only to be rejected, as all these acts come within the same umbrella of the consensual acts between the petitioner and the respondent. Therefore, the offense under section 376 or the fact of abortion under section 313 as is alleged are loosely laid against the petitioner, which could not have been. Permitting further proceedings to move on the offenses under section 376 and 313 would run foul of the judgment of the apex court in the case of Naeem Ahmad versus State of so and so, reported in 2023 SCC Online SC, page 89, where the apex court, considering identical facts where the prosecutrix before the apex court had also become pregnant and the abortion had taken place on the direction of the accused therein. The apex court holds that would not be enough circumstance to haul the accused for an offense under section 376 of the IPC. The apex court further considers whether it amounts to cheating or otherwise. The issue would be that for all the 6 years, both the petitioner and the respondent are petitioner and the complainant have indulged in acts which are consensual. Neither have lured the other. Therefore, if the acts are of consensus between the two, the breach of a promise of marriage would not become an offense under section 420 of the IPC, as the ingredients under section 415 is hardly met. Section 415 mandates that the intention of cheating by the accused upon the victim should be present from the inception. The inception in the case at hand is consensus. If the inception is consensus, it cannot lead to cheating. More so in the light of the fact that all efforts were made by the accused to get the victim in marriage, but the parents of the accused have denied marriage on the ground that the victim was 3 years older than the accused. Therefore, the case cannot be brought under the quote unquote false promise of marriage. It at best is a breach of promise of marriage. None of the submissions that the learned counsel for the second respondent complainant seeks to contend are acceptable in the light of the fact of the issue standing answered by the apex court in the aforesaid judgment. Allowed quashed.
One submission, Lords.
Yes, ma'am.
If accused petitioner never made an effort to get married, Lords, if your Lordship just observe.
Statement 164 statement ಅಲ್ಲಿ ನಿಮ್ದೇ ಇದೆ.
Their
Parents ಹೋಗಿ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ರು. They have denied ಅಂತ.
petitioner does not make an effort is what is fine, sir. Your Lordships observe that.
Anyway, yes. That's why I've quoted the statement also. Because these matters, innocuous matters, go to the Supreme Court.
Grateful.
PG. Naeem Ahmad.
This is the case of-
ಮೊನ್ನೆ ಮಾಡಿದ್ದೀನಿ. ಇವ್ರು ಕೇಳಿ. ಮೊನ್ನೆ ಒಂದು ರಿಲೀಸ್ ಮಾಡಿದ್ದೀನಿ ನಾವು. ಯಾವುದು ಒನ್ ನೈಟ್ ಎಂಗೇಜ್ಮೆಂಟ್
This is the case of KPS examination, my lords, the paper leakage. KPS examination
Yes,
paper
sir.
leakage case. My lords, kindly peruse page number 87, my lords, ink page number 87. My lords, with respect to the petitioners, they are been arrayed as accused number 17 and 18 in CC number 8033.
You are
In
the
entire-
beneficiaries.
My lords,
You are the beneficiaries.
yeah, I am the candidate of the KPS
No,
examination.
no, you are the candidate who has impersonated. ಅದೇ ಅಲ್ವಾ ಇದು? Yes, government.
Next week,
Why?
additional SPP appearing.
ಹೇಳಿ.
My lords, kindly peruse page number 87, my lords.
What is the allegation against you, sir?
My lords, the only allegations against me is with respect to page number 52. Para number 3, my lords.
ಅದೇ 16 to 19 ರವರುಗಳು
Yes, my lords.
ಸಂಪರ್ಕಿಸಿ ಅವರುಗಳು ಹೆಚ್ಚಿನ ಹಣಕ್ಕಾಗಿ ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆ ಮತ್ತು ಉತ್ತರವನ್ನು ಮಾರಾಟ ಮಾಡಲು ಆರೋಪಿ ಇಪ್ಪತ್ತರ ತೋಟದ ಮನೆಯಲ್ಲಿ ಪರೀಕ್ಷೆ ಹಿಂದಿನ ದಿನ ಗುಪ್ತವಾಗಿ ಒಪ್ಪಿಕೊಂಡು
ಅಕ್ರಮ
ಇರುತ್ತಾರೆ. ಅಲ್ಲದೆ 21 ನೀಡಿದ ಪೆನ್ ಡ್ರೈವ್ ಬಿಬಿಎಂಪಿ ಕಸದ ತೊಟ್ಟಿಯಲ್ಲಿ ಬಿಸಾಡಿ ಸಾಕ್ಷ್ಯ ನಾಶಪಡಿಸಿರುತ್ತಾರೆ.
only, this is the only allegation against me, my lords.
Enough, sir.
And also, accused
Enough.
number,
These people
my
should not
lords,
be
with
spared.
respect to this, ಯಾವುದು ಒಂದು ಪೇಪರು ಸಹ ಅಲ್ಲಿ
ಪರವಾಗಿಲ್ಲ. ಅದೆಲ್ಲ
there is no amount which has been recovered from me.
It is in the charge sheet, sir.
Yes, my lords, but I have been arrested on the date of 24, my lords. ಅದು ನೆಕ್ಸ್ಟ್ ಡೇ ನಂದು 24 ಗೆ ನಾನು ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
No, these
23 ಅಲ್ಲಿ ನನಗೆ ಈ ತರ allegations
see such people perforate the fabric of education in the country.
My lords, I am just a candidate, my lords. I am with the
Allegation
accused
is
number
not that,
15
sir.
accused number 15 is the SDA, my lords, in the KPS exam, sorry, KPS
problem.
department. My lords, he hails from the same village. Again, the accused number 17 and 18 also hails from the same village. On 24, that too in the evening, my lords, around 10 p.m.
Your accused number
17 and 18.
17 and 18.
I'm from the same village.
So what?
Accused number 15 ಮೇಲೆ allegations ಇದೆ.
ಪರವಾಗಿಲ್ಲ.
Accused number 17 ಮತ್ತೆ 18 ಅದೇ ವಿಲೇಜ್ ಅಲ್ಲೇ ಇರೋದು. ನನ್ನ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಅದು ಏನೋ ನಮ್ಮನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿರೋದು ದಟ್ ಇಸ್ ಆನ್ 24th, my
No
lords.
problems.
The allegation which they are raising is with respect to on the 23rd of January. ಅದು ಹಿಂದಿನ ದಿವಸ ನಾವು ಇದನ್ನೆಲ್ಲ ಕೃತ್ಯ ನಡೆಸಿದ್ವಿ ಅಂತ ಅನ್ನೋದನ್ನ ಬಿಟ್ರೆ
ಈಗ
ನಮ್ಮ ಮೇಲೆ
ಏನಾಗಿದೆ?
ಯಾವ್ದು prima facie
Entry model
material
ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ, my lords.
There is no entry model. What is the stage now?
Admissions, my lords.
Huh?
Admission ಅಂತ ಇದೆ.
No entry. ನನ್ ಇಲ್ಲ sir. What is the stage?
ಅಲ್ಲಿ HBC
ಇಲ್ಲಿ ಏನ್ ಸ್ಟೇಜ್ ನನಗ್ ಗೊತ್ತು.
ಅಲ್ಲಿ HBC ಇದೆ, my lords.
ಅದನ್ನ ಕೇಳಿದ್ದು.
ಆ.
ಇಲ್ಲಿ ಏನ್ ಸ್ಟೇಜ್ ಅಂದ್ರೆ ಅಡ್ಮಿಷನ್ ಗೊತ್ತು. ಅಡ್ಮಿಷನ್
ಅಲ್ಲ,
ಲಿಸ್ಟ್
ಅಲ್ಲಿ
ಆಗಿದೆ.
hearing for charge ಇದೆ.
ಹಾ. Yes, sir.
Apart from this, my lords, apart from these bad allegations or the bad statements, there is not even a single material to prove that ಇದಕ್ಕೋಸ್ಕರ ನಾನು ಈ ತರ ಕೃತ್ಯ ಮಾಡಿದ್ದೆ.
ರಿಜೆಕ್ಟ್ ಆಗಿದ್ಯಾ?
My lords,
ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕಿದ್ರಾ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ, my lords.
ಅದು ಹಾಕೊಳ್ಳಿ, ಇಲ್ಲಾಂದ್ರೆ ಆನ್ಸರ್ ಮಾಡ್ತೀನಿ ಈಗಲೇ. I will answer. What is your role?
My lords,
Destroy
apart
the
from
fabric
this,
of education.
apart from this, my lords, I am just a candidate, my lords. I am from the same village where the accused number 15 is residing. ಅವನು ಅಲ್ಲಿಗೆ ಬಂದಿದಾಗ ನಾವು ಅವ್ರ ಜೊತೆ ರಾತ್ರಿಯಲ್ಲಿ ಇದ್ವಿ ಅಂತ ಅನ್ನೋದು ಕಾರಣ
ಸಂಪರ್ಕಿಸಿ ಅವರುಗಳಿಗೆ ಹೆಚ್ಚಿನ ಹಣಕ್ಕೆ ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆ ಮತ್ತು ಉತ್ತರವನ್ನು ಮಾರಾಟ ಮಾಡಲು ಆರೋಪಿ 20 ತೋಟದ ಮನೆಯಲ್ಲಿ ಪರೀಕ್ಷೆಯನ್ನು ಹಿಂದಿನ ದಿನ ಗುಪ್ತವಾಗಿ ಬರೆದಿದ್ದೀರಾ?
ಆಯ್ತು, my lords, ಅದಕ್ಕೋಸ್ಕರ ನಮ್ ಜೊತೆ ಏನಾದ್ರು ಒಂದು ಮಟೀರಿಯಲ್ ಆದ್ರೂ ಇರ್ಬೇಕಲ್ಲ.
Trials.
There should be some material
I will
so
not-
that
I will not interfere in this.
I had
Not
obtained so
such
and so
people.
material.
Merited students are suffering
I
because of
agree,
all
my
this.
lords, but the thing is, apart from this, there is no any prima facie material coming forth in this charge sheet,
Oh,
my
no.
lords.
I will not.
Even considering, my lords, even in his statement also, page number 56,
What statement?
column number 7, my lords.
I am at column
There-
number 7 only.
Yeah, page number 56.
ಅದೇ
ಅದೇ ರೀತಿ ಆರೋಪಿ 16ರಿಂದ 19ರವರೆಗಳು 15ನೇ ಆರೋಪಿತನೊಂದಿಗೆ ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆ ಪಡೆಯುವ ಸಂಬಂಧ ಮಾತುಕತೆಯನ್ನು ಮಾಡಿ ಅದರಂತೆ 23/1/2021 20ನೇ ಆರೋಪಿತನ ತೋಟದ ಮನೆಯಲ್ಲಿ 15ನೇ ಆರೋಪಿತನು ತಂದಿದ್ದ ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆಯನ್ನು ಪಡೆದು ಸಿದ್ಧತೆಯಲ್ಲಿ ತೊಡಗಿ ಮೋಸದ ಕೃತ್ಯದಲ್ಲಿ ತೊಡಗಿರುತ್ತಾರೆ.
More than
My lords,
more than enough. 120
having to
B
see this
ಇಲ್ವಾ?
also, having to see this also, there should be
120
some material also to show. ಯಾವ್ದಾದ್ರು ಒಂದು ಕ್ವಶನ್ ಪೇಪರ್ ಆದ್ರೂ ಅವರು
Oh, no, sir. ಅದಕ್ಕೆ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ 2 ವರ್ಷದಿಂದ.
My lords,
ಅಯ್ಯೋ 201, 120 B ಎಲ್ಲ ಇದೆ. Loaded.
120B ಇದೆ.
Anything else? In such case, if we interfere,
My lords,
no, sir.
we have to see the materials also which are been
That the
placed
court
by
will see,
the
sir.
police officer.
That the court will see, trial court will see. Anyway, it's at the stage of HBC. That will see, will answer it. Yes, Barkal.
I may be given the liberty to file the discharge application, my lords.
Whatever you want, you file. No, discharge on HBC stage and discharge. The petitioner, after arguing the matter at length, seeks leave of this court to withdraw the petition and avail of such remedy as is available in law. The petition is disposed with such liberty.
Much obliged.
42.
Respondent number 2.
Appear for the petitioner in this matter.
Senior Pakka Court.
498A.
Yes, not 498, my lords, 420, my lords. This is, the dispute is with respect to a sale agreement. There's a specific performance suit also pending.
What happened to the suit?
Suit is still pending, my lords. First, they'll file a suit for specific performance
The
and
date of the suit?
Suit is of the year 2020, my lords.
Date,
Date,
plaint ಇಲ್ವಾ?
plaint ಇದೆ, my lords.
ಯಾವತ್ತಾಗಿದೆ?
2/12/2020, my lords.
2/12,
2020.
he files SP, is it? You file.
He files a
He
specific
files.
performance.
Hmm.
And thereafter on,
Agreement ಏನದ್?
agreement is of the
ಅಲ್ಲಿ
year
ಯಾವತ್ತು?
29/1/2015. With respect to purchase of a property. The
He did
petitioners
not-
are the
He did not
landowner.
come forward?
He did not come forward is my contention, my lords.
Yes, crime is on 23/3/21.
Yes, my lords.
Why
He files a PCR complaint, my lords.
3/27/3/24?
My lords, those offences are dropped in the charge sheet.
What is the offense retained?
Now, my lords,
Page-
406, 417, 430,
Where's the
5.
charge sheets?
Charge sheet is it?
Yes,
Page number
it's,
25, my lords.
417, 504, 506, 406.
They file a PCR, my lords, which is not supported by the affidavit also.
When do they file, sir? 2021?
Yes, my lords, on 16/3/2021.
No affidavit at all?
No affidavit. I have produced the order sheet also.
ಸೀನಿಯರ್ ಬರ್ತದೆ. FSL ರಿಪೋರ್ಟ್ ಸಹ ಬಂದಿದೆ ಇದು.
ಏನ್ FSL?
ಇದು ಅಗ್ರಿಮೆಂಟ್ ಆಗಿರೋದಕ್ಕೆ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಆಗಿರೋದಕ್ಕೆ
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಹೋಗ್ತಾ ಇದಾರೆ ಅವರೇನೆ.
Sale agreement is not disputed.
ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಿಲ್ಲ, FSL ಗೆ ಯಾಕೆ ಹೋಗ್ಬೇಕು?
ಸೀನಿಯರ್ ಬರ್ತಿದ್ರು ಪಕ್ಕದ ಕೊಟ್ಟಿರ್ತಾರೆ ಪಾಸ್ ಅವರು
ಯಾರು ಸೀನಿಯರ್ ಯಾರು?
ಟಾಮಿಸ್ ಸಬ್
ಹಾ?
ಟಾಮಿಸ್ ಸಬ್
Thomas. Password.
Right.
We'll close this today. Yes.
43.
ಸರಿಲ್ವಾ?
Charge sheet is ready.
Charge sheet
Is ready.
to be filed. There is no stay here. Why have you not filed?
Now it is ready. We'll
Huh?
file. Now it is ready, my lord. Charge sheet is ready.
The learned HCGP on instructions and verification of the records would submit that the charge sheet is ready and would be filed in the course of the next week. There is no representation on behalf of the petitioner. List after 4 weeks. Yes, next.
44.
Government murder.
ಇಲ್ಲ ಅಂತ ತಗೋತೀನಿ.
Application ಕೊಟ್ರಲ್ಲ?
In this
Hang it,
case also,
memo.
my lord, charge sheet is ready. We'll file it.
ಇಲ್ಲೇನ್ ಸ್ಟೇ ಇಲ್ಲ?
ಇಲ್ಲ.
ಸ್ಟೇ ಇರ್ಲಿಲ್ಲ
ಇರ್ಲಿಲ್ಲ.
ಈಗ ಕೊಡ್ಬೋದು.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತಿದಾರಂತ. ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಬಿಡಿ.
ಹಾಕಿಲ್ಲ
ಹಾಕಿಲ್ಲ. ready this. ಆಗ್ತದೆ.
They'll file it anyway. Or you want me to answer, we'll answer it. Because I have asked Somyaji to get some, there is no such document.
It is placed on record along with a memo. Certified copy we have placed on record.
That itself is forged ಅಂತ ಇದೆ.
ಅದನ್ನ
That is the allegation.
There are
is there
13,
certified copy we have produced.
Senior ಹೇಳ್ಬೇಕಾರೆ wait.
there are,
We produced the certified copy.
there are 13 e-Khata fabricated documents, my lord. And
Even
from
PDO
that,
na?
my lord, 7
Panchayat
sites are-
Development Officer.
Correct.
Yes, my lord.
ನಾವಲ್ಲ, ನಾನು am the owner of the property. I'm the owner of the property.
ನೋಡೋಣ ಬರ್ಲಿ ಒಂದು ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತೇನೆ. ರೀಚ್ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ ನೋಡೋಣ. ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿರ್ತೇನೆ.
Next
you
week
can attend-
ಹಾಕಿದ್ರೆ ಒಳ್ಳೆ.
You can attend to your other.
Next week ಹಾಕಿದ್ರೆ ಒಳ್ಳೇದು.
ಸೋಮ್ಯಾಜಿ ಬರ್ಲಿ. Next week ಹಾಕ್ತೇನೆ.
Very well.
No representation on behalf of the respondents. Heard the learned senior counsel, Kumar Rajgopal appearing for the petitioner. No representation on behalf of the respondents. The second respondent, list the matter next week.
ನಾವು ತಗೊಂಡ್ ಬರ್ಬೇಕು.
45.
ಎಂಟ್ರಿ ಮಾಡಿ 2 ವರ್ಷದಿಂದ ಇಲ್ಲ, ಇವಾಗ ಬೇಡ.
Respondent. What's it?
ಇದು ಟ್ಯಾಪಿಂಗ್.
Failed trap, my lord.
Trap is not paid, your lordship. Amount is kept on table,
Who's table?
petitioner's table.
Phenolphthalein not test proves negative.
ಇದು 7A.
Please.
ಎಲ್ಲ ಒಟ್ಟು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಹೆಂಗೂ ಇದೆ.
ಇದೆ.
11th
11th ಗೆ
ಎಲ್ಲ 11th ತಗೊಂತೀನಿ. Place the matter on 11th along with all connected cases not connecting but in seriatim. Interim order if any shall continue till the next date of hearing.
In the meanwhile, Lokayukta may be implemented.
ನಿನ್ನೆ ಲೋಕಾಯುಕ್ತ ಮಾಡಿಲ್ವ ಇದರಲ್ಲಿ?
ಇಲ್ಲ.
ಅದು ಇಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಡಿ.
Permit me right now, my lord.
ಇಲ್ಲದ್ರೆ we will dispose it for the disposal and ask you to file. Implete ಮಾಡಿ.
Please.
Transpose.
Please.
The learned counsel shall implete the Lokayukta as a party respondent in the place of ACB, which is abolished by an order of the division bench. The transposition shall be done forthwith.
Yes.
ಈಗಲೇ ಮಾಡಿ. And I have at least ನೆನ್ನೆ 7 or 8 cases ಎಲ್ಲ 7A and 13(1) ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದು for the reason that you file all objections by then. 11th and 28th ಒಂದು ಹಾಕಿ.
28th carried.
28th and 11th 2 dates.
Please.
Tell baby Patil to be ready.
Please.
Yes, ಅವತ್ ಬಂದ್ ಮತ್ತೆ ಟೈಮ್ ಕೇಳಬೇಡಿ.
Yes. Good.
46.
ತಗೊಳ್ಳಿ amendment.
This case, I am for the petitioner, Milan. The alleged offence is 498A, Milan. 3 and 4 of the DP Act, Milan. The petitioner has a father-in-law and mother-in-law, Milan. The husband is not before this court, Milan. That the marriage is taken place, Milan, on 26/12/2020, Milan. As per the complaint, our remains, Milan, the wife was stayed in the husband house, Milan, only 45 days, Milan. ಅದರಲ್ಲೂ ಬೆಂಗಳೂರು ಮೈಸೂರಿಗೆ ಓಡಾಡಿದೀವಿ ಅಂತ, ಮಂಡ್ಯಕ್ಕೂ ಮೈಸೂರು ಓಡಾಡಿದೀವಿ ಅಂತ. That by reading the entire complaint, there is no allegation against the petitioner. The only ಅವ್ರಿಗೆ ಸ್ಯಾಲ್ರಿ ತರ್ತಾ ಇದ್ರು, ನಮ್ಮ ಮನೆಗೂ ಸ್ಯಾಲ್ರಿ ಕೊಡು ಅಂತ ಕೇಳೋದು ಅಷ್ಟೇ allegation.
Oh, she's in employment, is it?
Employment. And moreover, the initial the husband constituted a notice regarding respondent number 2, on 8/2/2022. The notice was duly served to the complainant. Thereafter, complainant issued a reply notice to the husband. Thereafter, after 2 months delay, this present complaint was lodged by the.
Don't tell all that. Husband will escape if that is said.
Your lordship, this matter, there are 3 accused before the lower court, please.
Huh?
There are 3 accused before the lower court.
Husband, mother-in-law and father-in-law.
2 of them are the petitioners here.
Huh.
But unfortunately, the entire investigation has been stayed. Even though case number
will
1 is
permit-
not.
Husband
party to
ಮೇಲೆ
this.
investigation ಮಾಡ್ತಾ ಇಲ್ವಾ?
ಮಾಡ್ತಾ ಇಲ್ಲ. They've stayed the entire evidence.
Conveniently you do this because only 2 ಅಂತ ಹೇಳಿದ್ರು.
Because of the stay.
ಇದು convenience of the IO.
No, she's been abandoned with the child, please. She's been abandoned with the child to fend for herself. There was a
No,
settlement.
you go against the husband. What mother-in-law and father-in-law will do?
No, there is an allegation of
Where?
that.
Take me to that.
There is an allegation that
Where is that? You take me to a specific allegation.
please. That she was fed, page number 15 of their thing, please.
Fed what?
Fed food to abort the child. They were against the.
Where is that? Show me that.
Yes, please.
One sentence you show me. Come to page 16.
Page
Second
17.
paragraph.
Please. Yes, please.
ಏನಾಗಿಲ್ಲ.
Agila, but she was
in
fed.
contact with her mother. She has not.
Yes,
eaten.
luckily she was in contact with the mother. That is the reason this is
Luckily
happening.
she has said so.
With this matter, please, my lord, see, he's already married. He's already married and settled with somebody else.
ಈಗ ಸದ್ಯಕ್ಕೆ
Divorce ಆಗೋಗಿದೆಯಾ?
ಡಿವೋರ್ಸ್ ಆಗಿಲ್ಲ.
How is he?
Mohammedan. His second marriage.
Okay.
So he's already married. We wanted a settlement. On the last occasion, they said that they will settle it. There was some jewelry that has to be explained, exchanged, and we will settle it. Anta. Then they did not appear for mediation. It was referred for mediation.
ಇಲ್ಲ ಹೋಗಿದ್ವಿ ಸ್ವಾಮಿ. ಬಟ್ ಏನು ಅಂತಂದ್ರೆ ಅವ್ರ ಜ್ಯುವೆಲ್ಲರಿ ಸ್ವಲ್ಪ ಇದೆ, ನಮ್ಮ ಹತ್ರ ಇದೆ. ಅದ ನಮ್ ಕ್ಲೈಂಟ್ ಹತ್ರ ನಾನು ಕೇಳಿದ್ವಿ, ಸ್ವಲ್ಪ ಇದೆ, ಅವ್ರ ಹತ್ರನು ಸ್ವಲ್ಪ ಇದೆ. ಬೇಕಾದ್ರೆ ಮತ್ತೆ ರೆಡಿ
ಏನೇನ್ ಜ್ಯುವೆಲ್ರಿ ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡ್ಬೇಕು ಮಾಡ್ಕೊಂಬಿಡಿ.
ಅಷ್ಟೇ ಇರೋದು ಅದರಲ್ಲಿ. He did not appear for mediation. We are ready.
Yes. Settle it, we'll close it. ಇಲ್ಲ ಅಂದ್ರೆ I'll send you to trial.
This week, please. Please set a date. We will
It's on
set this
Friday.
week. Friday ಅಂತ ನಾಳೆ ಬರ್ಬೇಕು ಸ್ವಾಮಿ mediationಗೆ.
ಆಯ್ತು.
Friday ಹೋಗ್ತೀರಾ?
Absolutely, please.
The parties are directed to appear before the Bangalore Mediation Center on Friday at 3 p.m. List the matter on Tuesday.
Obliged, please.
Yes.
7.
Not erstwhile owner of the vehicle, not his,
Karnataka.
not erstwhile owner of the vehicle, not is shown as one of the accused in the charge sheet and FIR not registered as against accused number 1.
Where is the
Not delivery
transfer of
note,
vehicle form 2930?
page 133, my lord,
1?
33. Is the accused number 1 also, my lord, in the prosecution paper says, yes, it is my vehicle. Page
130?
133. But I sell this vehicle to the
Delivery note idea?
delivery note on 22nd January 2020.
Date of the accident?
The incident on 23/9/2021. Accidental ಇದೆ in the essential commodities lay.
Easy.
Easy.
23
23/9/2021.
date of interception ಯಾವತ್ತು?
23/9/2021, madam.
23/9/2021.
Not the accused, my lordship will find.
Page
124, madam.
you are A2 is it?
ನಾವು A3 ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಸರಿ.
Page 124, the statement of not the present owner of the vehicle. Para 2, my lord.
1 minute. Para
ಮುಂದುವರೆದು ಸದರಿ ಉಗ್ರಾಣದ ಮುಂದಿನ ರಸ್ತೆಯಲ್ಲಿ ನಿಂತಿದ್ದ ಸೋನ್ಸೋ ಬಗ್ಗೆ ವಿಚಾರಿಸಲಾಗಿ ಸದರಿ ಲಾರಿಯು ನಮ್ಮ ಕುಟುಂಬಕ್ಕೆ ಸೇರಿದ್ದು ಎಂದು ನಾನು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತೇನೆ. ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್. On this ground, not your lordship was pleased to not record this. Entry model, your lordship was pleased to grant it. Only on this is the only ground, my lord.
Yes.
He was transporting the rice in his vehicle, my lord, in his lorry.
ನಂದಲ್ಲ.
ಆದ್ಮೇಲೆ he was transporting and
A1, your case is against A1.
you go against A1.
Yes, he is A3.
The petitioner is before this court calling in question the proceedings in CC so and so registered for offences punishable under sections. ಏನೇನಿದೆ ನೋಡಿ ಮೇಡಮ್ ಹಾಕ್ಬಿಡಿ ಎಲ್ಲ. The heard so and so. Facts in brief are as follows. On 22/1/2020, a vehicle bearing registration number KA29/7688 is intercepted by the respondent. The interception leads to the seizure of certain essential commodities which were being transported in the said vehicle, which is allegedly belonging to the public distribution system. A crime then comes to be registered in crime number 314 of 2021 for several offences as aforequoted. The petitioner at that point in time, FIR li ಅವರಿದ್ರಾ?
A3 ಅಂತ ಹಾಕಿದ್ರು ಸಂಬಂಧಿ.
The petitioner was also arraigned as accused number 3. The investigation leads to the filing of the charge sheet on 3/2/2022 against all the accused for the aforesaid offences. The concerned court takes cognizance of the offence on 15/2/2022, which drives the petitioner accused number 3 to this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that the petitioner has sold the vehicle on 22nd January 2020 and it is intercepted after about 18 months. Such interception cannot lead the petitioner into the web of crime as he had nothing to do with what was being transported after the sale of the vehicle. He would seek quashment of the proceedings. The learned HCGP would though seek to refute the submission on a contention that the charge sheet is filed and the petitioner should face the trial and come out clean in the same, he would seek dismissal of the petition. So I have given my response. The four narrated facts are not in dispute. The interception of the vehicle, which was allegedly carrying goods that were belonging to the public distribution system and contravening the provisions of the Essential Commodities Act or the IPC, as the case would be, is a matter of record. The proceedings are initiated by registration of a crime in crime number 314 of 2021, and a charge sheet after investigation comes about on 3/2/22, and the charge sheet leads the concerned court to take cognizance of the offense. The issue lies in a narrow compass, qua the petitioner accused, who is drawn as accused number 3. He did own the vehicle up to 22nd January 2020. On 22nd January 2020, sells the vehicle to accused number 1. The delivery note is appended to the petition. The delivery note reads as follows, marked portion at page 133. The documents of registration are said to have been changed in favor of accused number 1 after the said sale. The charge sheet is filed, and while filing the charge sheet, the charge sheet material would assume certain significance for a resolution of the list. The accused number 1 gives a statement prior to the filing of the charge sheet, during the investigation. The statement reads as follows, page 124, 125. The statement of the accused number 1 is that the said vehicle, which was intercepted, belongs to the family of accused number 1. If this is the statement of accused number 1, it is ununderstandable as to how the proceedings were drawn against accused number 3, the petitioner, as well, long after the sale of the vehicle. It is legally sold and purchased, and all documents of such sale are produced to the petition. In the said circumstance, permitting further proceedings against the petitioner as accused number 3 would become an abuse of the process of the law and result in patent injustice. For the aforesaid reasons, the following order allowed quashed only against accused number 3. It is made clear the observations made in the course of the order. So and so. Yes, next.
48.
Six years of relationship and friendship, my lord.
Yes, your lordship.
And lordship,
Yeah.
kindly, yes, according to the the prosecution case and the complaint, she says that she is asking for certain
417, 420, na?
417, 420. And moreover, lordship may kindly.
I've heard you on the last time, yes.
No, he has taken a 3.2 lakh rupees as well as a 6 lakh worth rupees gold, my lords.
From you.
Please.
It is not, lordship may kindly see, this is nowhere it is.
The
Now it
document, my lord.
appears to be, lordship may, this is also fabricated document. Lordship may kindly see.
Fabrication and the trial.
Allah, fabrication Allah, this document is never there. This is now the new revelation she has come out with a new, which is not there in the complaint nor in the charge sheet. Now.
How was the transaction? Gold bidi, the money?
Through bank, my lords. She was working in one Dubai company. All her salary transferred to his account.
All your salary?
Please.
Lordship may kindly see the document, because why I made a statement this appears to be fabricated. According to her, 2015 January onwards relationship. Now Lordship may kindly see the document which is produced in.
When is the transfer, sir? Money.
2010.
2015. my lords.
2010.
What is the beginning of the relationship?
They were colleagues, and thereafter.
Year.
Sorry, my lord.
When did it begin, sir?
They were working in Dubai separately.
Huh.
They were both of them are independent consultants. So their friendship developed. She came to know that subsequently they were friends with live-in relationship also. That is also not in dispute. Lordship,
Anyway, 376 is not alleged.
376 not alleged.
Rightly so.
Yes. Now Lordship may kindly see the money which is 6 years they lived together. Obviously there was transaction between here and there. The moment we come to know the same tactics, because her previous husband also committed suicide because of same blackmail. Kind of blackmail she has done, she has committed suicide.
Why did the uncle commit suicide?
For husband.
Husband?
Previous
Whose husband?
Her previous husband.
He's a widow, my lords.
Don't worry about that, sir.
No, same practice he has used here also started blackmailing. That is
You
why
are strong, don't worry.
he is distanced himself from.
At that time he
so
was
that
married.
is offshoot of this distance because he was also realized that these things are.
If
gone
there
on.
is any money transaction after the relationship began, both of you, give it back.
Lordship may kindly see, these are the documents also for a moment, Lordship may kindly see for this page number 4, as for page number 5. This is not from her account. She has taken all this document from my bank computer and saying that this is transaction she's talking about. Sender name, Lordship may kindly see.
So have you received any amount like this?
Only
You
125,000.
received amount from her.
Only one amount it is there,
What?
according to her.
Ah.
Page number 8, that is only 25,000 rupees.
25,000.
No, totally 3,06,000 ಆಗಿದೆ ಸ್ವಾಮಿದಲ್ಲಿ. ಏನಾಗಿದೆ ಇವ್ರು ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಕೊಟ್ಟು ಎಲ್ಲ ಅಮೌಂಟ್ ಇವ್ರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗೋ ಹಾಗೆ ಮಾಡಿದ್ದಾರೆ. ಅವರು ಪಾರ್ಟ್ ಟೈಮ್ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ದುಬೈ ಕಂಪ್ನಿಗೆ. ದಿರಾಮಲ್ಲಿ
Where is that mandate to the bank to transfer?
6 years their relationship.
So what? All the 6 years you have looted her and rain madakagat.
According to her, only 3 lakhs, my lord.
Kindly
Please, sir.
see, my lords, kindly see a page number
Been
20.
considerate, bari 3 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ.
Please, ಮತ್ತೆ 6 lakh worth rupees gold ಇದೆ ಸ್ವಾಮಿ ಅಲ್ಲಿ. ಮತ್ತೆ ಎಲೆಕ್ಟ್ರಾನಿಕ್
Did you give gold also?
ಅವ್ರು ಮನೆ ತಗೋಬೇಕು ಅಂತ ಹೇಳಿ ನಮ್ ಗೋಲ್ಡ್ ನ ಪ್ಲೆಡ್ಜ್ ಮಾಡಿದ್ದಾರೆ.
It is not the new
At that
revelation,
time,
my
That
lord.
you will have
Married.
done, no doubt.
The new revelation, not in the complaint, nor in the charge sheet. Completely new revelation before this.
Not the charge sheet material also.
Nothing,
No, she's a
not
careless,
even a
my lord.
word
I
whispered
have
this
produced
regarding
every
this.
document before the investigating officer. Lordship,
They
one more
produced.
thing, my lords. In
Charge sheet
electric,
is filed, my lord, in the charge sheet, entire charge sheet, no material.
lords, in a complaint, my lords, kindly see page number 13 of the petition, my lords.
What is this credit bill?
My lords,
Sai Hospital.
that is filed by, that is you.
Medical document, he is also going through some health issues, my lord.
Huh.
Those documents were produced.
Your lordship, kindly see page number 13 of the petition, my lords. My lords, he is having two hard disks, 5 mobile phone, 3 pen drive belongs to her, my lords. And in that.
Don't keep pen drives, sir.
No, my lord, this is
In that pen
her
drive,
own
there are
complaint,
some
lordship may kindly see.
personal videos.
Then
my lords.
tomorrow you'll face proceedings.
In that
Lordship may kindly
pen
see
drive,
her
there
own
are some-
complaint.
Hmm.
He says that I want his list 1, 2, 3, 4, 5. It does not belong to her. She is asking for all those things.
Because
Obviously, you would have captured everything in those.
No, it is not their case also, my lord.
And
It-
maybe, then
interestingly,
why are you
if it
keeping
is-
that?
If it is
It
my,
belongs to you.
Dial, my lords.
belongs to my computer, she's asking for my laptop, she's asking for my telephone, he's asking for my desktop.
She'll take all the data that is there in that and give it back.
It is not, my lord, that is not the case also, that is not.
Unless you have
It is-
something else also in it,
It is not there.
identical.
It is not there, my lord. I don't know how these new revelations are coming in, I don't know, it is nowhere on record, my making a statement on the bar,
Lordship,
without
everything is on
supporting
the
any
record,
such
my lord.
document.
Your lordship, in pen drive and the hard disk, my lord, there are some private videos are there, man. That's the main thing.
That's why I said,
No,
don't
not-
keep,
And in the-
don't keep the pen drive, sir, give it. Yes.
Your lordship, in one WhatsApp messages, my lords, he has been admitted, my lord, he has taken her 6 lakh worth of his gold.
Page.
Page number 29. Document memo I have filed.
What is your date?
Tony Shobha Anto.
29.
This. I gave 30,000 already for a booking. Rest we need to approximately 3.5 to 4. You two plus we will sell a Panayam, the gold we have, yours and Ammas.
When 6 lakhs
When
come
6
back,
lakhs
we'll
comes
buy
back,
gold.
we will buy gold. And Ponna sell it. And in another transaction, I saw a house, it's a damn good house. Amma liked a lot. Loan will mostly be approved in 15 days, I guess. Ninte paisa indi venum, 2 lakhs. If you don't mind.
Why this was not given to the IO?
My lords, everything I have given, my lord. She's a careless, she's a widow having one
What is the date
specially
of this?
challenged child, my lords.
Date of this?
Date is,
Date ಇಲ್ಲ ಇಲ್ಲಿ.
no, my lords.
ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ಅಯ್ಯೋಗೆ ಯಾವ್ದು ಕೊಟ್ಟಿಲ್ಲ.
Date.
Date
I
is
mean,
not-
date of this.
Date, I'm not talking, my lords. We have given all the documents to the investigating officer at the time of.
Why
the
have you not
complaint.
taken note
No,
of
my
The
lord.
care light.
As per the instruction, my lord, they have not, she has not produced any documents and
ಅಲ್ಲ, if this document was there, she would have definitely given it.
Yes, ma'am.
ಅವ್ರು ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತಾರೆ?
she has not produced.
And if you have taken money, give it. Why all this? You are
My
married
instruction, my
now.
lordship, I am married, my lord, my
You are
instruction is
married
that-
and living peacefully.
No,
The
lordship,
time
I
of
am-
relationship, he was married.
Presumably
I
peaceful.
also, I personally called him and taken instruction from this thing.
He was married at the
says
time
that
of
these
relationship with this
documents are
lady,
not-
my lord.
Give it. If
Got
there is
to be-
WhatsApp chat, then
No, the lordship
then
says-
let the trial go on for this. At least you'll come out clean or otherwise in the trial. 6 lakhs ಕೊಟ್ಬಿಡಿ.
It is not, if PSDB, it is not, I mean, that is my instruction, my lord, because,
This is your chat.
no, it is, and according to him, it is all created for this
This
purpose.
can't be forged, sir. What do you mean?
No, it
The
is.
WhatsApp chat
if at
between
all
you
lordship
and
may
her.
kindly see, these were there, definitely police should have recovered it. Placed before the police, they would have investigated.
See, everything has happened between the two. It's
Now,
all
according-
right. If you have taken money, why do you
Kindly see, 6
cheat the
lakh would
lady?
have Transferred it, they should have produced some document before the investigation officer.
If they have produced and this IO has not taken, what can be done? I will permit trial and to produce these documents by the petitioner under section 207.
In the trial, my lord,
Trial.
because even charge sheet is also.
Potpidi will close it here only. That's all you want, right?
That's all.
Jewels that were pledged for the house and the money that you have taken.
According to him, it is not
ಇದೆ.
instruction. No, this is, according to him, this is purpose, for the purpose of this case, is just created this.
ಏನು ಮಾರ್ಫ್ಡ್ ಇದು?
Morph ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅವ್ರದ್ದು injection.
Then trial
That is,
ಆಗಿ.
that is statement is made.
Then trial ಆಗಿ.
I specifically asked, that's what he said.
Then we'll specifically direct trial. Yes, I'll give you one chance next week. If you don't come out with solution, then we'll do it.
Kindly fix on date, my lord.
Yes, sir.
Date.
Next week,
Any date,
next Thursday,
please.
next Friday, sorry, 28th. Yes.
Okay, for
Connected
the
matter and
petitioner,
project-
my lord. This matter, my lord, the 319 applications came to be rejected.
319 rejection.
Rejection, against the 319 rejection.
You are the complainant.
I am the complainant.
Huh.
But there are two petition, one petition.
What was
filed
the,
with
what is
state.
the allegation?
The allegation that, my lord, there was a Galata, my lord, that's respond number 3,
Huh.
who also made an assault on the, my lord, the victim.
Hmm.
And my lord, there was specific, my lord, allegation even in the complaint.
Hmm.
But while filing the charge sheet, my lord, respond number 3 was dropped.
Which is your petition?
No, 274.
Both are yours?
274.
Why state is preferred?
Yes, my lord, in
Rejection of 319.
on the base of the statement of PW 123, my lord, added the petitioner's son as accused.
No, why did you drop first at the first instance? Now take me to the charge sheet.
No, charge sheet.
First the complaint.
Or complaint I produced, my lord, page number 19.
What is the offense?
But offense, my lord, 323, 307.
307,
307.
Yes, ma'am.
You were accused number what in the FIR?
My lord, the FIR, my lord. My lord, the respond number 2 is the, my lord, first accused. And the proposed respondent here, my lord, is accused number 2.
Respondent number 1, DT Krishna Gowda Yav accused, sir.
My lord, he is accused number 1, my lord. My lord, he is there in the charge sheet.
Why have you made him a party then?
My lord, since before the trial court is, my lord, in the application is there, my lord.
Now, who is to be bought in is his son, is this Harish?
Part 3, my lord,
TK?
Harish, DT Harish.
He was dropped.
He was dropped in the charge sheet.
Now, for dropping, what was the reason?
Reason that not they say, my lord, there is no, my lord, the allegation, after investigation, my lord, there is no allegation found as against, my lord, that petitioner.
During trial, what was the evidence against
No,
him?
evidence, my lord, all the eyewitnesses, my lord, including the independent eyewitness have, my lord, given their version saying that, my lord, this petitioner, this, my lord, the respond number 3 has made assault on the. my lord,
ನಮ್ಮ
the
ಮುಖ್ಯ
victim.
ವಿಚಾರಣೆಯಲ್ಲಿ ಆಗ ಆರೋಪಿಯ ಮಗ ಹರೀಶ್ ಅಲ್ಲಿಗೆ ಬಂದು ಒಂದು ದೊಣ್ಣೆಯಿಂದ ಸ್ವತ್ನಮಳೆ
ಹೌದು.
ಮುಂಬೈಗೆ ಹೊಡೆದು ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ನೀಡಿರುವ ಸಾಕ್ಷಿ ಎಂದು ಕಂಡು ಬರುತ್ತದೆ. ವಿಚಾರಣೆ ಅಲ್ಲೇ ಇದ್ದ ಆರೋಪಿ ದೊಣ್ಣೆ ಯಾರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದು?
PW 1,
PW?
3.
PW 1, my lord, Ratnamma, she is a victim.
1, 2, 3.
And my lord, 1, 2, 3 also, my lord. 2 is, my lord, another eyewitness.
Where is?
2 and 3 are the brothers of the
2 and 3 are brothers.
brothers.
No, no, no.
PW 2 and 3, who's been.
No, 2
deposed.
is the brother and 3 is my lord the coolie, my lord, who was there at the spot.
If this is the circumstance, how are you dropped, madam?
On 2/7, I'm an advocate by profession. On 2/7/2014.
Harish is an advocate by profession.
2/7/2014, I've actually submitted documents in, you can actually look at page number 21. Your
Of
Lordship.
what, madam?
Objections, Swami. ವಕಾಲತ್ ಹಾಕ್ತೀನಿ.
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. I have filed it on.
Objections ಹಾಕಿದ್ದೀರಾ?
Objections ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಅಫಿಡವಿಟ್ ಒಂದು ಹಾಕಿಲ್ಲ. ಅದಕ್ಕೆ objections raise ಮಾಡಿದ್ದಾರೆ. ಅಫಿಡವಿಟ್ ಒಂದು
ಯಾವ ಪೇಜ್ ನೋಡ್ಬೇಕು ಈಗ ಹೇಳಿ?
ಸ್ವಾಮಿ ಪೇಜ್ ನಂಬರ್ 21 ಅಲ್ಲಿ ವಕಾಲತ್ ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ. ಇನ್ ಅನ್ AC ಮ್ಯಾಟರ್ ತಹಸೀಲ್ದಾರ್ ಮುಂದೆ. ದಟ್ ಇಸ್ ಆನ್ 2013 ಅಲ್ಲಿ ಹಾಕ್ತೀನಿ. 2012-2013 ಅಲ್ಲಿ ಆನ್ ಪೇಜ್ ನಂಬರ್ 21 ಸ್ವಾಮಿ. ಐ ಆಮ್ ಆನ್ ಬೋರ್ಡ್. ಆಮೇಲಿಂದ 2/7/2014 ಅಲ್ಲಿ ಐ ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರೀತಾರೆ ಐ ಆಮ್ ಪ್ರೆಸೆಂಟ್ ಇನ್ ದಿ, ಅಂದ್ರೆ ಆ ದಿನ ಕೇಸ್ ಇತ್ತು ಸ್ವಾಮಿ 330 ವಾಟ್ ಎವರ್ ಇನ್ಸಿಡೆಂಟ್ ದೇ ಆರ್ ಟ್ರೈಂಗ್ ಟು ನರೇಟ್. ಐ ವಾಸ್ ನಾಟ್ ದೇರ್ ಅಟ್ ದಟ್ ಟೈಮ್ ಬಿಕಾಸ್ ಹಾಸನ್ದಲ್ಲಿ AC ಕೋರ್ಟ್ ಸಿಟ್ಸ್ ಅಟ್ 3 o'clock. ಸೊ ಇವ್ರು ಹಾಕಿರೋದು 2/7/2014 ಅಲ್ಲಿ ದ ಸೇಮ್ ಡೇ ಐ ವಿಲ್ ಡ್ರಾ ಯರ್ ಅಟೆನ್ಷನ್ ಟು ದ ಆರ್ಡರ್ ಶೀಟ್ ಸ್ವಾಮಿ. ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಪೇಜ್
ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲಿದೆ ಮೇಡಮ್?
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಎಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಜೊತೆ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಎಲ್ಲಿ
ಪೇಜ್ ನಂಬರ್ 10 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ಸ್ವಾಮಿ.
Objections ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲಿ?
ಹೌದು ಸ್ವಾಮಿ.
ಮೇಡಮ್ ಅದೇ objections. It's here. Yes. Page
ನಂಬರ್ 10 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ಸ್ವಾಮಿ.
ವಕಾಲತ್ ಯಾವತ್ತು ಹಾಕಿದ್ದೀರಾ? I am at page number 10, madam.
ಪೇಜ್ ನಂಬರ್
What is the date of the incident?
2/7/2014 ಸ್ವಾಮಿ.
7/2/2014.
ಹೌದು ಸ್ವಾಮಿ. 2/7/2014.
2/7.
ಹೌದು ಸ್ವಾಮಿ. ಸ್ವಾಮಿ ಕೇಸ್ ಕಾಲ್ಡ್ ಔಟ್ ಅಪೆಲೆಂಟ್ ಆಬ್ಸೆಂಟ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪ್ರೆಸೆಂಟ್ ಅಂಡ್ ಆಸ್ ಫೈಲ್ಡ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂತ ಇದೆ.
Case called appellant absent. You are the counsel for the respondent.
ಹೌದು At the time of incident, I was not present, Swami. I was present here in Hasan ನಲ್ಲಿ. ನಾನು I was being
Incident ಆಗಿರೋದಲ್ಲಿ?
ಚನ್ನರಾಯಪಟ್ಟಣದಲ್ಲಿ. ಸೊ ನಾನು ಇಲ್ದೇ ಇರೋ ಕಾರಣ ದಟ್ ಇಸ್ ವೈ ಇನ್ ದ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ನನ್ನ ಹೆಸರನ್ನ ಕೈ ಬಿಡಲಾಗಿದೆ ಸ್ವಾಮಿ.
What is the distance?
40 kilometers ಇರ್ಬೋದು ಅನ್ಸುತ್ತೆ ಸ್ವಾಮಿ. 40 to 50
What was the time of the incident?
3:30 ಸ್ವಾಮಿ.
ಮಧ್ಯಾಹ್ನ.
3:30. AC sits at 3 o'clock in Hasan ಸ್ವಾಮಿ.
Incident happens at 3:30.
3:30. That is what is being alleged in this complaint ಅಲ್ಲಿ ಇರೋದು 3:30.
Will dictate in the afternoon.
Not here the case, not they have taken the plea of alibi, whether the same advocate who appear, not is the matter of trial, they have to, not
Same advocate.
not, they say respondent not present.
ವಕಾಲತ್ ಎಲ್ಲಿದೆ?
No, they say they say not.
ಇದೆ ನೋಡಿ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ 21 ಅಲ್ಲಿ ಹರೀಶ್ DK ಅವ್ರದೊಂದೇ ಸಿಗ್ನೇಚರ್ ಇರೋದು ಸ್ವಾಮಿ. DK ಹರೀಶ್ ಅಂತ ರೈಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ಅಲ್ಲಿ ಇದೆ.
Sometimes not even the colleague could also go there and represent them not case. It's not the very same person, not it's a plea of alibi. They have taken, it's a matter of trial.
Who is the one who gave evidence that you have beaten him with a stick?
Not PW 123.
PW1 ಯಾರು?
PW1 is a victim. PW2 is a
victim, all right. Where is
PW2 is the brother.
ಸ್ವಾಮಿ.
Brother of the victim.
Victim.
ಹೌದು ಸ್ವಾಮಿ.
PW3 is the coolie. He was present at the spot. PW3 also given the evidence.
Swami, there are a lot of disputes between the DT Krishnagowda and the petitioner idare. So there is, she happens to be the second wife of his brother. So
what is your role in this?
Nanu maga Swami ashte. I am the son of DT Krishnagowda.
And an advocate ashte.
I am an advocate, but I was not present at the incident. I have nothing to do with this incident. There is a dispute between accused number 1 and ಇವರು. ಬಟ್ ನನ್ನ ಮಧ್ಯ ಏನೂ ಇಲ್ಲ ಸ್ವಾಮಿ. ಐ ಹ್ಯಾವ್ ನೋ ಬಿಸ್ನೆಸ್ ಇನ್ ಇಟ್ ಬಿಕಾಸ್ ನಾನು ಪ್ರೆಸೆಂಟ್ ಇರಲಿಲ್ಲ, ಏನೂ ಇಲ್ಲ. ಮತ್ತೆ ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲೂ ಸಹ ನಾವು ಇನ್ ದ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ 319ಗೆ ನಾವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ. ಇನ್ ದೇರ್ ಓನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅವರೇ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರೆ. ದಟ್ ಐ ಕ್ಯಾನ್, ಇಫ್ ಯು ಪರ್ಮಿಟ್ ಮೀ, ಐ ಜಸ್ಟ್ ರೀಡ್ ಇಟ್ ಔಟ್.
Page.
ಸ್ವಾಮಿ ಪೇಜ್ ನಂಬರ್ ಅವರ ಇದರಲ್ಲೇ 32 ಪೇಜ್ ನಂಬರ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ.
30?
32 of the petition what has been filed by the
Yes.
petitioner itself. Number objection, andre objections what has been filed. Here
Yes.
is the instant case, there is no material before the court to implead the additional proposed accused because on the perusal of the prosecution papers, it can be seen that the first information was given by the further statement to the police on 4/7/2014. In the said further statement, she has stated that since she was in panic condition, Swami, either please note it, even though the proposed accused Harish was not present in the place of occurrence. She had stated that proposed accused also was involved in the alleged offense. In other words, CW1 in her further statement has admitted that the proposed accused has not participated in the alleged crime anta ide Swami. ಅವರ ಓನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲೇ ಇಲ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ ಪ್ಯಾನಿಕ್ ಅಟ್ಯಾಕ್ ಅಲ್ಲಿ ಇದ್ದಾಗ
ಆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
ಸ್ವಾಮಿ ಅದು ಪೇಜ್ ನಂಬರ್ 32 ಅಲ್ಲಿದೆ ಸ್ವಾಮಿ. 32 ಅಲ್ಲಿ ಆಮೇಲೆ 33 ಅಲ್ಲಿ
ಏನು ಅದು ಅಬ್ಜೆಕ್ಷನ್ ಆಯ್ತು. ಯಾವ 32, 33?
ಸರ್ ಇವರ ಪಿಟಿಷನ್
ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಏನ್ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀರಾ
ಹಾ.
ಅದು ಎಲ್ಲಿದೆ? Statement 4/7/2014, where is it? Further
Yeah.
statement. Yes, government.
My lord, he is added as a proposed accused.
accused.
Allegation is, my lord.
Supposed accused, all right. Now, the objection hakirad iವರು that the CW1 has given the statement that he was not in the scene of crime.
My lord,
Where is that
has to
statement?
be adjudicated during the trial. my
No, no,
lord.
you will not permit sumne alarm.
No, my lord, here the case, my lord.
Consciously, you have dropped him and now you want to bring him back.
My lord, kindly appreciate, my
My
lord.
lord.
My lord, in the complaint, my lord, in the complaint, when the first instance, my lord, the complaint is filed. If the name of the, my lord, this petition, my lord, this proposed petition is not there, if there is no allegation, my lord, if, and subsequently, my lord, his name is not found in the further statement, then my lord, the different issue. My lord, here the case, in the first instance.
Crime
my lord-
ಅಲ್ಲಿ, sir, 319 ಬರದೆ if you have dropped someone in the
Please,
charge
my lord,
sheet.
please.
So he has been dropped, no doubt about it.
My lord, dropped because, my lord, on the basis of the further statement, my lord, that is the, my lord, reason, my lord, why, how, my lord, it was dropped because of the further statement, my lordship, no, aware that, my lord, sometimes, my lord, this happens, my lord. My lord, the further statement, my lord, is
See,
not the statement.
Once you drop, there should be stronger evidence than what was found during the investigation to bring them back into the
Lord,
regular.
fine, my lord, here the case, my lord, if at all, my lord, if she's a victim, my lord, it's only a victim evidence, my lord, based on which, my lord, its application is filed. Then, my lord, there might be, my lord, some,
You have suffered an order of rejection. I will consider it. I'll dictate at 2:30.
lord, in fact, my lord, here the case, my lord, the, my lord, incriminating articles is also been seized.
What incriminating?
No, there is a club
Club used by,
by the, my lord, the proposed petitioner.
he says he was not even there.
My lord, here, my lord, the further statement, my lord, the what, my lord, the police records, my lord, saying that, my lord, it's, my lord, the club is also been used, but it is, my lord, used by the, my lord, accused number 1. That is, my lord, the father of this petitioner. That is why, my lord, they have thwarted the, my lord, that
The
we-
father, if father is already in a.
already is there, my lord.
He will face.
My lord,
He has done it, he will face.
my lord, here, there is no dispute as to that, my lord, the father is, my lord, accused, my lord, he is facing the trial. My lord, now, my lord, in view of the, my lord, the fault investigation, my lord,
Why do you want to drag the advocate also into it?
my lord, because, my lord, he is participating in the crime. My lord, otherwise, there is no question of, my lord, he is making allegation against him in the evidence. My lord, if at all, my lord, it's only, my lord, if there is a, my lord, the dispute, family dispute, as well as, my lord, that, my lord, property dispute between the, my lord, the two
No,
parties.
between his father and you.
My lord, dispute that, my lord, my lord, my lord, the victim herein is, my lord, this, my lord, my lord, the daughter, I'm sorry, sister-in-law of the, my lord, my lord, the father of the, my lord, proposed petitioner herein. Since, my lord, she is the
Who are
second
you?
wife,
Who are
60,
you?
my lord, I am the second wife of, my lord, her, my lord, accused number 1's brother, second wife. I am the
Family.
second wife.
In
Please,
the
my lord.
family.
Because, my lord, he wanted, my lord, property of the, my lord, the husband's, my lord, the share. So therefore, my lord, there was a galata between, my lord, two families.
We're not on that. The invocation of 319 is correct or not, we'll answer.
Please.
2:30 only.
Your Lordship, may I make one submission? Serial
Ah.
number 56, kindly adjournment for still Saturday, Lordship.
Page wise karibidi madam.
Page wise
My lord.
50 to 55.
Page wise karitai.
50 serial, 50, my lord, serial number 50.
What do you
May I
want?
have on 27th, my lord, it is for reporting settlement.
Learned counsel for the petitioner seeks time up to 27 to report settlement. List on 27th at 2:30 PM. Yes.
Page
Next.
56 to 64.
56 Lordship, serial number.
Prakash sir. 56 sir.
I am for the respond number 2 Lordship. Kindly have it on Saturday Lordship.
No sir. Petitioner is objecting, yes.
Lordship, already entry mode is there.
Sir, mention when the case is called, yes.
Page 9, 65 to 71. Page 10, 70, 75. Page 11, 76 to 81.
My lord, serial number 81. There are other two connected matters posted on 12th July, my lords. Kindly may list on.
Good way of taking attention. Yes. Tag this petition along with so and so. 12th idea?
12th July, my lord.
Yes, 12th July. Next.
Serial number 83, my lord.
1 minute.
Page 12, 83, 82 and 83.
83, I am for the R2, my lord.
83.
Yes, my lord. Objection filed ಮಾಡ್ಲಿಕ್ಕೆ ನಾನು other side inform ಮಾಡಿದ್ದೀನಿ. And 2 weeks time ಬೇಕು.
You are for Mohan.
R2, yes ma'am.
Entry ಮಾಡಿದ್ಯಾ?
ಇದೆ, ಅವ್ರಿಗಿದೆ. ಎರಡರಲ್ಲಿದೆ, ಒಂದರಲ್ಲಿ ಇಲ್ಲ.
ಹೆಂಗಿದೆ ಹಂಗಿರ್ಲಿ. 83 learned counsel appearing for the second respondent seeks time to file statement of objections. The list after 2 weeks, objections if any by then. Entry order subsisting in any of these cases shall continue till the next date of hearing. Yes. Keep the please.
Page 30, 84 to 88. Page 91.
ಇನ್ಯಾವುದಿಲ್ಲ?
Let's I seek one indulgence from this.
Yes.
Minutes, this, I may be permitted to move a memo. This is in respect of a matter minutes where SBI law officer is made as a party, as an accused. So now her service is at stake minutes. The original documents in a home loan minutes is allegedly misplaced by the bank. So the law
Why does-
officer who's
why does the
totally
law officer
unconnected
come in?
minutes. The law officer who's totally unconnected to the transaction minute is
Put
made as an
Tomorrow, take it
accused.
tomorrow.
On submission.
Serial number 95 millions. Next week, date may be fixed.
95 years.
Yeah, 90.
Settlement ಇಲ್ವಾ ಇವತ್ತು?
ಅಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಇವತ್ತಿಲ್ಲ, ಮಾತುಕತೆ ನಡೀತಾ ಇದೆ.
ಮಾತುಕತೆ
ವಿಲ್
ನಡೀತಾ
ರಿಪೋರ್ಟ್
ಇದೆ.
ವಿಲ್ ರಿಪೋರ್ಟ್
Same 27.
27 ಪ್ಲೀಸ್.
Serial number 60, your lordship.
60. Yes.
Press for some time.
Huh?
ಅಲ್ಲಿ ಕೆಲವೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕಾಗಿತ್ತು ಅಂತ.
Petitioner, entry order ಇದೆಯಾ?
ಎಂಟ್ರಿ ಮಾಡಿ
2 weeks ಬಿಟ್ಟು on date ಕೊಡಿ. Entry order continues.
ಪ್ಲೀಸ್.
4th ಬೇಡ ಮೇಡಮ್, 11th ಹಾಕಿ. Yes. And permission. And permission. Serial number 65, I am applying for the respondent. Engage the senior counsel. That's the reason any other 65.
This case appear for petitioners. I am opposing the adjournment.
Opposing,
Please, my lord.
reach other kedi.
I am engaging the senior counsel.
Opposing. I engage the senior counsel, that's why. How senior counsel? If there is opposition, mention when it is called, please. Continue. Yes, sir. ಹಾಕ್ಬಿಡಿ ಅಲ್ಲಿ. ಆಯ್ತು ಸರಿ. ಬಟ್ ಮೆಮೋ ಮಾಡಿದ್ದೆಲ್ಲ ಹಾಕಿ ಇವತ್ತಿನ ನಾಳೆ. ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಇದೆ ಎಷ್ಟಿದೆ?
Voting settlement 92.
An offense.
My lord, for the reported settlement, madam.
Offense.
Hello?
What's the offense, sir?
Offense is
ಕೊಡಿ ನಾನೇ ನೋಡ್ತೀನಿ. Four 471.
I'm to respond number 2, my lord. They have not intimated to us about any settlement.
Lord, actually they are in abroad, my lord. So release the matter
Also,
after
my
2
lord,
weeks. my lord.
kindly
The learned
direct,
counsel for the second respondent submits that there are no talks of settlement with the respondents. Therefore, list this matter after 4 weeks.
on the submission, my lord. Kindly
Interim
direct
order
the
may be
petitioner,
1 minute.
kindly direct the petitioner to provide us a copy of petition number 3318 of 23. We haven't received any
The
copy.
learned counsel for the petitioner shall serve upon the counsel for the second respondent complete set of papers forthwith. Yes.
93.
Interim order ಇದೆಯಾ?
Yes, my lord.
Kindly have it on second week of July. my lord.
Same ಕೊಡಿ. List on 18th July.
93.
98 and 3 and matter is settled. 498 and 3 and 4 of dowry prohibition. Matter is settled.
Where settled, where?
Settled between the parties, my lord. They have
In the
agreed to-
mediation or what?
ಅಲ್ಲ, out of court.
ಇಲ್ಲೇನಾ?
ಕೊಡಿ, DD ಕೊಡಿ. Giving DD for rupees 12.5 lakhs as permanent alimony, my lord. Should be handed over.
Whatever. Madam. ಇದು recommend. The pen drive ಇಸ್ಕೊಳ್ಳಿ. ಬಂದ್ಬಿಟ್ಟು joint memorandum of settlement.
And
The
they're also
parties-
exchanging gold and demand draft is given and also gold, my lord, they've received.
ಇದೆಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ, ಫೋಟೋ ತೆಗಿಬೇಕಾ ಇಲ್ಲಿ? ಮತ್ತೆ?
Just bringing it to the knowledge.
I will say all conditions fulfilled. The petitioners are before this court so and so. During the pendency of the petition, the parties to the list have settled the dispute amongst themselves and have filed an application under section 320 of the CRPC seeking compounding of the offences. Since the offences are the ones punishable under section 498A and 34 of the IPC and Dowry Prohibition Act, and not being against the state, I deem it appropriate to accept the application seeking compounding of the offense, compound the offense, and quash the proceedings against the petitioner on recording of the affidavit. The affidavit reads as follows. And the affidavit is filed in support of the joint memorandum of settlement. The joint memorandum of settlement reads as follows. In the light of the two, and the offense being thus the following order, disposed, quashed. Madam, ಇದು lengthy ಇದೆ. Pen drive ಇಸ್ಕೊಳ್ಳಿ.
What sheet?
Give the content in the pen drive.
94. 94.
447.
Lord, 380, 447. Lord, the other
Settle-
side council is not yet come, my lord.
Passover.
Petition is, pass over, my lord, parties are present.
95 to 96.
Matter has been settled before the mediation, my lords.
498 ಏನ?
No, my lords.
Plus one.
323, 324, 383, 504, 506, said with 34.
Yes. Settlement ಕೊಡಿ. The petitioners are before this court seeking quashment of so and so. The parties were also before the mediation. Karnataka Mediation Center, Bangalore. and So and so. A memorandum of settlement is drawn in mediation. The settlement also recognizes closure of the present proceedings. The settlement, insofar as it pertains to the closure of the present proceedings, is as follows. Clause B at page 4. Adonde. The learned counsel for the petitioners parties would submit that all other conditions in the settlement stand fulfilled and the complainant has no objection to quash the proceedings. In the light of the settlement, adonde parasak madam, settlement, so and so, offenses being so and so, disposed, quashed.
Voting settlement, Pastor 34.
Madam, ಇದು 2015 act ಮಾಡ್ತಾನಪ್ಪ final hearing. ಇದು settlement. Serial number? Passed over.
Please, pass.
ಏನ್
Matters, two matters, my lords. My lord friend.
offense ಏನು?
My lord, one matter is 354.
306 ಇದ್ದಂಗೆ ಇದೆ.
One 306, sir. What happened is, my lord, there was a joint development agreement between the accused and the deceased. In respect of that, our contention of this accused person was that he has not satisfied the conditions. So legal notice was issued, he answered. There are some disputes. He was under serious financial trouble, and he committed suicide because of the allegation is because of dispute. And we requested him to hand over the flats immediately, my lords. He committed suicide. That is the allegation. That's in the first case. And the second case is after that, the allegation is he threatened and outraged the modesty of the widow.
In 354, huh?
How 354? Second is again. My lord, now my lord, as far as the disputes, civil disputes that has been settled, my lords, entered into an agreement, how it has to happen, my lord. One flat is handed over, etc., my lord. The matter has been compromised. Now, my lord, as far as 354, my lord, we will be praying on the court. Yes. As far as 306 is concerned, my lords, one, of course, we have raised a, also, my lord, respond number 2 is also filing an affidavit, my lords, under which circumstance she filed the complaint, etc. Even otherwise, our submission is, my lord, entire complaint if taken together, it reveals that there is a dispute. We have issued legal notice, etc.
No, you come on merits, 306, why settlement?
Please, on merits, I'm submitting.
Settlemental list ಆಗಿದೆ.
There are two matters which are connected, my lords. Two matters which are connected. As for 306 is concerned, my lords, one aspect is that we will not hide it, my lords. Truth is that respond number 2 herself says, my lord, that as far as quashing is concerned on merits, not otherwise, my lords. We have no objection. That is the affidavit which she is filing, my lords. Even otherwise, your lords may kindly see that complaint, 306 complaint which has been filed, my lord. That's at page number 100, my lord.
Yes, Sadashiva sir.
Yes, my lord.
306.
Since the
354 will close.
well, both the cases, because the parties have settled their disputes in the civil case.
306 cannot be closed by way of a settlement.
My lord,
306 cannot be closed by way of a settlement. Particularly when monetary transaction has led to filing of a compromise petition. Cannot do it.
but fact remains, my
You
lord.
have to come on, no, fact may remain anything. I
Civil
have to
suit-
pass an order.
Yes, yes. Civil suits are already concluded.
ಅದಕ್ಕೆ just you come on merits, we'll consider on merits.
Merits, 2
306 merits.
On merits only, man. This is covered by my lord's recent view taken. my
Settlement,
lords On 5/4, no, on merits, we are submitting on merits, my lords. The decision of my lord on 5/4/2024 in David.
That
my
David
lords,
D'Souza.
Your lordship has covered all the points. I will not reiterate, my lord. I beg to submit it, my lord permits it, my lords. And the kind.
4844 ಅಲ್ಲ? Writ petition 4844.
ಹೌದು. We are grateful, my lords. Every time we feel.
Yes.
We are not done proper homework, my lord. I don't remember the number, my lords. I'm grateful. And I am not getting it out to remember it every time. And the recent view in Vikas Chandra, Supreme Court, all these things, if there is a financial dispute, and my lord, there should be, that's, I do not repeat it, my lords, I know.
Recent decision
Recent is, my lord, Vikas Chandra on the Supreme Court may pass on same facts, my lords. Very recent, that's why I am producing it, my lords. Wherein in
306.
306, so financial disputes iddaga not be attracted unless.
We'll answer it on merits.
On merits. I beg to take my lord to only 2-3 sentences, page 100.
No, but, then wait, I'll just run through the list and then take this. One settlement ಅಲ್ಲಿ ಮುಗಿಸ್ತೀನಿ, ಇನ್ನೊಂದು merits ಮೇಲೆ answer ಮಾಡಿ.
As well.
Yes. You come about 4:15. 4:15.
Please.
Yes. Continue. 2:30 more matter. ಅದರ ಲಾಗ್ ಲೇ ಡೌನ್ ಮಾಡೋದಿದೆ ನೋಡೋಣ ಸರ್ ಮ್ಯಾಟರ್ ಪರ್ಪಸ್ ಎಸ್
It's continued.
ಹತ್ತೇಳು ಇಪ್ಪತ್ತು ಹಾಂ
49.
Before my lord, I just my lord said two things, my lord. Really. But as far as my lord, the contention as to my lord plea of alibi is concerned, my lord, it is not their case that my lord they have placed all these records before the IO at the time of investigation. It is for the first time, my lord, they have placed before the court and saying that my lord they were my lord the court at the time of the my lord incident. Under section 103 of the Evidence Act, my lord, they have to prove, my lord, that my lord there was a plea of alibi that they were not at the spot. Unless my lord, such evidence is not recorded, my lord, that straight away, my lord, that plea of alibi, my lord, contention of plea of alibi cannot be taken into account. The secondly, my lord, as far as my lord, they say, my lord, in the further statement recorded in section 161, my lord, I am not a signatory, my lord, it's my lord, the statement recorded by the, my lord, the police. My lord, whether, my lord, the statement, as I said, my lord, it was recorded.
164 statement ಏನಿದೆ
164 ಇಲ್ಲ
ತಗೊಂಡಿಲ್ಲ ಸರ್
ತಗೊಂಡಿಲ್ಲ. It's only 161 statement, my lord, upon which, my lord, they say that my lord, he has been dropped, my lord, during the charge sheet. But as far as the, my lord, contention is concerned, my lord, what is required, my lord, it's the evidence. But it's not a substantial piece of evidence, my lord, it's not on oath. It is only a statement recorded by the police, my lord. I am not a signatory to the statement, 161 statement, my lord, and the further statement. And my lord, in the FIR, my lord, I have given a clear statement that saying that not I am not signatory to the complaint, where I have clearly made an allegation that my lord, this person has made an assault. And my lord, with the club, my lord, there is no, my lord, and further, my lord, the club has been recovered.
Recovery
Recovery is there.
on whom is the assault now made, against the father?
No, my lord.
Then
My lord, it is, my lord, father and the son both have made assault on the, my lord, the victim.
now what, who remains? The father remains.
Father also, my lord, assaulted with, my lord, the chopper.
Father is still an accused.
Still an
Yes.
accused. Now the son, my lord, who made, my lord, the assault on the, my lord,
So
the,
what to whom is the object now attributed to? The club
my lord, club is recovered now.
recovered and it is attributed to whom?
Against, my lord, the proposed respondent now.
ಈಗಲ್ಲ in the while filing the charge sheet when he was dropped, the club was recovered. To whom is it attached to now?
That is, my lord, the accused
To the
number one.
father.
To the father.
ಅಷ್ಟೇ ಕೇಳಿ.
To the father, my lord. But my lord, the evidence, my lord, if a lordship will kindly appreciate, my lord, now the PW3, my lord, who is the independent eyewitness. He is an independent eyewitness, my lord, he clearly, my lord, the deposed before the court that, my lord, this person was there and made an assault on the, my lord, the victim.
Who is PW3?
PW3 is a coolie, my lord. My lord, he is nowhere connected to the family.
PW3 ಯಾರು?
ಬ್ರದರ್ ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
No, no, no.
ಯಾರ ಬ್ರದರ್?
ಅವರ ಪಿಟಿಷನರ್ ಅವರ ಬ್ರದರ್ ಸ್ವಾಮಿ.
PW3 ನು
ರೀನು ಬ್ರದರ್ ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
ನಾನ್ ಬರ್ಕೊಂಡಿದ್ದೀನಿ.
Lord, I produced, Lord, the copy. Kindly see page number
Club is
31.
recovered as per the Mazar,
Sorry,
saying that
exact
it is attributed by A2.
Where do you get that?
ಅಲ್ಲಿ ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳ ಮತ್ತೆ ಅಮಾನತು ಮಾಜರ್ ಅಂತ
Page ಹೇಳ್ಬೇಕು.
ಪೇಜ್ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲಿದೆ.
Lord, page, my lord, I have produced.
ಎಲ್ಲ ಶೀಟು ಕೊಟ್ಟಿಲ್ಲ ಅವರು ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ. ಒಂದು ಹೇಳಿಕೆ ಅಂತ ಒಂದೇ
ಒಂದು
ಒಂದು
ದೊಣ್ಣೆಯನ್ನು ತೋರಿಸಿ ಎರಡನೇ ಆರೋಪಿ ಕೃತ್ಯವೆಸಗಿ
Lord, in the memo dated page number
ತೋರಿಸಿದ
41, my lord.
ಮೇರೆಗೆ
ಯಾರ್ statement ಅಲ್ಲಿ?
ಮಾಜರ್ ಅಲ್ಲಿ.
Mazar ಅಲ್ಲಿ.
Mazar ಅಲ್ಲಿ.
Mazar is according to what the complainant says.
And in the cross examination also, they have cross examined in length. In the cross examination.
CW1.
Yes, my lord. She has clearly admitted that this accused number 2 has assaulted on her. And that has been supported by PW2 and 3 also.
Who is PW2 and 3? Who are?
Lord, PW2 is the brother of PW1. PW3 is not independent eyewitness.
ಅದು ಬೇಕು ತಾನೆ. PW3, what does he describe himself as?
Lord, he's a coolie. Kindly see page number 31 in the
Brother
memo.
ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಮೇಡಮ್, ಮೇಲಿದೆ.
ಬ್ರದರ್ ಅಂತ ಹೇಳಿದ ನಾನು ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ನೀವು ಬರ್ಕೊಂಡಿದ್ದೀರಾ? ಅಲ್ಲ ಬರ್ಕೊಂಡಿರೋದಲ್ಲ, ಇಲ್ಲಿ ಎಲ್ಲಿದೆ ಎವಿಡೆನ್ಸ್?
ಇಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ. ಇದ್ರಲ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
Then it is difficult. Independent eyewitness ಇದ್ರೆ.
ಸ್ವಾಮಿ ಅದ್ ಬೇಕಂದ್ರೆ ನಾನು ಕ್ಲಾರಿಫೈ ಮಾಡಿ ಹೇಳ್ತೀನಿ.
If it is
PW3
not an interested witness and an independent eyewitness.
Interested witness ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ because there are a lot of dispute which is already been pending between the father in the sister-in-law and the accused number 1 ಸ್ವಾಮಿ. ಒಂದು ಅಂತಲ್ಲ ಸ್ವಾಮಿ, ಪ್ರಾಪರ್ಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ತುಂಬಾನೇ ಇದೆ. ಬಟ್ I am not at all concerned with it ಸ್ವಾಮಿ. ನಾನು ಇರ್ಲೇ ಇಲ್ಲ ಆ ಜಾಗದಲ್ಲಿ. I was not there at all.
That's a plea of alibi.
ಯಾಕಂದ್ರೆ ನಾನು ಆ ರೆಕಾರ್ಡ್ ಅಲ್ಲೂ ಇದೀನಿ. ಆ ದಿನ ನಾನು ಒಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಮಾಡಿದೀನಿ. ಐ ವಾಸ್ ಪ್ರೆಸೆಂಟ್ ಇನ್ ದ ಕೋರ್ಟ್ ಸ್ವಾಮಿ. AC ಕೋರ್ಟ್ ಮುಂದೆ ಐ ಬೀನ್.
Name is not recorded.
Please.
ಅಲ್ಲಿ ನೇಮ್ ರೆಕಾರ್ಡ್ ಆಗಿದ್ರೆ you would have no problem at all.
ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಒಬ್ಬರೇ ಇರೋದು ಸ್ವಾಮಿ. Only one respondent, advocate for respondent ಒಬ್ಬರೇ ಇರೋದು ಸ್ವಾಮಿ. If you look at the
Independent eyewitness ಇದ್ರೆ then
ಅದು ಬೇಕಂದ್ರೆ ಒಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್.
that clarification I want.
ಬೇಕಂದ್ರೆ ಒಂದು ಶಾರ್ಟ್ ಅಕಾಮಡೇಷನ್ ಸ್ವಾಮಿ. ನಾನು ಕ್ಲಾರಿಫೈ ಮಾಡಿ.
You don't have independent eyewitness ಅಂತ ಹೇಳ್ತಾರೆ, ಏನ್ ಹೇಳ್ತಾರೆ?
ಹೌದು ಸ್ವಾಮಿ, I have produced, my lord. Kindly see. I have
Page
produced page of 31. In the memo, my lord, along with the memo I have produced, my lord. I have produced that copy also. Thirty-one, my lord, find that, my lord. Krishna.
Krishna.
Lord, kindly see, my lord, fourth line, ಅಲ್ಲಿಯೇ ಇದ್ದ ಆರೋಪಿ ಹರೀಶ್. ಹರೀಶ್ is the proposed, my lord, accused. ದೊಣ್ಣೆಯಿಂದ ರತ್ನಮರಳಿಗೆ ಹೊಡೆದ. The categorical state so.
ಶಿವಲಿಂಗೇಗೌಡ ಅವರನ್ನು ಬಿಡಿಸಿದೆವು. ರತ್ನಮರಳು ಸಾಯಿಸಿ ಬಿಡಿಸುವ ಅವ್ಯಾಚಿಸಿಗಳಿಂದ ಬೈದು ಕಲ್ಲಿನಿಂದ ಬೆದರಿಕೆ ಹಾಕಿದ ನಂತರ ಆಸ್ಪತ್ರೆ ಸಾಗಿಸುವ ಆಂಬ್ಯುಲೆನ್ಸ್
ಕಾಪಿ ಇಲ್ಲೇ ಇಲ್ಲ ನಮ್ಮ ಹತ್ರ.
ರತ್ನಮರಳನ್ನು ಕರೆದುಕೊಂಡು ಬಂದೆವು. ದೊಣ್ಣೆ ಮಚ್ಚು ನೋಡಿದರೆ ಗುರುತಿಸುವೆ. ಮುಂದೆ ನೋಡುತ್ತಿದ್ದವು. Then why the court rejects it now? On what ground?
Rejects it that, my lord. The court says that not.
Court said, my lord, there is no incriminating material seized from the hands of the accused number 2, but club is seized.
The court would say that not, in spite of recording that, my lord, not page number 15 ಅಲ್ಲಿ, the petition. So in the instant case, my lord, in the middle of the, my lord, the findings. Though PW 123 have deposed, the proposed accused was also present at the time of alleged incident, I have also deposed that the proposed accused assaulted PW 1. However, prima facie, there is no material to believe.
Prima facie, no material to believe this version of PW1.
Plea but 1, 2, 3 ಅಂತ ಇದೆ
And I've
ಸ್ವಾಮಿ.
also deposed proposed so and so. That apart, because we are not
Lord, the IO has collected accused being an advocate representing his claim before the particular, that cannot be taken.
You are going against the IO now. IO has collected sufficient material that on the incident, the proposed accused and advocate representing claim before a particular revenue court. So if this kind of submission is taken into consideration.
State has filed the petition. State has filed the petition. First petition.
Status.
State has
ಅದಲ್ಲ,
filed
ಅದು ಅದಲ್ಲ.
first
That is a
petition.
ಸ್ವಾಮಿ
State has also filed rejection of.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವರು 49 ನೋಡ್ತಿದ್ದಾರೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 49 ಅಲ್ಲಿ ಓನ್ಲಿ ಅಕ್ಯೂಸ್ಡ್ 1 ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಇದು 49.1 ಅಂತ.
Why is the state has come against the 319 order only?
ಅದು 274 ಅಲ್ಲಿ
319 order reject ಮಾಡಿದ್ಮೇಲೆ state also has come here.
ಹೌದು.
Yes. Because Supreme Court in its latest judgment says, if there is eyewitness, there in that case, there was no eyewitness. That is Shankar versus State of Karnataka. There was no eyewitness. Supreme Court says it was not enough material because the evidence of CW1 there, it is only the victim's evidence that cannot be used to bring him back, bring him or her back there. Illi there is independent eyewitness.
ಇಂಡಿಪೆಂಡೆಂಟ್ ಐ ವಿಟ್ನೆಸ್ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Independent eyewitness ಯಾರು ಅಂತ ನನಗೆ
ಯಾರು ಅಂತ ನಾನು ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ. ಸೊ
ಯಾರು ಅಂತ ಹೇಳಿ.
ಹೇಳ್ತೀನಿ. ಐ ವಿಲ್ ಜಸ್ಟ್
Day after tomorrow?
ಸ್ವಾಮಿ 21st ಬೇಡ, ಕಾರವಾರ ಆಕ್ಚುಲಿ.
ಯಾವತ್ತು ಬೇಕು?
ಮಂಡೇ ಹಾಕೊಳ್ಳಿ.
ಮಂಡೇ ಅಲ್ಲ, I'll take this on Wednesday. 23 ಇದು, 22, Tuesday. Yes. You look into that judgment and come.
ಸರಿ ಸರ್.
2024 SSC online SC 730. ಹೆಂಗಂದ್ರೆ ಬರ್ಕೊಳ್ಳಲ್ವಾ? Shankar versus State of Karnataka. 2024 SSC online SC 730. Look at paragraph 15 to 21. Supreme Court says if there is independent eyewitness, it will be a reason to bring him back.
ಸರಿ
Otherwise, Constitution bench judgment covers.
ಸರಿ ಸರ್.
Under 319, what are the parameters?
ಓಕೆ ಸರ್. ಅಚ್ಚಾ.
Number 50 adjourn, 51.
50 are adjournment on. Oh, Dilip Kumar. Yes, yes, settlement.
For the petitioner notes. Lords,
Here, respondent.
last time they appeared and sought time.
Now they have not appeared, will grant time. In offense.
Lords, the offenses are
406, 420.
406, 420 and 504, 505.
Oh, is my detail order is there.
Lord, the facts are
Or ಬರ್ಬೇಕಲ್ಲ madam. Heard the learned counsel appearing for the petitioner Sridevi Bosley. There is no representation on behalf of the respondent complainant. As a last chance, let's this matter.
Serial number 57, my lord, I am for the respondent number 2, 57 serial number.
51, sir.
I'm sorry.
The
Lords, he's on the other side in 51 also.
51 ನೀವೇ ಇದ್ದೀರಾ?
Yeah, I'm sorry, yes, my lord, 51, I am for
57
the
ಅಂದ್ರೆ?
complaint. Yes, I am for the complaint, my lord.
ಅಲ್ಲ 51 57
One day, sir, 51 on there. I'm sorry.
51 sir, 7 ಅಲ್ಲ.
Yes, I'm sorry, my lord, I'm sorry.
Yes.
My lord, your lordship may kindly see.
No, wait. Yes.
No, before that, your lordship may kindly see, I have
You are
produced.
ready?
Because they have to
ready,
produce.
sir? Are you ready in the matter?
My lord, my submission is they have to, along with complaint, I have produced 16 documents, they have not produced those documents. Without those documents, matter cannot be heard, that is my humble submission, my lord.
You produce it. You produce it, sir.
Yes, on the next date, I'll produce it, my lord.
The
Because your
learned
lordship
counsel
kindly-
appearing for the second respondent submits that along with the complaint, the complainant had produced 16 documents which are not placed in the writ as annexures to the writ petition. He would therefore seek time to produce the same. Illust the matter on 9th July.
Grateful.
Interim order subsisting shall continue till the next date of hearing.
The ball complaint, my lords. Copyrights Act does not attract the.
Copyright Act does not, why?
My lords, I am running on a complaint, the FIR has been registered, my lords. Page number 18 is the complaint. It is a pro forma complaint wherein the it is been inserted, my only name of the accused is been inserted in handwriting, my lords. It is just a pro forma stating that all those companies have given them power to file a complaint. Kindly see page number 18. I, Himanshu Chaudhary, advocate so and so, this says, and overall India assist the enforcement authorities in conducting the raid actions and do all the necessary
Interim
acts.
order is granted on a particular premise. 4823 order, nodi.
Yes.
That prior permission is not taken.
Yes, my lords. On this, it's a covered by judgment also, my
ಕೊಡಿ
lord.
ಮತ್ತೆ
This
ಅಷ್ಟು
point-
ಬೇರೆ ಎಲ್ಲ ಯಾಕೆ ಹೇಳ್ತೀರಾ?
Please, my lords.
Yes, government.
Permission is not.
ಅದು ಒಂದೇ ಗ್ರೌಂಡ್ ಆದ್ರೆ ಹೋಯ್ತು ಅಷ್ಟೇ.
ಅದೇ ಗ್ರೌಂಡ್
only
ಸ್ಟೇ
ground.
ಕೊಟ್ಟಿರೋದು.
ಹಾ?
ಅದೇ ಗ್ರೌಂಡ್ ಮೇಲೆನೆ ಸ್ಟೇ ಕೊಟ್ಟಿರೋದು.
ಅದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ ಅಲೋ ಮಾಡೋಣ. ಎಸ್. The petitioner is before this court seeking quashment of the proceedings in CC 21775 of 2022 registered for offences punishable under so and so prayer lide madam. The learned counsel appearing for the petitioner would submit that a coordinate bench in identical circumstance in criminal petition 6096 of 2016 disposed on 28th February 2019 has held as follows. Has answered the issue that without obtaining prior permission as obtaining under subsection 4 of section clause 4 of section 115 of the Trademarks Act, if the complaint is registered, it would become an act contrary to law. The coordinate bench in the said criminal petition has precisely answered the issue inter alia. The coordinate bench is held as follows, para 2-2. End argument. In the light of the issue standing answered, as admittedly there is no permission taken or granted from the hands of the superintendent of police as necessary under clause 4 of section 115 of the Trademarks Act, which is interpreted by the coordinate bench, the petition deserves to succeed, and therefore the following order.
Obliged.
53.
As for the petitioner in this matter, my lord.
Hmm.
Offense under section 417 and 420 IPC, my lord.
ನಿಮ್ದು ಯಾವ್ದೋ ಒಂದು ಪಾಸ್ ಓವರ್ ಆಯ್ತಲ್ಲ, ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಇದ್ದಿದ್ದು
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಪಾಸ್ ಓವರ್ ಅರ್ಜನ್ ಆಗಿದೆ.
Settlement ಇದೆ. DP Act had appeared on behalf of the respondent number 2.
Anyway, let's see. Tell me.
The offenses punishable in section 417 and 420, my lord. So supply of materials, mere keep up the promising does not come under the purview of cheating. And
Purview of? Cheating.
Yes, my lord.
Why?
Because in this case is that, my lord, the respondent number 2 had placed an order for supply of steel, my lord.
Have you supplied?
I have not supplied.
Why?
And
How much money did you take for supply?
this is the 20 lakhs, my lord.
Ah.
The beginning I supplied the materials.
Hmm.
So in the,
When did you stop supply?
the second installment, my lord,
Second
the
innings.
second time,
Why did you stop?
there is some dispute with regard to supply of materials
ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ, ದುಡ್ಡು
between the
ತಗೊಂಡಿದ್ದು
petitioner and
ವಾಪಸ್ ಕೊಡು.
respondent number 2, my lord.
Give the money back.
No, there is some serious dispute between the parties.
What
Both are dealers, cement and steel supply dealers, petitioner as well as the respondent 2, my lord. Now, in this case, even except in the case of the prosecution, my lord, the incident had taken place in the year 2022. The complaint came to filed in the month of January 2023, my lord.
Hmm.
And to attack section 420 or 417, there must be a fraudulent or dishonest intention right
ಏನ್ ಬೇಕು
from the
ಮತ್ತೆ?
beginning of the
You have
transaction.
not taken
Here
money
the
and not
case only
supplied.
that
ಏನ್
we are
ಬೇಕು ಮತ್ತೆ?
not keep up the promise.
Not keep up promise, ಅಲ್ಲ sir. You have not, you have taken money and not supplied. What else you want, sir?
They ought to have filed the civil case, even except in the case of the prosecution for a moment.
Why?
That he cannot give the clock of criminal offense for the dispute, which is essentially civil in nature.
Oh, seriously?
And moreover, the delay,
What delay? 1 hour? Sorry, 1 year.
yes, almost 1 year.
Ah.
In this regard, I am relying on the judgment of Andhra Appeals Court in the case of Hasmukh Lal versus the state of Tamil Nadu.
Why? For what reason?
Because the delay is not properly explained, so it
Huh.
is fatal to the case of the prosecution.
Which year is that?
Your lordship kindly turn to page
Citation ಹೇಳಿ sir.
site 10, yes.
ಹೇಳಿ sir, ಕೊಡೋದ್ ಬೇಡ.
The Hasmukh Lal versus State of Tamil Nadu.
ಯಾವ ವರ್ಷದ್ದು?
The 2022, my lord. Para 23, my lord.
Drugs and Cosmetics Act.
Yes.
ಅದರಲ್ಲಿ limitation is already prescribed under the act.
The Hasmukh Lal versus Ora versus State of Tamil
Yes,
Nadu.
sir.
Yes.
ಅದರಲ್ಲಿ limitation is prescribed under the act itself.
Here in the case 23, para 23, it is clearly mentioned. There has been a gap of more than 4 years between the initial investigation.
ನಿಮ್ದು ಬರೀ
and
ಒಂದು
filing.
ವರ್ಷ ಬಿಡಿ.
Even after lapse of substantial amount of time, no evidence has been provided.
ಬಾಲಕೃಷ್ಣ ಅವ್ರೆ,
Yes.
ಅದೇನು ಓದ್ಬೇಡಿ. ಈಗ ತಗೊಂಡಾಗಿದೆಯಲ್ಲ ದುಡ್ಡು.
Yes. They ought to have filed civil case. How can you file the criminal case, my lord? Cannot give you clock of criminal offense. Even except for the case of the prosecution for a moment.
For a moment. Yes. Yes, state.
Not
Comment.
supplied the,
ಏನು
Not-
ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ, you should only
not supplied the steel, my lord.
not supplied steel.
Yes,
What steel? ನೋಡಿಲ್ವಾ?
next week any day.
Why?
File is not. I'll take instructions.
Page number 16 is the complaint, my lord.
ನೀವು ಹತ್ರ instructions ತಗೊಂತೀರಾ? Page number?
16 is the complaint, my lord.
Yes, sir. Where is the invoice?
Page number 18, my lord.
Charge sheet ಆಗಿದೆಯಾ?
Charge sheet has made one.
Page.
After filing of this petition, the charge sheet.
Charge sheet
came-
challenge ಮಾಡಿದ್ದೀರಾ?
Charge sheet is not challenged.
Why? You don't want me to answer the charge sheet. And ಯಾವ್ದು 2000 ಎಲ್ಲ judgments ಕೊಟ್ಟಿದ್ದೀರಾ?
It is Sagar Suri and another.
2000.
Yes. Yes, my lord. Then mansion house properties, private limited and others.
ಅದೇ ಬೇರೆ ಹೈಕೋರ್ಟ್ದು.
Yes.
ಮತ್ತೆ?
Kindly have it in next week, my lord. I'll look into the papers in next week. my lord.
Yes, sir. ನಿಮ್ದೇನಿದೆ ಬಿಡಿ. Private dispute. The petitioner is before this court calling in question registration of a crime in crime number 24 of 2023, registered for offences punishable under section 420 and 417 of the IPC. Heard so and so. The petitioner is the accused and the second respondent the complainant. The two are dealers who have mutual transactions between them. One such transaction becomes the subject matter of the present crime. The allegation of the complainant is that the petitioner, having received 20 lakhs by way of RTGS towards supply of certain material, has not supplied the same, and therefore he is wanting to register a crime seeking recovery of the said amount. The police register, the jurisdictional police, on the basis of the complaint, register crime in crime number 24 of 2023 for offences punishable under section 420 and 417 of the IPC. It transpires that during the pendency of the subject petition, the police have filed their charge sheet even. Though the charge sheet is not called in question, the filing of the same is taken note of. The will dismiss the petition, sir. Charge sheet challenge madilla.
Filing of the charge sheet will not come in the
That
way
I
of
know. You need not tell
the
me.
power under section 482.
No problem, but you should challenge the charge sheet.
But here in the case, it is
We are justifying your
not like that, my lord.
carelessness.
Not like that.
ಮತ್ತೆ ಮಾಡಿ ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಲ್ದೇ ಇರೋದು ಕ್ಯಾಲೆಸ್ನೆಸ್ ಮತ್ತು ಜಸ್ಟಿಫಿಕೇಶನ್. So and so. The learned, the registration of the crime itself had driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would contend that the complaint itself narrates that it is registered for the purpose of recovery of money, and criminal law cannot be set into motion for the purpose of recovery of money. He would seek to place reliance upon certain judgments which would bear consideration at the time, bear consideration qua their relevance in the course of the order. The learned counsel would further take this court through the documents appended to demonstrate that there are several disputes between the two, both of whom are dealers of certain products and have between them the demand and supply. The learned counsel would submit, seek quashment of the entire proceedings. The counsel for the complainant has remained absent throughout. This court on 12/6/2024 had passed the following order. Even today, there is no representation on behalf of the complainant. Therefore, the served unrepresented counsel idara. Behalf of the complainant. Therefore, the counsel for the petitioner and the state are heard. I have given my so-and-so. The transaction between the petitioner and the complainant, both of whom are dealers, is a matter of record. The issue now springs from a complaint registered by the second respondent. Therefore, I deem it appropriate to notice the complaint. It reads as follows, Madam, page 16, 17. Narration, after the narration in the complaint, what the complainant would seek is the support from the police for recovering 30 lakhs from the hands of the petitioner. Therefore, it is a clear case where criminal law is sought to be set into motion for the purpose of recovery of money. The documents that are appended to the petition would further demonstrate that financial transaction between the two, being dealers of a particular product, has gone on. ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದು?
3-4 years, ma'am.
Has gone on for the last 3-4 years between the two. Therefore, the dispute arising with regard to invoice and supply or short supply of certain material after receiving the amount, or the amount being amount to be recovered, cannot be made subject matter of a crime. It was always open to the respondent, second respondent, to register appropriate civil proceedings for recovery of money. The offences alleged in the case at hand are the ones punishable under section 417 and 420. Section 417 and 420 have their ingredients in section 415. Section 415 reads as follows. For an offense to become, for an act to become an offense under section 420, the dishonest intention of the accused against the victim should be from the inception. Here is a case where both are dealers and have financial dealing with the products between the parties. If the petitioner and the respondent have mutual dealings with them, between them, with regard to distribution of products, and one such going astray would not mean that the complainant would be entitled to, complainant would be permitted to initiate, set the criminal law into motion and further permitted to continue the proceedings. The issue in the list stands answered by several judgments of the apex court. Madam. So Lalit Chaturvedi 2024 SCC online SC page 114. Adon hakondiri Lalit Chaturvedi. So load cost. The quashment of these proceedings will not come in the way of the respondent initiating appropriate civil proceedings if need arises.
Yes, much job.
Yes.
54,
Charge sheet is ready. Charge.
ಈ ವಾರ ಚಾಲೆಂಜ್ ಮಾಡಿ ಅದನ್ನ. Yes,
Liberty maybe.
ಇದು last chance.
Last occasion they had not appeared.
What is this? ಯಾವಾಗ ಹಾಕಿದ್ದೀರಾ?
It is ready in the scrutiny.
Ready-ನಾ?
Scrutiny.
ಪರವಾಗಿಲ್ಲ ಹೇಳಿ. Yes, sir, come on.
Page number 13,
420.
please.
ಏನ್?
Page number 13 is the complaint, my lord.
What is the complaint about?
Accused, petitioner is the accused number 2 in the complaint, FIR, my lord. The complaint against the accused, my lord, this petitioner has given the phone call to the concerned bank, complainant bank manager, and asked the person to grant loan while pledging the gold by the accused number 1, my lord. Based on that, they have issued a loan.
Spurious gold,
As per the complaint, my lord, it is subsequently they got to know that it is not gold. The only allegation against this petitioner, my lord, particularly, he had phoned to the concerned bank manager and instructed him to grant the loan. Subsequently, my lord, on 13/2/2023, the same gold were released, and subsequently, once again, he pledged the gold as per the complaint statement. At the first instance, as per the complaint, he has instructed the concerned bank manager to grant loan. Subsequently, on several occasions, he has pledged the gold, and after a lapse of 1 year, they got to know that the said, while auditing, they got to know that the said gold is not gold ornaments, and lodged the complaint against this petitioner. Particularly, my lord, against this petitioner, only allegation, my lord, he has telephoned to the concerned bank manager and instructed him to grant loan. He is nowhere concerned, neither he has received.
charge sheet material ಕೊಡಿ.
ಬಂದಿಲ್ಲ. Charge sheet material ಇಲ್ಲ. Ready ಆಗಿದೆ ಅಂತ instruction.
Get the material, please. I'll take this on Tuesday.
Please.
Wednesday. List the matter on Wednesday. The state is directed to place the charge sheet material to point at the offense, point at the role of the petitioner in the alleged crime. Let me see.
Please.
Fifty-five,
For the petitioner. Worship 323, 324 and 354, 504, 506. The dispute between the brother and sister, your lordship. The property was bequeathed by the father of the brother and sister. The civil dispute was arisen, wherein my lordship, OS number 25692 is pending consideration for declaration and injunction. Lordship, there was a proposal for compromise. The land civil judge directed the parties to settle the matter since both are, my lordship, the brother and sisters. Next day, my lordship, complaint has been given against the petitioners.
Where is the direction?
Oral direction, settle ಮಾಡ್ಕೊಳ್ಳಿ ಅದಲ್ಲ.
ಯಾವ ಕೇಸಲ್ಲಿ?
OS sir, ಅವ್ರು ಹಾಕಿರೋ
OS sir.
OS. Marshal, kindly come to page 30.
ಇದು settle ಮಾಡ್ಕೊಳ್ಳಿ.
In fact, matter was heard last week, lots. There was some settlement proposal I've given. The will is very clear. It doesn't have any room for interpretation. What we have told is they're occupying the portion which is bequeathed to us. He says you give up that area. We said that area is already bequeathed to us. It doesn't require, it's a registered will.
Your brothers.
Brothers and sister. It's a registered will. He's also in occupation of the other portion of the will which he has not challenged till date. All that I'm saying is take some time and give me the portion and I'm okay with that.
ಇದು ವಿಲ್ಲು ಲಾಂಗ್ ಬ್ಯಾಕ್ ಮಾಡಿದ್ರು. ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಬ್ರದರ್ಗೆ ಸರ್, ಫಸ್ಟ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ ಒಂದು ಬೆಡ್ರೂಮ್ ಬ್ರದರ್ಗೆ.
ಇದೆಲ್ಲ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಏನು ತೀರ್ಮಾನ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
Criminal case.
Criminal case. Why do you want police to deal with all this?
It's not that.
Kindly
what has happened on the particular date? There's also a 39 rule 2A against the said sister. There are several instances of some kind of nuisance that's happening. On one day, Lords, there has been an altercation where they've assaulted the said respondents. And there's also wound certificates produced. It is the only case is that there is only minor abrasion and there's a thing, but it's not an grievous.
All that is fine. Brother and sister, why do you want to fight? What is all this?
Kindly.
Being a beneficiary of the will, they also not.
ನಾನೊಂದು ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಏನಂದ್ರೆ ಅವರು ಫಸ್ಟ್ ಫ್ಲೋರ್ ಅವರೇ ತಗೊಳ್ಳಿ, ನಾನು ಸೆಕೆಂಡ್ ಫ್ಲೋರ್ ಮೇಲೆ ಒಂದು ಕಿಚನ್ ಕಟ್ಸ್ಕೊತೀನಿ ಅದಕ್ಕೆ ಪರ್ಮಿಷನ್ ಕೊಡಿ ಅಂದ್ರೆ ಕಟ್ಕೊಳಲ್ಲ ಅಂತಾರೆ ನನಗೆ ಕಿಚನ್ ಇಲ್ಲ ಅದಕ್ಕೆ
They have a kitchen on this. I see this.
ನಾನು ಅಷ್ಟೇ ಪ್ರಪೋಸಲ್
very
ಇರೋದು ಬೇರೆ
And in
ಇನ್ನೇನ್
fact-
ಕೇಳ್ತಾ ಇಲ್ಲ ನಾನು ಸೆಕೆಂಡ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ ನಾನು ಕಿಚನ್
ಟೇಕ್ ವಾಟ್ ಎವರ್ ಯು ವಾಂಟ್. ಅಲೋ ಹಿಮ್ ಆರ್ ಹರ್ ಏನಿದು?
ಸಿಸ್ಟರ್ ಸ್ವಾಮಿ ನಾನು
ಅಲೋ ದ ಸಿಸ್ಟರ್ ಟು ಬಿಲ್ಡ್ ಅ ಕಿಚನ್. ಎಲ್ಲ ಸರಿ ಹೋಗುತ್ತೆ. ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್?
What my client instructions is as per the will.
You are behaving as though husband and wife's inflated ego ತರ ಆಡ್ತಾರೆ.
There is no inflated ego is what this. What he says is as he has also got a floor as per the will. And he's also not challenged the will. It's only one room which is given to us, which he is in possession for a long time.
It's all right. Now sit across and settle.
ಅದನ್ನ ಕೊಡ್ತೀವಿ ಅವ್ರು ಒಪ್ತಾನೆ ಇಲ್ಲ
Kitchen
If they want to meet directly and have a discussion, I have no objection. They only
meet
discuss.
directly ಅಂದ್ರೆ how indirect?
Let them meet at the mediation center because OS suit pending
mediation
is there.
Who is where? How are they meeting?
Lots, what has happened on the on the original suit side, we made a submission that
I
let
think
them,
go before the mediation center.
let them feel, let them approach the mediation.
Mediation ಬೇಡವಾ?
ಅಲ್ಲ ಮೀಡಿಯೇಷನ್ ಇಲ್ಲ ನಮ್ ಫ್ರೆಂಡ್ ಮನಸ್ಸು ಮಾಡಿದ್ರೆ ಆಗುತ್ತೆ ಇವ್ರು ಆಗ್ತಾ ಇಲ್ಲ
ಇವರೇ ಅಡ್ಡ ಬರ್ತಾರೆ ಅದು. What is this, Mithun?
I don't know. This is something which.
No, it is not an allegation, Your Lordship.
On the last occasion, in fact, the matter was heard and it was going to be disposed of. I said it's okay. Let the matter be settled. Even now, I have no issues.
See, it's not like that.
ಸ್ವಲ್ಪ ಕನ್ಸೆಷನ್ ನೋಡ್ಸಿದ್ರೆ ಸೆಟ್ಲ್ ಆಗ್ಬಿಡುತ್ತೆ
He wants me to prevail upon the.
No, prevailing illa. Let the parties decide.
That's why I said let the parties meet and decide. Lords. I have nothing to.
Go to the mediation center. Then ಆಮೇಲೆ ನಿಮ್ಮೆಲ್ಲೇ ಹಾಕ್ತಾರೆ ಯಾಕೆ? Parties decide. Both the parties to the petitioner and the complainant are brother and sister. They are fighting over a portion of the property which forms the fulcrum of a will. The learned counsel for the petitioner submits that he is given the first floor
Please.
without a
Portion,
kitchen. Portion of the first floor without a kitchen. And he wants to, and the sister wants to construct a kitchen.
in the second floor
In the second floor for the usage of, for her usage, as there is no kitchen in the first portion that is bequeathed to her, which is not permitted by the brother. And therefore, the criminal law is set into motion. The charge sheet is also filed by the police. It is brother and sister. So and so. Therefore, the parties are directed to appear before the Karnataka Mediation Center on next Wednesday hogi. On next Wednesday date nodi madam at 3 p.m.
Please. Lords.
to explore the possibilities of resolution of a trivial dispute between them. Yes,
People.
list the matter on 28, list the matter on 2nd July.
interim
3rd
order.
July.
Interim order.
Interim order subsisting shall continue till the next date of hearing.
Good. I represent.
Short accommodation. senior-
Objection ittala.
Yes,
Yen
my lord. Last occasion also, he has taken the time, my lord.
Last
Say
occasion
498 ena.
306, my lord.
Not 6.
The detail, interim order only, detail
Interim
order
order
is
ಯಾರು?
passed.
My
Interim order
interim
is
order.
Yes, my lord.
Death note ಇದೆ.
Death note is
Video is
even in
also
death note
secured.
also. My lord, the relationship between this part, they are not family members. They are completely outsiders. My lord, the relationship is between deceased with one Shilpa. And they wanted to marry each other and they later, due to the difference in religions, they fall apart and they married in different persons. Thereafter, my lord, now this particular petitioner wanted to inform the house of the deceased.
Date of death ಏನು?
My lord, on,
2021 incident ಗೆ 2022 ಅಲ್ಲಿ death
yes,
and 306.
yes. Detail order has been passed.
21 crime registered.
21 ಅಲ್ಲೇನೆ.
Yes, sir.
Kindly have it on Saturday, Lordship. We'll file the objection.
Even in the last,
Objection ಹಾಕ್ಬೇಕಾ?
like, even in the last
ಹಾಕ್ಲಿ
occasion.
ಬಿಡಿ interim order ಇದೆಯಲ್ಲ.
Alla, let him, he has taken 20 days on the last occasion, my lord.
We'll grant him
30 days,
another 10 days. ಏನಾಗುತ್ತೆ?
Interim order is.
The interim order is final order, sir, unless you bring something, because a detailed interim order.
Sought for some documents, Lordship. from
I-
the-
The counsel for the respondent seeks time, yet again. List this matter as a last chance on the 3rd of July. In the event no submission is made, the petition would be answered on the submissions of the learned counsel for the petitioner. List on third, interim order subsisting shall continue to the next date of hearing.
57.
Three not four B minutes. 304B. Petitioners are the, first petitioner is the
Husband,
father minutes. Father of the accused number one, husband is not before this.
stay ಕೊಟ್ಟಿಲ್ವಾ?
No stay.
ಯಾಕೆ ಫಾದರ್ ಮೇಲೆ ಏನಿದೆ? ನೀವೇ ಟೈಮ್ ತಗೊಂಡಿದ್ ಲಾಸ್ಟ್ ಟೈಮ್.
Please, my lord. My lord, in this matter, my lord, charge sheet is already filed, my lord. There is death note is also there, my lord, in this, which they themselves have produced along with the
ಇಲ್ಲ
petition.
ಡೆತ್ ನೋಟ್
This is suppression of death note, my lord, that is the contention from the petitioner from the day one, from the day of registration of the crime.
ಡೆತ್ ನೋಟ್ ಏನಾಗಿದೆ?
Death note ನಾವು ಅವ್ರಿಗೆ ತಗೊಂಡು ಕೊಟ್ಟಿರ್ತೀವಿ ಸುಮ್ಮನೆ ಆಮೇಲೆ they thrown it, my lords. They torn.
Is
they
this
thrown
death
it.
note is here?
This death note is produced by the petitioner, my lords. Even from the stage of bail, also the bail proceedings. Our contention that, my lords, the deceased herself has consumed the carbomet poison and she committed a suicide by
Husband is not before the court.
husband is not before this honorable.
ಇಲ್ಲ ಈ ಫೈಂಡಿಂಗ್ ಹಸ್ಬೆಂಡ್ ಹೆಲ್ಪ್ ಆಗ್ಬಿಡುತ್ತೆ.
Will not file any petition before this honorable court, my lords, on behalf of petitioner. Even the accused number one is ready to face the trial, my lords. The father is aged about 83 years. Their allegation is that, my lords, at the age of 83 years, I have demanded the 5 lakhs rupees for the purpose of running a matrimony website. That is the allegation, my lords.
That I have seen. Who is the second petitioner?
Second petitioner is the sister of the accused number one, my lords. In law.
ಅಲಿಗೇಷನ್ಸ್ ಏನಿದೆ ಹೇಳಿ? 304B ಗೆ.
Please, my lord.
ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್ ಬೇಕಾ? ಇಲ್ಲಿದೆ.
Yes, my lord. They have produced the charge sheet.
ಅವರೇ
Page
ಪ್ರೊಡ್ಯೂಸ್
number 33.
Your
ಕಲೆಕ್ಟ್
lordship-
ಮಾಡಿದಿರಲ್ಲ?
Your lordship has
my
directed
lord,
them
they
to
have
last
challenged
occasion to
the
produce the entire charge
entire
sheet. We have also
proceedings.
produced it, my lord.
Yes. Yes, Tejesh, ಹೇಳಿ.
Please, my lord, in the charge sheet, the page number
Come to
33,
page
my lord.
33. ಇವ್ರ ಮೇಲೆ ಇರೋದು ಅಷ್ಟೇ. They demanded more money.
On account of demanding only, my lord.
213 ಆರೋಪಿಗಳು ಮ್ಯಾಟ್ರಿಮೋನಿ ನಡೆಸಲು ತವರು ಮನೆಯಿಂದ 5 ಲಕ್ಷ ಹಣವನ್ನು ಹೆಚ್ಚುವರಿ ವರದಕ್ಷಿಣೆ ತರುವಂತೆ.
Yes, sir. ಟ್ರಯಲ್ ನಡೀತಾ ಇದೆಯಾ?
No, my lords. Really.
Stay has been,
ಸ್ಟೇ ಇದೆಯಾ?
Stay ಇಲ್ಲ, stay ಇಲ್ಲ.
ನೋ ಎಂಟ್ರಿ ಮಾಡಿ.
no increment. Stage is
Pending
for
for
framing of
HBC.
charge.
Pending for HBC.
This first petitioner we will stay. 84 years.
Second petitioner, my lord, she is residing separately. And the charge sheet, they show that she is also residing with the accused number 1 and 2. That is their allegation.
Where, what material do you have to show?
No, my lord, nothing. They have examined the 2 witnesses of the name.
ನೀವು ಆಚೆ ಇದ್ದೀರಾ ಅಂತ ಎಲ್ಲಿದೆ ಮೆಟೀರಿಯಲ್?
They have taken that contention, my lords, but we have
Contention
not produced any.
Contention ಆಗಲ್ಲ because there is evidence that you are staying there. Yes, this the matter on 5th July. The learned HCGP to go through the papers in and make his submissions. Respondent yaru?
Respond.
Third, my lord, I think.
Brother,
Served,
of the deceased. Served, my lords.
Unrepresented. Since the respondent is served unrepresented. A perusal at the summary of the charge sheet would indicate the petitioner number 1 having no capacity to allege, or having no capacity to perform any overt act as he is 83 years old. The allegation against him is that he has demanded 5 lakhs from the hands of the deceased wife of the accused number 1 for setting up a matrimonial website. The learned counsel would submit that the husband is ready to face trial. As he is not before the court. But trial should not be permitted against the petitioner number 1 and the second petitioner. Finding prima facie no material against the petitioner father-in-law for offences under section 498A or 304B, and merely because section 304B is invoked, it is not that a person who has no allegations against him should be permitted to be tried. Therefore, there shall be an interim order of stay only against the first petitioner, the father-in-law, till the next date of hearing. ಈ application ಇಲ್ವಾ? ನೋಡಿ ಇಲ್ವಾ? ಸುನಿಲ್, stay application ಇಲ್ವಾ?
Apologies, madam. Last date also, your lordship had about to declare they are.
ಮೇಡಮ್, ಲಾಸ್ಟ್ 2 ಲೈನ್ ಮಾತ್ರ ತೆಗೆದು therefore list this matter on 5th ಕತೆ ಎಲ್ಲ ಹೇಳ್ಬಿಡಿ. ಆಮೇಲೆ therefore list this matter on 5th. ಇಲ್ವಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಅದಕ್ಕೆ. ಹಾ?
I'm apologizing. Because we want to dispose it of, because his health is deteriorated.
What to do, sir? Yes. Next.
For petitioner, 447, read with 34.
Respondent.
Last date itself, my lords, final opportunity.
My order.
Please, my lords.
8/6/2023. Not represented. ಬರೋದಿಲ್ಲ.
Interim order dated 8/6/23.
You are still in possession?
Please.
What is the suit pending?
Lords, RFA pending, my lords. With regard to this.
RFA, why?
My lords, a suit which was filed by the petitioner herein was dismissed, my lords. Lords, the dispute is between the societies.
But what was the suit for?
Suit for injunction, my lords. Suit for injunction, the dispute is between the society.
Not declaration.
Not declaration.
So you are in possession of the property.
My lords, NTI society ಅಂತ ನನಗೆ allot ಮಾಡುತ್ತೆ.
NTI society da idu. Who is the complainant?
Complaint is the Shantivana Society allotee.
Yes.
Up to date tax paid, my lords. BDA.
I know, that's all right, but this man, the Supreme Court ತಗೊಂಡ ಕೇಳಿಲ್ಲ ಅಂತಾರ ಆಮೇಲೆ. Yes. This court on 8/6/2023 had granted the following interim order. On 29/5/2024, owing to the absence of the second respondent, the court had passed the following order. Even today, there is no representation on behalf of the second respondent. List the matter on next Wednesday as a last chance. In the event the respondent would not appear, the petition would be answered on the submissions made by the learned counsel for the petition. In the event the respondent would not appear, ಹೇಳಿದ್ನಲ್ಲ? In the event the respondent would not.
Grateful.
39.
This is a case of road rage.
ಏನ್ ನಿಮ್ದು ಇವ್ರ್ದೇನಾ ಎಲ್ಲ?
The date given matters. On 29.
Innova car.
Innova car. Road rage, and he shown the identity.
ಇದು
card of-
respondent ಯಾರು?
Respondent is
Represented. Same order ಮಾಡಿ. 29/5 ಗೆ. This court on 29/5/2023 24 had passed the following order. The respondent number 2 was not present. Counsel for the second respondent was not present. Even today, he is not present. Therefore, as a last chance, ಅದ್ರಲ್ಲಿ ಹೇಳದ್ನಲ್ಲ madam.
The Article 61.
In this case. Respondent number 2 in this matter.
My lord, respondent number 2 has filed the private complaint, my lord, against the accused number 1, my lord, and this petitioner is accused number 2, my lord.
Accused number?
2, my lord. Accused number 2, my lord.
Offense.
Offenses.
406, 420, yeah?
Please, my lord.
Yes, sir.
My lord, he has purchased the property, my lord, from the accused number 1, my lord, in the year 2001, my lord. Thereafter, my lord, in the year 2006, my lord, he has sold the property to the respondent number 2, my lord.
Who?
Respondent number 2.
Who has
This
sold?
petitioner. The accused number
You
2.
purchased it from accused number 1.
I have purchased from the accused number 1.
When?
2001, my lord.
Date?
Annexure C.
Date ಇಲ್ವಾ ಅದಕ್ಕೆ?
17/8/2001. Thereafter, my lord, after lapse of 5 years, my lord, in the year 2006, my lord, 6/4/2006, my lord, I have sold the property to the respondent number 2.
6/4/2006 to the complainant.
Yes, please, my lord.
Yes.
In the meantime, Lord, I have applied for the Kata. Kata has been registered in my name, Annex D. 15/10/2001, Lord. Annex D.
Yes.
The Kata has been issued by the Purasabha Karyalaya, Holenarsipura.
Aye.
The very same authority has, my lord, in the year 1984, they have acquired the very same property. Thereafter, my lord, the coming
So
to.
according to you, A1 has sold you an acquired property
Please, my lord.
and you have sold it to the complainant.
I have purchased the property from the A1.
Adane nanu
I could not know, my lord.
is what I told you.
Please, please,
A1 has sold the property to you.
please, my lord.
You did not know that it was acquired.
Please, my lord.
You sold it to the complainant.
Please, my lord.
All right.
Thereafter, my lord,
So according to you, A1 is the culprit.
please, my lord, A1 died, my lord. Death
A1
death certificate produced, my lord, Annex F, my lord.
My lord, the thing is that A1 and A2 both were friends. They knew that.
No property ಮಾರಿದ್ರೆ ಆ 5 ವರ್ಷ ಆದ್ಮೇಲೆ he has purchased it.
Yes, my lords. But acquire ಆಗಿರೋ ಲ್ಯಾಂಡ್ಗೆ ಖಾತಾ ಮಾಡಿ ಆ ಖಾತಾನ ಇವ್ರು ಬದಲಾಯಿಸ್ಕೊಂಡು ನಮಗ್ ಸೇಲ್ ಮಾಡಿದಾರೆ. Knowing that after 5 years, lapse of 5 years, he's owned.
No, he says 17/8/2001 he has purchased it.
Yes, my lord.
ಖಾತಾ is changed on 15/10/2001. Acquire ಆಗಿದೆ ಅಂತ ಯಾರಿಗೆ ಗೊತ್ತು?
My lords.
ಅವ್ರು ನೋಡಿಲ್ಲ.
And private complaint filed in the year 2018, my lord.
My lord, that is because
After lapse of.
ಯಾವಾಗ ನೀವು
the complainant's son is a retired, he was in the army. After he got retired, he wanted to construct a house. That's when he went to get a survey done. That's when he got to know, he's got an endorsement saying that this property was acquired in the year 1984 and 85 itself, my lord. He's got an endorsement. That's when we got to know that this property is already acquired by the government. Until then, we had no knowledge of this, my lords.
Allegation in the complaint is that, my lord, the acquisition of the land by the local authority, Purasabha office, my lord. The very same authority has issued the Kata in my favor, my lord. After lapse of 30 years.
This is total negligence on the part of the officers. ಇವ್ರೇನ್ ಮಾಡಕ್ಕಾಗ? ಇಲ್ಲಿ ಸೇಲ್ ಆಗಿರೋದು 2006 ಅಲ್ಲಿ.
Yes, my lords.
2018 ನಲ್ಲಿ private complaint ಆಗ್ತದೆ.
In 2018 is when
After
I
lapse
got
of-
retired, and that's when I came back to Karnataka, and that's when I tried to get
After
a house with the
lapse of
property.
18 years.
That
He
property was
did
not
not
my.
know the fact is clear from he has applied for Kata and it is changed in his name. He has been there for 5 years.
My lords, our contention is that they both were friends. They knew that this was the scenario, and that's why they sold it to us.
Difficult. For cancellation of sale deed you have to file. ಅದಾಗಲ್ವಲ್ಲ ಈಗ?
ಅದಆಗಲ್ಲ.
ಅದಕ್ಕೋಸ್ಕರ criminal case.
My lords, but
Yes, sir. What is the explanation for delay? Where is the affidavit?
There is no delay, there is no affidavit.
Private complaint affidavit ಅಲ್ಲಿ.
No affidavit, my lord.
And where is the pleading that you have tried to register the complaint before the police? ಠಾಣೆಗೆ ದೂರು ನೀಡಿದ್ದು ನಗರ ಸೊ ಇದೆ ಬಿಡಿ. ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ, ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಬಗೆಹರಿಸಿಕೊಳ್ಳಿ. Anything else? The petitioner is before this court calling in question proceedings in CC 256 of 2020 registered for offences punishable under section 417, 420, 423, 406 of the IPC. Heard so and so. There are 3 protagonists to the subject crime. Accused number 1, the present petitioner. ನೀವೇ accused number 1.
Accused number 2, my lord.
ಮತ್ತೇನು ಬನ್ನಿ ಇಲ್ಲಿ petition ನೋಡಿ.
ನಾನು ಬರ್ದಿರೋದು.
Accused number 2, sorry, my lord. Accused number
ಮತ್ತೆ
2.
ನಿಮ್
The
pleading
PCR
ಯಾರು?
it is shown in the.
What's your name? Rishiketu.
Rishiketu.
The petitioner, accused number 2, one H.B. Manjunath, accused number 1, and the second respondent complainant. The accused number 1 was said to be owning certain property in site number 6311, survey number 213 of 213 in Dakshina Kasaba Hubli, Holenarsipur Taluk, Hassan district, measuring 30 into 40. The accused number 1 sells the said site in favor of the present petitioner, accused number 2, on 15/10/2001 by executing a sale deed on 17, executing a sale deed. The petitioner, after being in possession of the property for 5 years, the petitioner immediately changes the khata to his name, and the same is done by the Holenarsipura municipality. After about 5 years of holding the property, sells the property in favor of the complainant on 6/4/2006. The complainant is said to have been in possession of the property from 6/4/2006. A complaint emerges on 5/11/2018, 12 years after the complainant coming into possession of the property, alleging that the accused number 2, the present petitioner, has sold a property to the complainant which had already been acquired by the Holenarsipur municipality. The complaint, the learned magistrate refers the matter for investigation under 156(3) of the CRPC, and the police, after investigation, file a charge sheet against all the accused and the matter is pending in CC 256 of 2020.
No, my lord, not referred to this. Directly took the cognizance.
156 ಆಗ್ಲಿಲ್ವಾ?
No, my lord.
ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. ಏನೇಳಿ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ ಬೇಡ ಅದಕ್ಕೆ ಮುಂಚೆ. The learned magistrate then, after holding an inquiry as obtaining under section 202, takes cognizance of the offence and registers CC 256 of 2020 for offences punishable under il prayer lideyal. The issuing of summons against the petitioner is what has driven him to this court and the subject petition. The learned counsel appearing for the petitioner would vehemently contend that there is no element of cheating as is alleged in the case at hand. The petitioner is a purchaser from the hands of accused number 1, and after 12 years of the sale, the complainant has registered the crime, as all cause of action to initiate civil proceedings have died. The learned counsel would submit that if the further proceedings are not, if the proceedings are not quashed by the petitioner, it would become an abuse of the process of the law. Per contra, the learned counsel appearing for the second respondent complainant would contend that the complainant did not know the ploy of accused number 1 and 2, who are friends and have sold the property to the complainant. The complainant comes to know of the acquisition only when she wanted to construct the house in the property. It is then the complaint is registered, noticing the fact that a property that had already been acquired has been sold to the present complainant. I have given my so and so. Therefore, narrated facts are not in dispute. The petitioner is accused number 2, purchases a property from the hands of accused number 1 on 17/8/2001. The municipality, Holenarsipur, the competent authority, transfers the khata in favor of the present petitioner on an application looking into the sale deed dated 17/8/2001. After about 5 years, the petitioner executes a sale deed in favor of the complainant on 6/4/2006. The sale deed, 6/4/2006. The complainant remains in possession of the property up to 5/11/2018, on which day a private complaint is registered by the complainant. alleging that the the accused, both 1 and 2, have together colluded and sold a property that was already subject matter of acquisition in the year 1984 itself. And therefore the matter has to be investigated into. The learned magistrate does not refer the matter for investigation, but conducts an inquiry under section 202 of the CRPC and then takes cognizance of the offense and issues summons for the aforesaid offenses. The issue now would be whether in the peculiar facts of this case, the criminal case should be permitted to be continued. The offenses are the ones punishable as aforesaid. The petitioner is a purchaser from the hands of accused number 1. The accused number 2, the petitioner sells it to the complainant in the year 2006, 5 years after him being in possession. All the documents necessary to prove ownership were in the name of the petitioner. Therefore, the sale deed is executed and there was no problem up to 2018. 12 years after the sale, as every other cause of action to initiate civil proceedings against the accused had by then elapsed, criminal law is sought to be set into motion. There is no explanation with regard to why for 12 years the complainant kept quiet, even without verifying with regard to the documents that led to registration of the sale deed. It is presumed that at the time of execution of the sale deed, the complainant had indulged in due diligence with regard to the property being subject matter of acquisition or any other impediment for the registration of the sale. That having taken place in the year 2006, a complaint being registered in the year 2018, alleging that the petitioner has sold a property that was acquired by the municipality Hole Narsipura, would not mean that the proceedings should be permitted to continue. It is the very authority, i.e. the Hole Narsipura municipality, have issued all the documents in favor of the petitioner to mean that he is the owner of the property, free of all encumbrances. If that be so, a matter of 12 years vintage cannot be given life by an order of this court for permitting further proceedings to continue. The delay is not satisfactorily explained for this court to permit continuance of CC 256 of 2020. The issue, if further proceedings are permitted, it would run foul of the judgment of the apex court in the case of Chanchalapati Das versus State of West Bengal, reported in 2022 SSC Online SC page 23, SSC Online SC page 650, wherein the apex court has delineated that unexplained delay would be fatal to the case of the complainant. The issue in the list is also an unexplained delay or the shoddy explanation of delay as is found in the complaint. For the aforesaid reasons, the following got allowed quashed.
Lord
498A. Lord, husband, father and mother, Lord, are before your
Husband is
lordship.
here.
Lord, because it was a love marriage, Lord, he is.
So
before it.
husband is here.
But generally, Lord, the love marriages, Lord, take place like, Lord, they like each other much prior to the marriage, and Lord, in the mindset that they want to marry with each other. Nothing else in their mind, Lord.
So according to you, nothing, everything
As such, yes.
nothing fades away.
No, Lord, so far as the allegation of dowry is concerned, Lord, on that count.
Love marriage or dowry ralam.
Yes. Now, Lord,
The Lords permit me.
in that context, Lord, the petitioner and the respondent number 2, husband and
Only torture will be there.
Lord, there was no, in fact, no torture also, minor discord. Lord, that was, Lord, that led her to, Lord, pressurize the husband to leave the house or leave the parents and, Lord, make a separate house, for which he refused because of the medical requirement of the father.
What
Lordship,
happened?
Kindly see page 65, Lord, for a moment. Page 65. Lord,
What is this?
he is the father of the
Huh?
petitioner, yeah.
He's undergoing some test or he's like this only?
He is like this since more than, now Lord, please see, this is of 2021, marriage is of 22. Lord, and vague allegations, Lord, raised in the complaint against such person that he peeps into the room, that he peeps into the room when she is sitting alone. Lord, he hardly walks.
If you lots permit me.
Now, this
first, like-
shows, Lord, how exaggerated and omnibus allegations are raised, only to harass. Why? Because husband did not wanted to leave this parent because he has to take care of him.
Yes, sir.
Your Lords, the allegations that have been made by the petitioners herein are all brought up into this criminal petition, Your Lords. In the way there was a domestic violence case that's been going on before the learned magistrate. They themselves have admitted that the said marriage is a arranged marriage. And regards to the concept that they're bringing that it's a love marriage, I would like Your Lords may.
Where has he admitted, sir?
In this one, Your Lords.
Where is that?
2 minutes. 2 minutes, Your Lords. I'll just show, I have the copy of the CMS petition, sir, wherein in their statement of.
Where is your file?
Please, Your Lords. Please, Your Lords.
You came for adjournment, is it?
No, Your Lords.
Then?
I was prepared, Your Lords.
Then file alli preparation illi. Yes.
Maybe he is misreading that marriage was arranged in a simple ceremony, not an arranged marriage. Nevertheless,
So what you mean to say is,
please, Lord.
it was love that led into arrangement of marriage.
Yes, it was under the
And not
pressure.
arranged marriage that led into love.
It was, in fact.
Mm.
But that unfortunate discord, Lord, minor discord, in fact.
Final
Not that.
card.
Discord. between-
Discord.
Yes.
Yes, sir.
Your Lords, if Your Lords permit me, I'll just state all the events in a chronological
Then
style,
first
including
ಹೇಳಿ.
the love
Give-
marriage. act,
give
Your
act
Lords.
ಹೇಳಿ first ಕೊಡಿ.
That's all.
Where is the admission that the marriage was
It's not, I have Your Lords, I have it over here.
And Lord, there are so many chats to show that they were in love before marriage.
chats?
WhatsApp chats.
We have also WhatsApp chats pertaining to the same, Your Lords.
Chats versus chats. Yes. Yes, sir. But what do you say about this photograph?
Your Lords, pertaining to the photograph, that's what if Your Lords permit me, I'll state all the events in a chronological manner, which will help me assist the court to cast away the clouds that have been casted by the petitioners, Your Lords. That's, I just seek a 5 minutes time, Your
No
Lords. not
problem.
for-
We'll hear till it is cast away. Yes.
Please, Your Lords. Your Lords, the main issue that's been raised by the petitioner in the writ petition is that we have not followed the due procedure while registering a complaint against the petitioner under the section 498A, Your Lords. In regards to which, I'll just set the chronological aspects, what has happened till now. 21/1/2022, the marriage between the petitioner and was solemnized. Prior to the said marriage, the petitioners have clearly stated that they wanted to have a lavish engagement ceremony, because of which the widow mother of the petitioner, respondent number 2, has complied with that demand and further also paid a sum of rupees 15 lakhs along with the additional jewelry. Soon after their marriage, the petitioner, on the instigation of the petitioner number 2 and 3, had started taunting the respondent number 2, wherein he has stopped her from pursuing her final year MSc, her studies, Your Lords. Later on, they even took the forceful possession of all the articles that was there in the petitioners of the respondent number 2. Thereafter, on 16/4/2022, the petitioner, the respondent number 2 got to know that she was conceived. The respondent number 2 thinking that as she was conceived, this would create a hope for her that the petitioners and the family members would revise from their behavior. Yet again, I was clear a victim for the cruelty and harassment, wherein they used to harass me both physically and mentally, your lords. In regards to that, they have not even concerned about the unborn child that is still I have conceived, your lords. In regards to that, your lords may take my statement of objection. your
You
lords.
narrate the stories.
Thereafter, in the petition number 1, in order to avoid his legal responsibility, has called my mother, the widow mother, wherein in my family it solely consists of me, my widow mother, and my younger sister. I have no male member in the family. Have called my mother, stated that he has no interest to bear any expense towards the child or me. So he has clearly asked my mother to come pick me up and take care of all the delivery. He's least bothered about it. When my mother had come, when my widow mother had come before this, before the husband, he started making a ruckus, your lords. He started abusing me. Even he assaulted me in front of my mother and this sister, your lords, the family members. Thereafter, when the sore thought, when I had returned back to my mother's family, the petitioners nor the family members have even looked or bothered to check about my well-being. They have completely deserted me. I have made various attempts to contact them. They have not even bothered, your lords. Thereafter, on 10/7/2022, the father of the petitioner, that is the petitioner number 2, your lords, had called me, stated that if I wish to recohabit with the petitioner, then I have to bring all my original documents, including the Nikanama, all my other marriage certificate, PAN card, and also demanded additional jewelry, your lords. If I am able to comply with this demand, then itself I can come and recohabit. Me, with the hope, I went again to the house of the petitioner, wherein the petitioners, that is the petitioner number 2 and 3, on the instigation, to forcefully took the possession of the additional jewelry that I was having in. Also got this affected into the writing by forcing me, your lords. Thereafter, I was allowed to stay at the petitioner's house. On 12/7/2022, when the issues were getting out of the hand, the uncle, who also happens to be the good friend of my mother and also the good friend of the petitioners, tried to mediate the said issue. When the said issue was tried to resolve, the petitioner, number 1, taking it on his ego, started harassing me, wherein he clearly stated that he wanted all the jewelry, including the mahar that was given to me, which is already in his custody. There is a clear way he has demanded for all the jewelry. When I was not able to comply the same, he started assaulting me in front of everyone, your lords. In order to avoid this aggression, for my sake and for my unborn child, I had to immediately leave the petitioner's house. Immediately, the Hoysala, which was on the patrol, had intervened and inquired about the said incident.
Patrol.
Yes, your lords, on the patrol lane.
Patrol. Petrol.
Thereafter, they have immediately shifted me to, based on my condition that I have been assaulted, they have immediately shifted me to a nearby hospital. The wound certificate is there, your lords, and the requisition, your lords. I've also included the copy in the statement of objection, your lords. Thereafter, your lords, I've included the document number R2 and 3, your lords.
You are the husband.
R2 and 3, your lords. The document number R2 and 3, lords. Every allegations that I've made is being supported by the evidence, your lords. My statement of objection, your lords. The wound certificate I've included, it will determine the amount of assault that have been, your lords. Later on, based on the said MLC was launched, your lords, and an NCR was registered. The NCR will play a very critical role why the case should be subjected to trial, your lords. If your lords permit me, there's an undertaking that was given by the petitioners in the NCR, your lords. Page number 22, your lords, R3 document, please, your lords. It's a very critical, your lords.
Critical?
Yes, your lords.
R2.
Yes, yeah, R3, your lords. The statement of the petition. Petitioners, your lords. In the para 3, I'll just read out the relevant portion, your lords. ನನ್ನ ಹೆಂಡತಿಯ ಈಗ 5ನೇ ತಿಂಗಳು ಗರ್ಭವತಿ ಆಗಿರುತ್ತಲೆ ದಿನಾಂಕ 12/7/22 ರಿಂದ ನನ್ನ ಹೆಂಡತಿಯ
ನಾನೇ ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ಸರ್?
I'm reading out the relevant portion in the para 3, your lords, line 3.
ಇನ್ನು ಮುಂದೆ ಅದಾ? Page 22 ತಾನೆ?
Yes, your lords. Document number R3.
Document number?
R3.
R3, yes.
In the page 3, your lords, para 3, ನನ್ನ ಹೆಂಡತಿಯು ಈಗ 5ನೇ ತಿಂಗಳು ಗರ್ಭವತಿ ಆಗಿರುತ್ತಲೆ.
ನಾನು ನೋಡ್ತಾ ಎಲ್ಲಿ ಹೇಳ್ಬೇಡಿ ಸಾಕು, ನಾನು ಓದ್ಕೊಂತೀನಿ.
In this, they have clearly stated that there was a fight between.
It's better you interpret than read.
Please.
Yes.
In this, there is a clear this one, your lords, wherein due to the fight that has been occurred between the petitioner number 2, petitioner number 3, and the grandmother of the petitioner number 1, the husband, even though he's having the knowledge that the wife is pregnant, has assaulted her in a manner wherein he has slapped her and she has fallen, your lords.
Are you related to the complainant?
Yes, your lords.
You?
I am, sorry, please.
You as an advocate?
Please, your lords.
You're related to the complainant?
No, your lords. So here, there's a clear interpretation wherein at the instigation of the petitioner number 2 and 3, the petitioner number 1 has assaulted the respondent number 2 for not compliance, your lords. In this 3, I'll just point at 3 major aspects in related to, your lords. First thing, the petitioners have agreed that they have assaulted the petitioner number, respondent number 2. Second thing, it was on the instigation of the petitioner number 2 and 3. Thirdly, he was having the knowledge that the respondent number 2, that is me, I was pregnant at that time. It is relevant to assume, your lords, if a person who can assault me when I was pregnant, he has also assaulted me various times, your lords.
Oh, presumption.
Yes, your lords. It's relevant to presume, your lords. It is clearly admitting that he has done so. Thereafter, in the said complaint, they themselves come forward, stated that they would revise from their behavior in order to avoid these further complications. We never said that we want to separate residence, your lords. They themselves were the one who brought this concept.
When are you coming to the climax?
Your lords, it's a very lengthy, your lords.
Very lengthy?
Yes, your lords.
This OTT lo odalla.
Your lords, I've been supported by each and the allegations that is being made. It is very much subject to 498.
It's too lengthy even for an OTT.
Your lords, the complaint itself is around 18 pages, your lords.
18 pages?
Yes, your lords, 17 to 18. That is, we have detailedly written everything, your lords, supported by each and every allegation is supported by.
Every allegation?
Yes, your lords. It's supported by evidences, your lords. The reason why it is subjected to trial.
What, you're feeling sleepy from that time?
No, Lord. My eyes were burning. That's.
Eyes are burning. Because of the story. Flashback. Huh? Yes.
My permission.
No. You will argue till the cows come back. Yes.
I would I would file the relevant portion of the
complainant is here, is it, in the court?
No, your lords.
No. ಏನilla.
No, your lord. She was present, your lords. All this 2 to 3 days. After 5 days,
it can be a foundation for a soap opera.
No, your lords. This is the actual that has happened factually. Sadly, this is what have happened, your lords.
Husband, yes.
Please.
There are wound certificates. Will not.
I concede.
Your lords, the petition number 2 and 3, we have the call recording wherein the.
Father-in-law.
Yes, your lords. Father-in-law.
ಏನ್ ಮಾಡಿದ್ದಾರೆ sir father?
On 21/6. Father-in-law himself has called and demanded for the dowry, your lords. If I'm not complying with the dowry.
This is the father-in-law.
Yeah, that is the previous condition. I have the photos wherein the father-in-law is healthy and walking in the marriage, in the other ceremonies, and even recently what has happened, your lords. I'll file that all the photos, your lords.
Ella.
Yes, your lords. I'll file it. He's in a very good condition, your lords.
This is very good condition.
This is no, your lords. That they have.
How did this condition improve?
Your lords, this is
Because
the
of the
miracle that
marriage.
we have brought. your
Because
lords.
of the marriage.
And secondly, your lords, the concept of love marriage they have brought. All this are pictured into this writ petition to get misleading this honorable court, your lords.
No, your picture is also fine. Husband, no sir.
Please, I concede to that.
You'll not permit me. I'll just make out the case in respect of petition number 2 and 3.
No, there is nothing that I will permit father-in-law and mother-in-law to satisfy your egos That,
Your Lords, I've been harassed, your Lords. I have evidence,
exactly.
your Lords.
क्योंकि सास भी कभी बहुत ही आगल आएली.
No, no, your Lords, I've been, this one, your Lords. I've been harassed and I have the evidence, your Lords. They have assaulted me, your Lords.
That I will not permit.
If your Lords permit me, I'll come with the list of
Father,
authorities and
List of assault.
authorities, your Lords.
Authorities, ಕೊಡಿ ಈಗಲೇ.
If you permit me, I have the evidences wherein I've been,
Don't have
the call
authority.
recording is there, your Lords.
If you
wherein I've-
don't have authority now, take my authority. I will dispose it right away.
Your Lords, a humble prayer, your Lords. By next day,
No, you have spent so much on narrating the story.
your Lords, there is
The
yet to it, your Lords.
Production should begin.
No, your Lords, there is yet to it, your Lords.
You, what is against the mother-in-law? Yes,
Nothing, Lord, nothing.
now you come.
Lord, the allegation, Lord, in the complaint, is, Lord, she held her by her hair once,
ಯಾರ್ mother-in-law?
mother-in-law.
ಆಯ್ತು ಆಮೇಲೆ
That's all, Lord, nothing as such vague.
held her by her hair ಅಂದ್ರೆ
And Lord,
pulled her.
pulled her, yes.
Where is column 17?
Page number 48, common allegation against all the petitioners.
ಎಲ್ಲಿದೆ ಜಮೀರ್? Your eyes are still burning, huh? If you narrate the story like this, what would happen?
Your
to
Lords, this is what has sadly this has happened, your Lords. Your Lords, another submission, your Lords.
Start-
During the
wait,
filing
wait,
of the.
Let him start at least. How old is the mother-in-law?
Lord, she is 52 years.
Entry ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ?
Only in respect of A2, my Lord,
That is the father-in-law.
father-in-law.
Rightly so. We'll allow it also like that. Mother-in-law ಮೇಲೆ ಏನಿದೆ ಹೇಳಿ?
Mother-in-law, she has abused me, your Lords.
No.
We have the call recording, everything, your Lords.
All recording.
Yes, your Lords. The call
All
recording.
abuse ಮಾಡಿದ್ದಾರೆ.
Yes, your Lords. We have pertaining to also the documents that
ಎಲ್ಲ
father-in-law
divorce
has.
proceedings correct ಆಗಿರುತ್ತೆ, not for 498.
Your Lords, there is a clear demand, your Lords, that has been made. The father-in-law and mother-in-law, the key players have instigated the petition number 1, your Lords.
What is the present status of the father-in-law?
Lord, recently he has also undergone open heart surgery. Lord, he is under,
Yes. Mother-in-law ಮೇಲೆ ಏನಿದೆ ಹೇಳಿ?
mother-in-law allegation is only that one.
Where, come to the summary. Yes, Tejesh?
Is my common allegation against all.
ಎಲ್ಲ one ಮಾತ್ರ ಇದೆ. Yes. Will permit proceedings against the husband and not against the other two. The petitioner is before this petitioners, Phil Mill and husband of accused number, respondent number 2 complainant are before this court calling in question proceedings in so and so. The marriage between the accused number 1, the first petitioner and the complainant takes place on what date? Nil ಅಂತ ಬರೆದ್ಬಿಟ್ಟಿದ್ರೆ ಡೇಟ್ ಗೊತ್ತಿಲ್ವಾ?
Written, your Lords. 21.
21/1/2022.
2002.
It transpires that the relationship between the two appears to have floundered immediately thereafter, which gave rise to several dispute between the two. One such dispute leads to registration of a complaint before the jurisdictional police, which becomes a crime in crime number 244 of 2022 for offenses so and so. The police, after investigation, file a charge sheet which is pending in CC 8347 of 2023 for the aforesaid offenses. Filing of the charge sheet is what has driven the petitioners to this court in the subject petition. The learned counsel appearing for the petitioner would submit that several allegations in the lengthy complaint and the statement of the complainant is made against the father, who is bedridden and is not even in a position to walk, for which he has produced a photograph of the father. The other, insofar as the mother-in-law is concerned, it is his submission that there are only omnibus statements of torture on the demand of dowry by the mother-in-law. Insofar as the husband is concerned, the learned counsel would admit that there are allegations which also led to assault and In these circumstances, the counsel for the petitioner would submit that proceedings against the accused number 2 and 3, the father-in-law and mother-in-law, in the least be quashed. Per contra, the counsel for the complainant would vehemently refute the submission, taking this court through the complaint in its entirety, demonstrating every overt or non-overt act by these petitioners in the story twined in the complaint. The learned counsel would submit that the father-in-law is hale and healthy and is in a position to walk everywhere and has been torturing the daughter-in-law. The learned counsel would contend that mother-in-law and the husband have all meted out such torture, which would become the ingredients of section 498A on the face of it. The learned HCGP would, though refute the submissions of the counsel for the petitioner, would on perusal at the summary of the charge sheet submit that statements are there against the three, but they are omnibus. I have given my so-and-so. Therefore, narrated facts are not in dispute. The marriage that takes place on 17/1/2022 soon results in the registration of the crime on 17/8/2022 for the offences so alleged. The reason is several skirmishes between the husband and the wife. The learned counsel for the petitioner seeks to project that it was a love marriage and dowry cannot be demanded, but the complainant seeks to project that it was an arranged marriage and not a love marriage. These would be in the realm of evidence before the concerned court. What has driven the petitioners to this court is the filing of the charge sheet. What led to investigation was the complaint. The complaint runs into 18 pages. For 7 months of life with the husband and the in-laws, a 18-page complaint is narrated with regard to every day's happening between the husband and the wife or any kind of skirmish. Therefore, I deem it appropriate to notice the summary of the charge sheet, which is filed after the investigation based upon the complaint. It reads as follows, page 47. A perusal at the summary of the charge sheet would indicate only omnibus statements made by the petitioners, omnibus allegations made by against the petitioners by the prosecution. Perusal at the statements that led to filing of the charge sheet would further indicate the fact that against the husband there are offenses of assault, and in support of assault there are wound certificates appended to the charge sheet. Therefore, the husband appears to have meted out torture upon the second respondent wife, be it a demand of dowry or otherwise. Therefore, the husband shall have to undergo further proceedings before the concerned court. Insofar as the father-in-law and mother-in-law, the state of the father-in-law is such that he is unable to walk. Not merely because of the photograph that is produced, but the medical documents that are appended to the petition. In this state, it is highly improbable that the allegations made by the daughter-in-law against the father-in-law is even sustainable, even to its semblance. Therefore, permitting further proceedings against the father-in-law would run foul of the plethora of judgments rendered by the apex court. Same goes with the mother-in-law. Only one instance is narrated in the complaint, which does not form a part of the charge sheet after investigation. Statements are glorified by the wife against the husband and the in-laws, while the glorification is sustainable only against the husband. The father-in-law and mother-in-law, if permitted to undergo trial, would run foul of the judgment of the apex court in the case of Kashkan Kaushar versus so-and-so 2022 SSC Online SC page 162. Therefore, permitting further proceedings against the husband accused number 1 - petitioner number 1, the proceedings against accused number 2 and 3, Phil and Mill, stand quashed.
Great.
For the petitioners in this matter, my lord. Challenging the order of taking cognizance and issue
This
process
matter,
passed
my
by
lord,
the
I've
honorable
taken
trial court.
motions, ma'am. A week's time may kindly be granted.
The covered by the ruling of the coordinate bench of this honorable court, my lord.
Covered?
Yes, my lord.
What covered?
It's the
Oh,
contrary to
those
section,
common orders.
contrary to section 30B of the MMRD Act.
Yes, Tejesh, ಏನು?
I look into it. Sir,
I've not
it-
looked into it. ಯಾವಾಗ
the
ಕೊಟ್ರು?
Judgment ಅದು ಈಗ ಕೊಡ್ತಾ ಇದಾರೆ. Moreover, I need to
ಇನ್ನು
take
ಮುಂಚೆ
instructions
ಕೊಡಕ್ಕೆ
in
ಏನಿದೆ?
this matter, MMRDA matter.
List after 2 weeks, interim order granted earlier stands extended to the next date of hearing.
Date may be
2 weeks. Date.
64.
The respondent.
Please, my lord.
Ready ಇಲ್ವಾ?
Senior is for the
One minute,
division
madam,
bench,
one
my
ನಿಮಿಷ.
lord.
Date time ಕೊಟ್ಟಿರೋದಿದೆಯಾ? ಬಿಡ್ತೀನಿ.
Entry matter ಇದೆಯಾ?
Cases that the petitioner is aged 78 years in US, my lords. And this whole complaint comes to be filed after 13 years from a contract which was entered into. My lords,
Why is the CBI?
They investigated the matter, my lords. They had an internal inquiry and then they place it before the CBI. CBI investigates into it. Two officials who are public servants. There are two officials, my lords, who are public servants. And two, one is a company and other is shown as the MD of the company. The present petition is by the MD of the company. Primarily, my lords, the grounds will be, my lords, that it is a purely civil contract, my lords, between the parties containing various clauses in
So
it.
these petitioners are private parties?
Yes,
Or
my
these
lords.
petitioners?
He's a private, he's a US citizen, aged about 78 years. And my lords,
The age got to do with
he's
offense.
not able to travel, my lords. My lords, he's got certifications, he can't travel for more than 2 hours. And even when an application was filed to avail the facility of VC, that was denied. And now NBW is issued, red corner notice against him. There is no way he can travel here, my lords. So we have both the aspects, my lords. For any reason, we're not in a position to convince the court that it's a case for quashment. Then, my lords, we would request that the trial will be permitted to appear through VC, my lords. Because the doctor's certification says he can't undertake a travel of more than 2 hours. That's his certification. And my lords, for a contract which has taken place 13 years back, my lords. My lords, they intended purchasing certain equipments, my lords. There were about 5 companies which participated in this global tender. We had 3 from Israel, 2 from US, and his companies from US. Successful bidder, my lords. And under the contract, he was supposed to supply about 35 of these equipments, my lords, which is required for DARE. All the supplies come. And my lords, in some of it, whichever they had to be repaired upon, sent back, repaired, sent back. Now, my lords, after about 5 years, they have an internal investigation done amongst themselves to say all these were not at all working at the time it was sent itself. And the persons to gain out of it is accused A1 and A3. A2 is the
After
company.
how many years of the supply?
My lords, after about 5 years. And after 3 years thereafter comes the complaint to the CBI. So about 8 years gap when the complaint goes to the CBI, CBI does a PE and then they file a charge sheet. In the charge sheet also, my lords, as I would like to demonstrate, there's absolutely no material to disclose any ingredient constituting the offense of either cheating or breach of trust. This would be the entire case, my lords. And my lords, if at all there's an allegation, it should be against the company, my lords. But they make an MD without exactly showing what is the role played by the MD. And for that, my lords, they have only 3 witnesses who say MD had come down to India, he was staying in Windsor Manor. That will not connect you to the crime per se, my lords. This is the whole sequence, my lords, of what has happened. And the reason why the complaint is given also is for some other reason, my lords. A1, who was an accused, my lords, was promoted. So a person who was not happy with the promotion sets all this in motion after 5 years.
Promotion sets into motion. Yes.
Lordship, the petitioner is accused number 4.
You ready?
The my
Then
senior
yes.
will,
Senior ಬರ್ತಾರೆ ಅಂದ್ರೆ ಹೇಳಿ. Ready ಇದ್ರೆ ಮಾಡ್ಬಿಡಿ.
my senior will.
No problem. If you're ready, you argue. If there's any difficulty, we'll get your senior. Then you, ಅಷ್ಟೇನಾ ನಿಮ್ದು?
Detailedly charge sheet ತೋರಿಸಬಹುದು, my lords. I can show the statements, but let them make the submission and say what is there against me, then I can reply back.
Accused number 4.
A4, MD of A2.
Why is he bought in?
He is the
Use the mic.
director of accused
Use the
number.
mic.
He is the director of accused company, my lord. They had to provide generators, but they provided generators which were not working and they have received payment for that, my lord. The
So
details
when
of
did you find out that generators were not working? Or when did the complainant find out? 5 years after the wear and tear of the generators?
My lordship, accused number 1 is the head of the division which was supposed to check the generators. Accused number 1 conspired with the company and gave the report.
That's the allegation.
Please, my lord.
So accused number 1 has not checked whether they were in working condition or not.
No, my lord.
Why did you take 5 years to register the complaint if it is not working on the first day itself? See, in a machine, natural wear and tear will always be there. For 5 years, if it has worked, you just have to seek instructions on this. 5 years, if it has worked, why a complaint comes about after 5 years? If it has, brought down on natural wear and tear, then how can you allege a crime of supplying wrong machinery? If it did not work on the first day, tell me.
I'll
Those
verify.
instructions you have to seek. And why do you bring in the company? Why you have not bought the company in and not the managing director?
Company is A2.
Company is also.
Company is there,
there.
company is there, my lords. But A4, managing director is brought in without any specific allegation of his role. He's right on top, my lords.
So true, but managing director was at the helm of affairs at the
And-
relevant point
yes,
in
my lords,
time.
but the offenses here are IPC offenses. They will have to point out how I'm responsible. It can't be a case of vicarious liability, my lords, on either.
No, there is no concept of
Yes, my
vicarious
lords.
liability in IPC
Unless they are
offenses.
able to point
Unless
out how
specific
my.
role is
Yes,
attributed.
my lords. That would be the point, my lords, of MD. How do you bring the MD? If you have a grievance against a company, company is there. We are
Company is
not
already
appearing.
there, is it?
Yes, my lords, we are not appearing for the company. And he's about 78 years now, my lords. He's in
ಮತ್ತೆ ಅದನ್ನೇ
US.
ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Adu, like, problem is he will not be able to participate at all, my lords. He's in that state. 2007 was a contract, 2020 is a complaint.
Where is he residing in US?
Let's say it was in US. California, my lords.
California.
How?
He can't travel for 2
My
hours.
lords, we have even produced a certificate, my lords, of the doctor. Page 158 ali there. That was last year's, when 158. But that is provided I'm not able to convince the court for quashment, my lords. I will go into that issue.
Let's see.
Yes,
Let her get instructions.
The witnesses
my
revealed
lords,
that.
repeatedly, some time has been taken. Could there be a stay, my lords? Otherwise, a warrant is there, red corner notice is there against him. He's not.
ಅದೆಲ್ಲ ಏನ್ಸ್ಟೆ ನೀವು ಎಲ್ಲೂ ಹೋಗ್ತಾನೆ ಇಲ್ಲ ನಿಮಗೆ ಯಾಕೆ
Hardly none.
US ಅಲ್ಲಿ ಎಲ್ಲಿ 2 hours ಹೋಗಕ್ಕಾಗಲ್ಲ ಅಂತೀರ.
My lords,
You can't go to Las Vegas.
Interpol.
You can't go to Miami. Then where do you want to go?
But my lords, as long as this is there in the, as long as such a criminal proceeding is there, my lords, it's always a sword which is
we'll
hanging, my
we'll
lords. It's
consider
always, Interpol will be there.
We'll
anywhere we
consider it
go, this-
definitely. Nobody will take you into custody in the United States. So
Could there be a stay of arrest at least, my lords, not of the proceedings for any reason?
where are you being arrested, sir?
Because they say Interpol, that's a problem, my lords.
ಆ ಥರ ಏನಾದ್ರು ಇದ್ರೆ ಹೇಳಿ. ಅಲ್ಲ ಇದೇ ಗೊತ್ತು ಥ್ರೆಟ್ ಆಫ್ ಅರೆಸ್ಟ್ ಇದೆ.
Anyway, my lords, if a date is given, we will
No,
submit
I'll-
on the next.
On Tuesday we'll finish it. Tuesday finally,
Please, ma'am.
whether you submit or Prasanna Kumar submits, these instructions I got. There's no problem even if you submit getting instructions.
Please, ma'am.
Yes. Heard the learned senior counsel Sandesh Chota appearing for the petitioner and what's your name?
Anita Krishnamurthy.
So and so representing the respondent. List the matter on Wednesday. Yes. For further hearing at 4 PM. Yes. Next.
55.
A case
ಆಯ್ತಲ್ಲ?
where doctrine of.
ಇದು
same-
ನಿಮ್ದೇನಾ?
This case, my lord, engage a senior.
Doctrine of?
Doctrine of sameness, second FIR has to go. My lords, an FIR is registered on the basis of information given by the husband, my lords. Certain SC/ST offenses and certain IPC offenses. We approach this honorable court. My lords was pleased to stay all the SC/ST offenses.
Where is that?
My lord's order of stay is page 33, my lords.
30?
33.
33 is some sale deed.
Allah, my lords.
In this case, my lord.
My lords is having 5887, my lords.
No, ಇದು ಯಾವ್ದು ರಾಜೇಂದ್ರ
5887 ಅಲ್ಲಿ ಇದೆ.
5387.
5887. Let's see first.
Madam, connected madam.
5887.
Yes, 30.
My lords, page 33.
My order.
Yes, my lords. My lords, this relates to the first FIR, which my lords should get at page
That is-
23. And
When was the second one
my lords,
registered?
1 week after my lords passed this order comes the second FIR where the wife is the informant, same accused, same cause of action. That led to this 482 where
Who
it's
was the informant in the first case? First-
husband. Husband gives information and there's an order of stay so far as SC/ST offences. And my lords said, let the investigation go on in so far as IPC. Adralli charge sheet hakuvaga, they find nothing against us and they drop us. So in the first charge sheet, we are dropped. Second charge sheet on the same cause of action, my lords, where there's an order of stay. My lords case, Bairegowda. I think Baireddy, my lord's case.
ಬೇರೆ ರೆಡ್ಡಿ ಅಲ್ಲ, ಬೈರೇಗೌಡ.
Bairegowda, sorry, Bairegowda covers the whole issue on sameness, my lords.
Engage senior counsel, my lord, because
What, husband and wife are playing hide and seek?
it's a.
Husband hides and wife seeks and wife hides and husband seeks.
49 crores, it's a, the fraud, it's a 49 crores is involved. And the
ಅದಕ್ಕೆ ಅಟ್ರಾಸಿಟಿ ಯಾಕೆ?
duplicated DD, they showed duplicate DD, not only this case. more than
Duplicate
20
DD.
More than 20 cases as against some of the petitioners in Bangalore itself. They are showing.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಡ್ರಾಪ್ ಮಾಡಿದ್ದಾರೆ
Charge
ಮತ್ತೆ
sheet
ಅವ್ರನ್ನ?
ಅಲ್ಲಿ drop
That is a major issue, my lord, because why they are, even though this honorable high court granted interim order, then also they investigated the matter under the SC/ST Act and they dropped the SC/ST Act. Main
I
person.
have stayed the SC/ST, sir.
Yes, my lord, even then, my lord, the contention, my lord, there is no SC/ST.
Where is your senior counsel?
Senior counsel, that's why, my lord, say, any other date, my.
Anyway, because it's 440. Same. ಯಾವತ್ತು ಹಾಕ್ದೆ ಅದು ವೆಡ್ನೆಸ್ಡೇ ಅಲ್ಲ?
27, my lord.
27 ಬೇರೆ ಎಲ್ಲ ಈ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಉಳಿದಿರೋದೆಲ್ಲ ಅವತ್ತಿಗೆ ಹೋಗುತ್ತೆ.
25, 26, some person. That's the reason.
27th ಬರ್ಲಿ.
Please.
Interim order ಇದೆಯಲ್ಲ?
ಇದೆ, my lords.
Interim order subsisting shall heard on this shorter land senior council. Subsisting shall continue till the next date of hearing. ಧಾರವಾಡ ನೋಡಿತ್ತಲ್ಲ ಮೇಡಮ್ ತಗೊಳ್ಳಿ. ಟೇಕ್ ಧಾರವಾಡ. Is waiting ಬೆಳಗ್ಗೆ.
Matter pertaining to Dharwad bench.
Yes, my lord.
Yes, madam.
Lord,
ಯಾರ್ದು ಕಾಸ್ಟ್ ಮಾಡಿದ್ದೆ ನಾನು?
A1 Sub Registrar Srikanth Bhatt,
ಇದು ಯಾರು?
A4 and A5, my lord. They are the deed writers, private persons.
Deed writers.
Also,
Heard the learned counsel Srimati Bharati Bhatt appearing for the petitioner. The learned counsel takes this court through. Where is the order, Srikanth Bhatt?
my lord,
Srikanth Bhatt order ಅಲ್ಲಿ.
Tandila Swami, case number 101560 of 23,
Oh.
criminal petition.
This, the learned counsel would submit that in the case of accused number one Srikanth Bhatt in 101560 of
2023.
2023, this court has quashed the proceedings on the score that there was neither demand nor acceptance against accused number one, who was said to be present in the, at the time of search. These petitioners are deed writers who had nothing to do with the offense under section, under
7A and 12.
7A and 7A,
And
7A and 12, 712 ಬರ್ಬೋದೇನಾ? 7A, 7 and 12 of the Prevention of Corruption Act. In the light of the quashment of the proceedings, where accused number one, further proceedings against these petitioners shall remain stayed. ಅದ್ರಲ್ಲಿ ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ವಿ notice? Who had appeared ಅಲ್ಲಿ?
Anil Kale.
Learned counsel Shri Anil Kale is directed to accept notice for the respondent Lokayukta.
Yes, my lord.
Petitioner to serve, ಅಲ್ಲೇ ಹೋಗ್ತಿರಲ್ಲ serve ಮಾಡ್ಬಿಡಿ.
ಮಾಡ್ತೀನಿ sir.
The petitioner to serve set of papers upon the aforesaid counsel. ಮತ್ತೆ ಯಾವಾಗ ಬರ್ತೀರಾ ಅವತ್ತು ಹಾಕ್ತೀನಿ.
Interim application, any date may be given.
Interim application allowed.
Yes, my lord.
Yes. List the matter of 4 weeks ಬಿಟ್ಟು ಒಂದು ಡೇಟ್ ಕೊಡಿ.
Yes, my lord.
Yes.
Date.
24/7.
Yes, ma'am.
Yes. All other matters will come on 27th. Interim orders will continue. 27th is next week. ನಾನೇನ್ ಮಾಡ್ಲಿ ಅದಕ್ಕೆ?
Top of the list ಮಾಡಿದ್ರೆ next week.
ಯಾವ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್? ರಿಲೀಸ್ ಆಫ್ ವೆಹಿಕಲ್
Remaining matters ಎಲ್ಲಾರ್ದು.
ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಬರಲ್ಲ. 27th.
Reach 3 ವಾರದಿಂದ reach
27th. I can't help it, Mahadev. Yes.
My lord, on submission, my lord. At 1:30, second respondent has taken the adjournment.
ಯಾವ್ದ್ರಲ್ಲಿ ಮೇಡಮ್?
Serial number 83, my lord. I moved the matter.
ಆಯ್ತು, ಏನ್ ಬೇಕು ಹೇಳಿ?
There are connected matter, we have got to stay, your honor. In this case, I have moved the matter to obtain the stay because it has been transferred to CCB
One
from
minute.
Kengeri police station.
83 ಯಾರ ಟೈಮ್ ತಗೊಂಡು?
At 1:30, he has taken the
Yes, he
adjournment.
has taken, madam. He said he has informed you.
He has informed,
ಅಲ್ಲ,
but
ನೀವು
yes,
ಪೆಟಿಷನರ್ ಈಗ
yes, my lord.
ರೆಸ್ಪಾಂಡೆಂಟ್ ತಗೊಂಡಿದ್ದು ಟೈಮ್.
Respondent ತಗೊಂಡಿದ್ದಾರೆ.
ಆಯ್ತು,
last-
ಇನ್ನೊಂದು ಅವ್ರ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಸ್ಟೇ ಕೊಡೋದು ತಪ್ಪು.
Last
I'll
week, it may be
post this
listed.
on
Kindly have it on Monday, my lord.
Monday. ಆಯ್ತು, ಮಂಡೇ ಬೇಡ, ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಇರುತ್ತೆ. ಐ ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ ಸ್ಯಾಟರ್ಡೆ ಆಗುತ್ತೆ. ಸ್ಯಾಟರ್ಡೆ ಹಾಕ್ತೀನಿ.
Thank you.
ಆಯ್ತು, ಎಲ್ಲ all 27th all the matters will come.
It's 94.
Your lordship, 84.
However short it is, 27th it is going.
One passed over matter, my lords.
All next week, 27th is next week, sir.
That's kindly interim order.
Yes.
That's serial number.
27th Thursday. ಯಾರಂದ್ರೆ ಈಗ ಇರ್ಲಿ.
That's serial number 74. 27th has become infructuous, my lords. I appear for respond number 2.
You can't say that, let the petitioner tell.
It's one serial number 90. I moved the matter before passing of interim order, the petition has become infructuous.
Why charge sheet ಹಾಕಿದ್ರಾ?
Charge sheet file, my lords.
ಆಯ್ತು, petitioner ಯಾರು ಹೇಳಿ ಅವ್ರು?
Serial number 94, my lords, passed over matter, my lords.
Passed over 94.
Settlement.
Settlement ಕರಿತೀನಿ, wait.
Your lordship, serial number.
All other matters, don't mention, all other matters on 27th, wherever interim order is there, it will continue. If you want beyond 27th, please mention.
Serial number 73.
27th ಆದ್ಮೇಲೆ ಬೇಕಾ? 27th ಆದ್ಮೇಲೆ ಬೇಕಾ? 22nd ಬೇಕಾ? ಕೊಡಿ ಮೇಡಮ್, 22nd. ಮಾತ್ರ 22nd ಕೊಡಿ.
73, my lord. After 27.
ಅವ್ರದ್ದು 27 ಕೊಟ್ಬಿಟ್ಟು ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಹಾಕಿ. ಸಾಕಾ?
My lord, serial number 73.
ಹಾ.
After 27.
ಆಫ್ಟರ್
27.
ಯಾವತ್ ಬೇಕು?
103.
ಸೀರಿಯಲ್ ನಂಬರ್
73.
73, 4th July ಹಾಕಿ ಮೇಡಮ್.
71 at 2:30, my lord. From January, I'm unable to get it.
Black magic, sir. Then it is seen to that it won't reach.
Blood husband has taken the stay.
ಅದೇ black magic. It won't reach at all.
Your lordship, if I make a mention for serial number 84, your lordship, I do not have an interim stay. in this
27th
matter.
it will be listed. Why no interim order till now?
The first, it is a matter of lokayukta, my lordship.
Then
Notices
no
been
interim.
served.
Yes.
Sure.
On
If-
20 on
like, I have
27th.
I have merits to demonstrate before
No
this. court
problem,
order.
madam. 27th, definitely.
With your lord.
72? Close ಮಾಡಿ, influxes.
Number 74.
Yes, settlement ಅಲ್ವಾ? ಒಂದೇ ನಿಮಿಷ.
74.
74 ಏನ್ influxes ಅಂದ್ರೆ? Yes, sir. ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿ.
I will, madam. I have just been informed that there's been a charge
ಸರಿ,
sheet has been
madam,
filed.
format order.
Please,
Yes, sir. Challenge it.
I will oblige, madam.
ಇನ್ಯಾವ್ದು ಮೇಡಮ್? Yes. Settlement.
Appear for the petitioner.
ಏನು offense?
380, 447 and 506 of IPC. The 10 accused petitioners are 10 in numbers.
ಅಷ್ಟೊಂದು ಸೆಟಲ್ಮೆಂಟ್ ಇದ್ರೆ ಪೆನ್ ಡ್ರೈವ್ ಅಲ್ಲಿ ಕೊಡಿ.
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ?
If you have narrated the whole story,
It's only joint affidavit. We are filing a joint.
ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್ ಹೇಳಿದ್ದು.
Please, notes, I will.
ಅದೇ ಅಷ್ಟ್ ಮಾತ್ರ ಇರ್ಬೇಕಾದ್ರೆ.
That portion that I will.
Yes.
And one more thing, my lords, I'm filing application now, subsequently charge sheet is filed. That amendment I have carried, petition, application I have filed along with the amendment petition also I'm filing it. my lords.
Amended
Amended petition also I'm filing.
for what?
For carrying out the amendment now because.
That sheet ga?
It-
That's all right.
Parvati.
Settlement ಅಲ್ಲಿ close ಮಾಡ್ಬೇಕಾರೆ ಎಲ್ಲ
Please, my
ಮಾಡ್ತಾರೆ.
lords.
Rajesh, please. Settlement ಕೊಡಿ.
Please, my lords.
In Vijay. Offense notes. Amendment and ಬೇಡ.
Please, my lords.
94.
And Vijay, ಇದು application under 320 of the CRPC. Accepted since the offense so third. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ಪಿ ಪಿ ಹೆಗ್ಡೆ ಅವ್ರದ್ದು ಇತ್ತಲ್ಲ ಇಲ್ಲಿ.
Passport 30.
In 354 compromise petition is submitted, my lord.
ಅಲ್ಲ ಒಂದು 354 ಕ್ಲೋಸ್ ಮಾಡೋಣ.
ಇನ್ನೊಂದ್ರೊಳಗೆ affidavit ಒಂದು ಹಾಕ್ತಾ ಇದ್ದಾರೆ ಅವರು.
ಅದು ನೋಡ್ತೀನಿ.
My lord, 354.
354 will close.
Oh, please.
I'm filing power for R2, my lord, in both the cases.
ನಿಮ್ಮ ಹೆಸರೇ ಹಾಕ್ಲಾ? Learned counsel R B Sadashivappa enters appearance for the complainant in both the cases. Registry to print the name of so and so. Second case 354 ಯಾವುದು? settlement ಅಂತ ಕ್ಲೋಸ್ ಮಾಡಿ. 350 same accused, huh? Same accused in both the cases?
Yes, yes.
Right.
Complainant is same and.
So 354 we have closed. Let the parties sign later. Now this
In the
20080 ಏನು?
My lord, may beg to first, the charge sheet itself, my lord. The charge, whether does it speak of the commission of the offense, my lord, in time of essay, page 131.
Entry ಮಾಡ್ರಿ ಇಲ್ವಾ?
ಇಲ್ಲ.
ಹ್ಮ್.
Page 131, my lord. ಸಾಕ್ಷಿ ಒಂದರವರೆಗೆ ಸಾಕ್ಷಿ ಒಂದು is the victim, my lord, wife, the widow who is present today. ಅವರ ಗಂಡನಾದ ಮೃತ ಪಿ ವಿವೇಕನಾಥ್ ಎಂಬುವರು ಸಾಕ್ಷಿ 16 ಅವರೊಂದಿಗೆ ಪಾರ್ಟ್ನರ್ ಆಗಿ ಕಾಲಂ 4ರಲ್ಲಿ ನಮೂದಿಸಿದ A1ನೇ ಆರೋಪಿಗ ಸೇರಿದ ಬೆಂಗಳೂರು ನಗರ ಮೈಕೋ ಲೇಔಟ್ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿನ BTM ಲೇಔಟ್ ಸೈಟ್ ನಂಬರ್ 35ರಿಂದ 41ರವರೆಗಿನ ಒಟ್ಟು 5,814 ಚದರ ಅಡಿ ಜಾಗದಲ್ಲಿ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕಟ್ಟಲು 33/2016 ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಪತ್ರ ಮಾಡಿಕೊಂಡಿದ್ದು, ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ 18 ತಿಂಗಳಲ್ಲಿ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕಾಮಗಾರಿ ಪೂರೈಸುವ ಕರಾರು ಆಗಿದ್ದು, ಆ ಸಮಯದಲ್ಲಿ A1 ಆರೋಪಿಗೆ ಡೆಪಾಸಿಟ್ ಆಗಿ 3 ಕೋಟಿ ಹಣವನ್ನು ನೀಡಲಾಗಿತ್ತು. ಅದರಲ್ಲಿ 1.5 ಕೋಟಿ ಹಣವು ಗುಡ್ ವಿಲ್ ನಾಟ್ ರಿಫಂಡಬಲ್ ಆಗಿದ್ದು, ಉಳಿದ 1.5 ಕೋಟಿ ಹಣ ರಿಫಂಡಬಲ್. A1 ಆರೋಪಿಗೆ ಸೇರಿದ ಫ್ಲಾಟ್ಗಳನ್ನು ಕಾಮಗಾರಿ ಪೂರೈಸಿ ವಶಕ್ಕೆ ಕೊಟ್ಟ ಬಳಿಕ A1 ಆರೋಪಿಯು ಪ್ರತಿ ಫ್ಲಾಟಿಗೆ 15 ಲಕ್ಷ ಹಣವನ್ನು ರಿಫಂಡ್ ಮಾಡುವ ಕರಾರು ಮಾಡಿಕೊಳ್ಳಲಾಗಿದೆ. ಆದರೆ ಹಣಕಾಸಿನ ಸಮಸ್ಯೆಯಿಂದ
ಓದಾಯ್ತು, ನೀವೇ ಗೊತ್ತಾಯ್ತು.
ಹಣಕಾಸಿನ ಸಮಸ್ಯೆಯಿಂದ ಪೂರೈಸಲಿಕ್ಕೆ ಆಗಿಲ್ಲ, ಅದಕ್ಕೆ ಒಂದು ತೊಂದರೆ ಮಾಡ್ತಾ ಇದ್ದ, ಡಿಮಾಂಡ್ ಮಾಡಿದ್ದ. Therefore, he committed suicide. My lord, a lawyer's notice was issued, my lord, admitted facts. Lawyer's notice was issued demanding.
Anyway, there is no opposition because of the
That's all.
settlement.
My
I
lords,
want to write it on merits
please,
because
my lord.
306 I can't close it by way of settlement.
Please, my lords, orders earlier passed by my lords and other decisions Supreme
David
Court.
D'Souza.
David D'Souza and other 2 decisions and Arnab and Arnab Goswami on 306.
Arnab Goswami is old, sir.
Not required. My lord has considered everything, my lords.
Yes.
And only thing is, there is one suicide note in the present case, my lords. And about the suicide note, my lords, it doesn't advance their case because it only shares a frustration. And on that point, my lord, recent decision of the Honorable Supreme Court, my lord, page 64, Mohit Singhal. It shows he had a financial problem, my lord, page 143. Page 142 and 143, the suicide note. It says he has financial problems, therefore he is committing suicide, my lord. That's all.
Yes, sir.
No, please.
Close ಮಾಡಿ. No, I want to answer it on merits ಅಷ್ಟೇ. The petitioners are petitioner. Petitioners accused 1 and 2 are before this court, calling in question the proceedings in CC 12731 of 2021, which arose out of crime in crime number 236 of 2020 for offences punishable under section 306 and 34 of the IPC. Heard so and so. Facts in brief, Germain, are as follows. The second respondent is the complainant, wife of one P. Vivekanath, who had certain transaction with the petitioners 1 and 2. The transaction between the two was with regard to certain joint development agreement and construction of the immovable residential property as described in the petition. The petitioner, the husband of the complainant was allotted certain work of construction of the building in survey number so and so page synopsis 31/3/2016. A sharing agreement was also entered into on 21/11/2017. And later, it is the allegation that the complainant did not complete the construction as was allotted to him, and the present petitioners have pestered him with regard to the completion of construction and also loan ತಗೊಂಡಿದ್ರ completion of construction. It is the submission, completion of construction. Unable to bear the onslaught of the petitioners with regard to the alleged torture, the husband of the complainant commits suicide, leaving a death note. The death note indicates the petitioners to be responsible for the commission of suicide of the husband of the complainant. It is on this basis a complaint comes to be registered, which becomes a crime as aforesaid, and the investigation leads to filing of a charge sheet and the matter pending as aforesaid. The learned senior counsel, the PP Hegde, appearing for the petitioner, would contend that the breach of the agreement or pestering the complainant, husband of the complainant, to complete the project in terms of an agreement cannot mean that there was an instigation for commission of suicide. He would submit that the that ingredients of offense punishable under 306 would require such instigation that the complainant or the person who would commit suicide leaving with no choice but to commit suicide. That is not the case at hand. That is not the issue in the case at hand, is what the learned senior counsel would submit. Per contra, the counsel, Sri R.B. Sadashivappa, who would submit that they would want to give a quietus to the issue, as there is a settlement between the two, and would not be willing to make any submission. The learned counsel, learned HCGP also, the learned HCGP would refute the submissions of the learned senior counsel, contending that the charge sheet has been filed and the matter should be set at trial, and the petitioner should come out clean in the trial. Merely because they have settled against between themselves would not mean that the petitioner should be let off. I have given my anxious consideration to the submission so and so. The afore narrated facts are not in dispute. The transaction between the petitioners and the husband of the complainant is a matter of record. The work entrusted to him not being completed is again a matter of record. Therefore, the petitioners have gone on pestering completion of work by issuing a legal notice and the complainant replying to the said legal notice. This has led to frustration of the complainant and the complainant committing suicide, husband of the complainant committing suicide. Therefore, the complaint is registered, the complaint is registered, and the charge sheet is drawn after completion of investigation. The summary of the charge sheet reads as follows, page 131, 132. A perusal of the summary of the charge sheet would clearly indicate that there is no instigation or goading to the extent that it would become the ingredient of section 107 of the IPC, which deals with abetment, for it to become an offense under section 306 of the IPC. Whether such instances would become ingredients of section 107 need not detain this court for long or delve deep into the matter. It would suffice if one of the judgment rendered by the apex court is rendered out of the plethora that are rendered on the issue. The apex court, in its latest judgment in Prabhu versus State of Karnataka, reported in 2024 SEC Online SC page 137, has held as follows. The apex court considers the entire spectrum of the law as laid down laid down earlier, and then considers that if there is instigation to the extent that the victim is left with no choice but to commit suicide with immediate proximity, it is only then it becomes an offense under section 306 of the IPC. The issue in the list stands completely answered by what the apex court has held in the aforesaid judgment. For the aforesaid reasons, allowed quashed. ಅದ್ರಲ್ಲಿ ಪ್ರಭು ಇಲ್ಲ ಅನ್ಸುತ್ತೆ.
ಪ್ರಭು ಅದ್ರಲ್ಲಿಲ್ಲ ಸರ್.
ಇದು ಪ್ರಭು ಅದು ಡೇವಿಡ್ ಡಿಸೋಜ್ ಆದ್ಮೇಲೆ ಬಂದಿದೆ.
Prabhu, my lord, January 30, 2024, my lord.
Yes.
My lord, order probably we did not bring to my lords.
ಅದ್ರಲ್ಲಿ ಬರ್ದಿಲ್ಲ ನಾನು.
It was January 30 report on.
Page 137. 2024 137.
My lord, ಅದರಲ್ಲಿ unreported download ಮಾಡಿ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟಿನಿ ಸರ್.
Unreported ಇಟ್ಕೊಂಡಿದೆ, ರಿಪೋರ್ಟ್ ನೋಡಿ.
ಅದೇ ರಿಪೋರ್ಟ್ ನನ್ನ ಹತ್ರ ಬಂದು.
Yes.
The problem now is that it's a unique number they are putting, my lords, but some of them don't.
ಯೂನಿಕ್ ನಂಬರ್ ಏನಿಲ್ಲ, SSC ಆನ್ಲೈನ್ ಹಂಗೆ ಇರೋದು.
SSC online.
ಆನ್ಲೈನ್ ಹೇಳಿದ್ದೆ.
ಹೌದು.
137.
Please. Great motion.
Yes. ಅಷ್ಟೇ, ನಿಮ್ದೇನು ಸೆಟಲ್ಮೆಂಟ್ ಬೇಡ 1306 ಅಂತ. ಇದು ಮೆರಿಟ್ಸ್ ಅಲ್ಲಿ ಕ್ವಾಶ್ ಆಗಿದೆ ಅಂತ ನೀವು ಆಮೇಲೆ ಸೆಟಲ್ಮೆಂಟ್ ಕಂಡೀಷನ್ಸ್ ಮಾಡಿ ರಿವೈವ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಇಲ್ಲ ಅದು ಆಗಿದೆ, ಸಿವಿಲ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಸಿವಿಲ್ ಸೀಟ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
ನೋ ಅದು ಸದಾಶಿವ ಸರ್, ವಾಟ್ ಇಸ್ ದ ಕಂಡೀಷನ್ ಹಿಯರ್? ಕಂಡೀಷನ್ ಏನು ಕಾಸ್ಟ್ಮೆಂಟ್ಗೆ? ಸೆಟಲ್ಮೆಂಟ್ ಕಂಡೀಷನ್ ಏನು?
ಅದು
only the suit, my lord, where the
ಇದ್ರೊಳಗೆ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕೊಡುವಂತದ್ದು ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ ಸರ್. ಅದು ಹಾಕಿದ್ವಿ ಕಾಪಿ, ಮೈ ಲಾರ್ಡ್. ಇಟ್ಸ್ ಆಲ್ರೆಡಿ ಫೈಲ್ಡ್ ಬಿಫೋರ್ ಅಲಾಂಗ್ ವಿತ್ ದಿ ಕಾಂಪ್ರಮೈಸ್.
ಹಾಕಿದ್ದೀರಾ?
ಹೌದು.
ಅದ್ರಲ್ಲಿ ರೆಕಾರ್ಡ್, ಅದು ಇನ್ನೊಂದ್ರಲ್ಲಿ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ಯಲ್ಲ?
ಹೌದು ಹಾಕಿದ್ವಿ, ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ವಿ ಸಿವಿಲ್ ಸೂಟ್.
ಆಮೇಲೆ ಇಲ್ಲಿ ಮೆರಿಟ್ ಮೇಲೆ ಒನ್ ಅನ್ಬಿಟ್ಟು ಡೋಂಟ್ ಗೋ ಔಟ್ ಆಫ್ ದಿ ಸೆಟಲ್ಮೆಂಟ್ ಅದು ಮಾಡಬೇಡಿ. ಐ ವಿಲ್ ರಿವೈವ್ ಎವ್ರಿಥಿಂಗ್ ದೆನ್.
ಪ್ಲೀಸ್ ಎಲ್ಲ ಕಾಂಪ್ರಮೈಸ್
ದಟ್ ಇಸ್ ವೈ ಐ ಹ್ಯಾವ್ ಸೆಡ್ ಹಿ ಹ್ಯಾಸ್ ನಾಟ್ ಮೇಡ್ ಎನಿ ಸಬ್ಮಿಷನ್.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್. ಹೌದು.
ನಿಮ್ ಪರವಾಗಿ ಆಯ್ತು ಅಂತ ಡೋಂಟ್
ಇಲ್ಲ,
ಡಿವಿಯೇಟ್ ಫ್ರಮ್ ದಿ ಸೆಟಲ್ಮೆಂಟ್.
Great.
ಎಸ್,
ಮೋಸ್ಟ್ ಗ್ರೇಟ್ಫುಲ್.
ಅಲ್ಲ ನೀವೇನ್ ಮಾಡಲ್ಲ.
ಇಲ್ಲ, that will never.
Petitioners you can't.
It's our duty also to advise. We have advised. We have spoken to both.
ಆ ತರ ಏನಾದ್ರೆ ಒಂದು ಮೆಮೊ ಮಾಡಿದ್ರೆ ರಿವೈವ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. Yes.
Nobody would dare to do it.
Huh?
At least here, nobody would dare to do it.
Yes. Because ಒಂದು ವರ್ಷ ಬಿಟ್ಟು ಮೂವ್ ಮಾಡಿದ್ರೂ ಗೊತ್ತಿರುತ್ತೆ ನಮ್ಗೆ ಏನು. Yes.
Most.
Yes.
Presence may kindly note.
Just ನೋಡ್ಕೊಂಡು. ಕವರ್ಡ್ ಮ್ಯಾಟ್ರಾ?
Covered.
Serial
number 86, my lord.
ಏನದು? 7A 13 7A ಕವರ್ಡ್ ಎಲ್ಲಿರುತ್ತೆ? ಏನ್ ಪೋಸ್ಟ್ ಪೇಡ್? ಪೋಸ್ಟ್ ಪೇಡ್ ರಿವರ್ಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪರ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ.
Postpaid, it is only, no.
ಹೌದಾ?
This is ordered, not even investigation.
No, just see. Yes. That Jagdish ಅಲ್ವಾ ಅದು? ಪೋಸ್ಟ್ ಪೇಡ್.
Image Jagdish, but postpaid is my lord Prakash.
Oh,
The Brista's case, my lord.
Sabrista's case, correct. ಅದೇನಾಗಿಲ್ವಾ? ಎಸ್, ಇದೇನು 83 ನಾ?
86, my lord. May I request, my lord?
86. ಇದರಲ್ಲಿ ಏನು?
Lord, I was working as assistant executive.
ಎಲ್ಲಿ ಬೇಬಿ ಪಾಟೀಲ್? Get him, not now. Next Wednesday, same. 7, Oh, it's 7A, 11th.
Of matters posted. There is a.
ಇಲ್ಲ, ಅವತ್ತು 11th ಬರೀ 7A. Trap day. All cases pertaining to trap.
22nd, Lord, I'll take chance.
ಬೇಡ. 11th is declared to be a trap day.
You will be trapped, Lord. Your lordship.
That is exactly the point.
ಅದಕ್ಕೇನೆ 22nd.
You should not escape ಅಂತ. ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಫೇಲ್ ಟ್ರ್ಯಾಪ್ ಆಗಲ್ಲ. Yes.
ಆಗಲ್ಲ. But 22nd, Lord, I'll take chance.
22nd ಬೇಡ, ಯಾಕೆ?
22nd
ಅದು
sitting
ತುಂಬಾ
there.
ಕೇಳ್ತಾ ಇದ್ರೆ ಮೇಡಮ್ ಕೊಡಿ 22nd.
Serial number 71, top of the list at
ಎಲ್ಲರ
least.
ಜೊತೆ ನಾನು ಟ್ರ್ಯಾಪ್ ಆಗ್ಬಿಡ್ತೀನಿ ಅದೇ ದಿನ ಹಾಕಿದ್ರೆ.
ಓ, ನಿಮ್ ಸಪರೇಟ್ ಟ್ರ್ಯಾಪ್. ಎಸ್,
Top of the list, 71, please.
ಯಾವುದು ಸರ್? ಬ್ಲಾಕ್ ಮ್ಯಾಜಿಕ್?
Please, my lord, from January I'm waiting, please.
See, the black magic is so strong that I am unable to take the matter only.
Lord, please, my lord, serial number 71.
ಯಾವತ್ ಬೇಕು?
27th ಇದೆ.
27th.
Top of the list, my lord.
ನೋಡೋಣ.
My lord, please.
So black magic ಮಾಡಿ ಮೇಲ್ ಬರ್ಲಿ.
My lord, I'm not at all done, my lord. I'll explain it to the court, my lord. Please, my
How
lord.
black magic is done ಅಂತನಾ? What do you want to explain?
No, that I'm not done any black magic. It is because the husband and wife, they have
Black
conflict.
Magic Act, I think Shanti Bhushan is also there in that.
Yes, my lord.
Central government, ನೀವು ಇದ್ದೀರಾ ಅದರಲ್ಲಿ. ನಿಮ್ಮ ಆಕ್ಟೇ ಮಾಡಿರೋದು. Yes. We'll take it on 27th. We'll take.
Top of the list.
You should do some magic. It will come up. Don't worry.
Please, my lord.
ಇದ್ದಾಗ ತಗೊಂತೀನಿ. We'll take. ಅವ್ರದ್ದು ಸತೀಶ್ ಹೇಳಿದ್ದೆಲ್ಲ. ಸತಿ ಎಲ್ಲಿ? ಇರ್ಲಾ?
Sir, 22nd.
ಇರ್ಲಿ ಮೇಡಮ್. ಅದೊಂದು ಹಾಕಿ ಮೇಡಮ್, ಎಲ್ಲ ಟ್ರ್ಯಾಪು 11th ಹಾಕ್ತಾ ಇದ್ದಾರಾ? ಎಂತ ಮೇಡಮ್?
22nd.
ಮೇಡಮ್.
Court officer. Court officer.
22nd.
Hello, madam.
Madam, ಹೇಳಿ.
Madam, kindly please check serial number 73, which date is posted, madam?
27. No, 47.
27 only.
47.
47. Ha, thank you.